Hey, everybody. It's day 9 of the boat crash trial, Florida versus George Pino. And you are here with Defense Diaries and Kat Not Williams. And we will be going over jury instructions. So, all of you dorks out there should love this, because it's like
Lord
law
Dork.
dorks. I mean, it's everything, it's all the learning, it's all the cooking, it's all the background. It's everything that matters except maybe to the jurors. I don't know. I don't know.
Sausage being made. That's what's happening. That's what's happening.
Agreed. And remember, no court tomorrow, you guys. Federal holiday for Juneteenth. So, no jury today, but also like no court at all tomorrow. And if you missed anything yesterday, basically we had a quick rebuttal from the state where the state put up Katy Puig's father and then called Lucy's father back up. Obviously, the defense rested their case right before that, and a second argument for a judgment of acquittal was denied. So that's basically the quick recap of yesterday. And court is just starting to file in. We haven't missed anything. They started late, as they seem to. And we've got the chat for a little bit here. Let's do like 5 minutes with the chat, see what you guys are saying.
They're on island
Oh,
time out there down
I
in
forgot to put the chat
southern
up.
Florida. You're so
There we go.
small.
Oh, it covers us
Hey,
too.
Hey.
All right, guys. Rate Allie's opening on a scale of 9 to 10.
I did not know that was happening.
I thought it was
I feel
X.
chipped.
Do I get a vote?
I know
Yeah,
what
you get
your
a
vote
vote.
is.
I'm giving you a 10, baby.
I know. I know.
10.
That was such a good
10,
opening.
Somehow figured my husband would say that. I mean, I could have like just been like, Bob would be like 10, babe. I love you.
Let's see. Mimi 2GC said, Bob, I sent a message the other day about @Katt's typo on the overlay. You all just no, we didn't.
Well,
You
we
must have
did
been
until
off.
somebody
You mean that
else
we
said it.
missed the typo? Yes, I
And
definitely
her
did not.
email.
Huh?
It wasn't I don't think it was her email that got the change done, is her point. Mimi's like, "I messaged y'all about it, and you didn't do shit."
All right, who
Yeah, I think
sent it?
someone
Somebody
Venmoed
sent a
you. Someone
Venmo,
Venmoed
yeah.
you.
It wasn't Mimi?
No, I
Oh.
think she sent
So,
I don't
Mimi,
know.
you're looking for full faith and credit on the fact that you first recognized the fact that we forgot to put a R in George's name. However, we missed you desperately reaching out to us to make the correction, and we gave credit to someone else. Do I have
No,
that
I don't think
clear?
that's what her point is. Her
Oh,
point
yeah.
is just we could have fixed it sooner had we paid
Oh, yeah.
attention to her shit. That's
It,
what
it
I
was
got.
it
wow.
was George Pino on trial. Dismiss the case. We
George
have the wrong
Pino.
I've like
person.
a hair in my
See, you guys
eyeball
just saw a
somewhere.
little example of Ali being a defense attorney. She came immediately to Mimi's defense. That's what I deal with every time I try to discipline the kids when they don't like do a chore or just completely ignore us or don't give us good night hugs. Like all the things that I'm very insistent upon. Ali will always have some kind of whack excuse for them. I'm like, what? I'm like,
I
we are
can't
supposed to be
clear
a
this.
united front.
It's like I got a cobweb in my eye that I can't find. There's like a
Old
little
cobweb
hair
eye.
somewhere. I think I got it.
He's
Jeez.
old cobweb eye. All right. So where are you guys at? I put a little tweet out there checking the temperature of the old George Pino case. What do you guys think? You guys think the state, pre-closing arguments, obviously, based on the evidence alone without closings, do you guys think the state has met their burdens as to either charge? I'd like to know. I'd like
I
to know.
just don't
And
think it's the
actually,
right charges.
I want to see people that are saying yes.
There
That's what
were
I want.
6% of people
I
yesterday.
know. Well,
6
show
to 12,
yourselves.
depending on,
Show yourselves.
show yourselves.
Show yourselves. Come forward. Come hither and tell us why. Yeah, maybe I'm missing
Chicago
it.
one's, I think we all agree, or
Yeah.
at least strongly fear that no matter
Well
what,
put, babe. Well
the
put. That's
right,
it.
the defense, the jurors
I mean, if it's the same as it ever
might find
was
guilty.
proposition, then he's going to
Same
get
as it ever
convicted on
was.
some emotional
Same as it
bullshit.
ever was.
It's an emotion case for that's the emotion narrative. That's what they're really working it. They're really working it. Scooter?
Oh man, I think we need to get into the instructions because I just pulled up the stream like to queue it up, and the caption says something about it reads because you charge it as a DUI is what the caption says.
Huh?
I
That's
don't
what
know.
they're
I feel like
saying,
it's
the
gonna be a
words they're
hot mess.
spoken. All right, let's get into it then.
Bring it
Yeah,
in.
we're
lock
like
these people up.
5.5 minutes behind.
Oh my God.
Oh
The
Lord.
world is coming to an end.
Y'all are out.
And
Bye,
I want to
chat.
know why they're saying the word DUI. Chat, love you guys. Curiosity is getting to me. All right, so I'm gonna nuke my chat. Sorry.
The ham of
Bye,
all
guys.
hams refused to be on camera. Shocking.
Let me get this ready to
She
go.
probably hasn't seen herself in a mirror yet.
Yeah, she's like, I just woke up. My head, it's just, I look sleepy. My hair's not dead. All right, whatever. Okay.
Okay, and apparently it starts with.
Hold on.
This is the frame we're starting with. This
Okay.
guy.
Bye, chat.
This
Love you.
guy.
All right.
Oh,
He loves his camera time.
yes. All right, here
And
we
his
go.
name's
Let me know
out
if the
there now.
volume's good.
Man, Deputy
Man.
Mr.
Gomez.
Gomez on blast.
It's probably Roberto.
Hey,
Robert-
Roberto Gomez.
It could
Robert
be
Gomez.
Ricardo.
He does not look
Ricardo
like a
Gomez.
Ricardo or a Roberto. I just added the O there. He just looks like a Robert Gomez.
Rufalo Gomez. It could be all
Rich.
kinds of
Just a
shit
plain
down
Rich.
there. You know?
Rich Gomez. Oh Lord, that would be
Richie Gomez. Hey, how you doing? My name's Richie Gomez. I am your friendly bailiff.
I think it's just like that. How?
Oh, it zooms in on him too.
Oh man.
Do I need to have the zoom on?
Wait.
I know Ms. Gomez was going to zoom in if it was
Oh,
available.
It's
okay, then I'll
Mr.
put
and
it on.
Mrs. Gomez both in the courtroom.
Gomez is the attorney. The
Oh.
Janelle.
Oh. I thought it was the court clerk.
Yeah, Janelle needs to get on the Zoom. She's the attorney that put on the record, like, hey, we want it to be on the record that the prosecutor was rolling her eyes and like voting in court.
She's getting texts from people. Dude, we all just saw the prosecutor. She's probably getting texts all day long. There's this, there's that. What about this?
We synced it. She rolled her
passing the
eyes.
notes.
And gave some kind of weird little like.
Now we know why the judge didn't want to chat.
Oh wait, I thought I skipped this. When they
Wait, who
argue about
needs
the
the tissues now? There's no witnesses today. Oh my God!
Boy,
Every
they're
one of
really
them
moving
moved
that
it.
box around.
All the
Yeah, you're
germs.
blocking my view of the. I don't want the. I want
Okay,
the camera to
let's
see
go
the top
on
of
the
my head.
record. State of Florida versus George Pino. Parties can
Too bad we
announce,
got you
please.
covered by the closed captions anyway.
Good afternoon, Judge. On behalf of Mr. Pino, who's waiving his presence today,
Right?
I'm accompanied by my law partner, Mark Shapiro, and Robalo. Morning today, Alexa Klein is with us.
Okay.
I should have said my name is Howard Strubing.
Okay, very good. Thank you. And it's no problem for Mr. Pino not to be here today because we are, and he's, of course, can be if he wished. We're just going to be conducting our charge conference. I want to go through the jury instructions, and thank you, everyone. You all sent me your proposed instructions. And I think really the meat of it will be for me to address the manslaughter instruction, the vessel homicide instruction, and
all the big things.
request for an instruction on the navigational rules.
No, you guys are forgetting something. The upgrade
You
instruction.
each have your copies
It does
of
include
what
it in
you
count one,
provided to
though.
me, correct? You have your copies of
Court?
To be clear, earlier, over the weekend, last weekend, we may have sent you.
yes, but it's been updated.
Yes, what we did today was we sent you the correct Word version
Perfect.
of what we had sent you in a PDF. There was a mismatch. Now you have exactly what we intended you would have as of last week. Today we will have some additional requests to go over with you.
Okay,
So you should have, from our perspective, we propose doing it on the
I
computer.
have yours here,
Using paper.
I have the states here, and I have mine here. Okay, so perfect. Thank you for doing that. Okay.
We also have the ability to put it on the screen if we want to read along with you, that's up to
Oh,
you.
that's okay, sure. But as long as you all have copies, you can follow along as we're going through. So I
Old
think,
school.
you know, I mean, just
Old
to, I'm just gonna go page by page, and when we get to the instructions that,
I don't know if you guys want to throw them in your YouTube description, but if you go to my YouTube description, you should be able to copy and paste all of the links to the filings for the defense and the state's request for special instructions. If you want to just like throw for anyone that wants to read along, or I can drop them in the private chat. So they're already in my description, and we'll make Bob put them in Defense Diary's description.
I shall do it now.
We are making
we'll have further discussion on.
It.
We'll stop and we'll talk about it, okay? So, the introductory, which I would call page 1, is just the introduction to the final instructions. And if I don't hear any objections, I'm just going to put a check mark and say that it's clear. Okay? All right, so that's clear. And we go to what would be page 2.
Kat, are they all in the
Statement
same
of
Google
charge.
Drive? Or are those all different
Charges.
Google Drives?
Yeah, they're all in there, and I also just
And
pasted
we'll
the
have
link to the
both,
private chat.
Crimes of manslaughter and vessel
Oh,
homicide.
I was into your,
And there are
okay.
no objections that I'm hearing. All right, so then we get to introduction to homicide. And the standard instructions, from the way I understand them, is this instruction, if there is a death or manslaughter, there's a manslaughter charge, I have to give the
I was like, or a manslaughter.
introduction to homicide.
Oh my God, now the
with
judge
what
moved
would
the
be
tissues.
Excusable and definitions of excusable and justifiable homicide. So
Nobody wants excusable,
while it was
justifiable
crossed-
homicide.
It was X'd out in
Right.
in the defense.
They don't want that.
Yeah,
There's
it
no-
should be X'd out.
There's no allegation of that.
You all want to talk about that?
Sure. Would you like us to stand or can we remain seated?
You could sit. That's fine.
So
I can't.
the state is proceeding, we believe, we're talking about manslaughter now.
Well, I'm talking about, again, yeah, it would be, well, and I'll ask to state this, for the introduction to homicide instruction, all right?
Yes,
That would be 7.1
Correct.
of the jury instructions. Now, it must be read in all murder and manslaughter cases. So I would not have vessel homicide in there and referred to anyway, because it's to be read in all murder and manslaughter cases under the rules.
because I'm gonna double check, because in any DUI manslaughter case,
Manslaughter, right, but I'm talking about
Right.
vessel homicide. I don't think I'm gonna say vessel homicide. I think it's manslaughter is unlawful, because
Oh my lord, has this judge never done a manslaughter case?
It's probably never
you
done
charge it as a
a,
DUI
With vessel
manslaughter.
homicide.
What is the vessel homicide is a separate
which is
Under a
unusual
separate-
down in Florida.
Well,
statute.
or it's the very similar equivalent to vehicular manslaughter. But I guess it is strange they call it vessel homicide and not vessel manslaughter.
All right. And if, as Kat says, if y'all want to follow along, over at our house, I dropped it towards the bottom of the description. So I've got like the factual scenario of the case, and then towards the bottom, I have all the links that Kat put together for Google Drives. It has all the goodies that you may want to peek at while we're
Yeah,
doing this exercise today.
especially since they said they're gonna not pull it up on screen for us to see through the stream. So
Yeah.
So and just to clear up, right now what they're talking about is the instructions say for a murder or a manslaughter case that you read the justifiable homicide instruction. I don't know, and I'm about to pull it up, if it's like a shall, because here no one is saying this was a justifiable homicide. They're saying this was not a homicide at all. This was a accident, So I would think it's confusing to get a justifiable homicide
That it was not
instruction.
a manslaughter at all. Like,
Right. Right.
See, but it's interesting because the defense included the manslaughter instruction.
Yeah, the manslaughter
yeah.
instruction, yeah, because it
But they have a count
charges
for it.
manslaughter, but they right.
Wait,
So they have count 1 is the manslaughter by culpable negligence. Count 2 is the vessel homicide.
okay.
And now she's going over how we're going to just do like the introductory definition of just the word homicide. So the homicide is like I don't know what it's. We could probably pull up the standard, but to the effect of it's a death of somebody. And not all homicides are necessarily unlawful, right? That would be where you start to get into if it's a
Well, homicide is
justifiable.
always unlawful. Not the I mean the death, causing someone's death is not always unlawful, but the word I mean,
Well, there can be a justifiable homicide.
yeah,
Which
but
is
that
what we don't need to
implies
get into.
but that implies the intentional taking of somebody's life. You see what I'm
Correct.
saying? So
Yes.
that's why I'm saying when it's homicide, it implies the intentional taking of somebody's life. So if your defense was, it's that it was justified, like in if there's the instruction on justifiable and excusable homicide is supposed to be given at the same time if you're like instructing on manslaughter, but I don't think it needs to be done when somebody is not alleging. I don't see their notes here. Like
I will
the
now define
I'm in
culpable
Florida's
negligence.
thing.
This is
I
what they want this is what the defense put in their motion for vessel homicide. They wanted to read like this.
Is that what they're
You want-
doing first? Is that the instruction we're handling now?
They're handling just the intro to homicide, the word homicide. Like we haven't even gotten to these specific counts or elements.
Right, they're talking about introduction to homicide is the standard jury instructions, like pretend you're looking at a book, and so 7.1 is like the introduction to homicide. And then so it says read in all murder and manslaughter cases, and then you give the degree that's applicable. So what they're saying there is that the judge is saying she has to, you know, to instruct on justifiable homicide, but it says
All applicable.
right, right.
Well, maybe they'll catch it and they'll be like, it's not applicable.
On manslaughter, but what you have here is the vessel homicide is under a separate statute.
Sorry, Judge, did you say DUI?
I mean, I thought the state just said that it's not if anything, it would be a BUI, but we don't have a BUI charge. And again, I'm looking at my rules and the 2026, and it says read in all murder and manslaughter cases, and I don't.
The reason why, I'm going to try to find a case for Your Honor, but the reason why I think it's important to read as to both of the homicide charges is because the excusable homicide instruction that the court would give as a part of the introduction to homicide, I think applies both to vehicular and vessel homicide, because not every death, whether it's by a vehicle or a vessel, is necessarily going to be criminal. It can wind up that it is an excusable homicide. So if we can hold off on that, I just want to see if I can find a case that substantiates that. But I think it's important that the jury understands that if they find that this was an excusable homicide, whether it's as to vessel homicide or to manslaughter, that the elements of excusable are applicable to any of those charges.
Okay, and I think the defense, I don't want to speak for you. It seems to me that your position is that you don't think it should be given at all.
So I think, just give me 1 second.
Because it was crossed out on your
Yeah, so-
things.
This is a
So
really strange
we agree that
situation.
excusable homicide should be explained to the jury, but think that justifiable is not relevant to the case.
Well, go back and look at the excusable homicide instruction.
It may not be, Judge, but again, that goes along with the
There is no
standard instructions,
justifiable
which
shouldn't
is
be
that the
there.
jury needs to be placed on notice that just because a death results, it's not always going to be criminal. For example, justifiable use of deadly force. Nobody's saying here that, obviously, this is a self-defense case, but I think it's important for the jury to have context within which homicide charges are brought. And that's why I think the instructions for this instruction say it is to be read in all murder and manslaughter cases.
Is she missing the as applicable language there, Ali?
No, she's right on the sense that, um right, like
For the broader
right,
inclusion
but
of just defining homicide.
right, but you wouldn't say, like, you will then consider the circumstances surrounding the killing and deciding if it was second-degree murder or manslaughter, and I would be arguing that there needs to be a special instruction even for that, you know, or that's something that says that you can find that it wasn't criminal, but it says or then it would say, or whether the killing was excusable homicide. But then the standard excusable homicide thing says when the killing so it's excusable when the killing is committed by accident or misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. So that's like too broad here because he wasn't
You're
doing
going
it
to
by
get to culpable negligence too.
right, right, because we already know that regular negligence, which would not be lawful means. I don't know. It's kind of crazy because then it says when the killing occurs by accident and misfortune in the heat of passion. I mean, how is it accident if it's in the heat of passion? When the killing occurs by accident and misfortune in the heat of passion upon any sudden or sufficient provocation, how is that considered
It's not relevant at
an
all here.
accident? No, but I'm just wondering for excusable homicide, it's bizarre. But then it
So even the
says
excusable language seems to be attached to some relation to a
like to
justification
somebody
defense.
actually.
Where are you seeing? Do you have that? Where are you reading that
I'm on the
particular instruction?
I'm in Westlaw on the like I've got the whole jury instruction for homicides up, so I'm starting with introduction to homicide. But for it says it like a dangerous weapon is an object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by design and construction. This is obviously an old instruction that hasn't been updated because that dangerous weapon um and- has been like, that's great. If that's the one that they're using, that's wonderful, but that there we went over it on another live where there was a case that changed that dangerous weapon to be anything that is used as a weapon, not that, um, if it's if used in its usual and ordinary manner.
And happens to result in injury.
Right, because it says no, this one still says the old one. A dangerous weapon is any object that will likely cause death if used in the ordinary and usual manner contemplated by its design and construction. That would be a great one for
Yeah,
the, but that's
defense.
not what the law has changed. So I don't know if they forgot to update
Well, we'll
that.
pick the good things from the old law and the good things from the new law, and then we'll have a perfectly crafted prosecutor friendly jury instruction to send back.
Oh, wait, I found it. Give if applicable. They added it. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. So that took that. But I to me, this excusable homicide where it says in doing any lawful act by lawful means with usual ordinary caution and without
Yeah.
any, like, how could this be said to be done with usual and ordinary caution? We know there was negligence here, or the accident wouldn't have happened. Some form of distraction, ordinary negligence. So,
And
and that,
Ali, you also, while you're on that, do you want to explain like why we're talking about that in the release? I have count one on the screen.
okay. So any murder or any homicide or manslaughter charge. So any time that there, you know, that there's any sort of killing. So with one where it's culpable negligence and without justification or excuse, which caused the death of. So that's where we're saying, like, culpable negligence, as we've gone over, and they will still go over, and they will have to talk about how this, like, butts heads at some point. Culpable negligence specifically says something more than ordinary negligence, something more than recklessness. You can't be reckless and be said to act in the ordinary with ordinary caution. How the fuck can you be both reckless and acting in ordinary caution at the same time? And for count one, culpable negligence requires something more than recklessness. So it's like the instructions, the full amount of the instructions have not come to terms with the new application of, like, using a boat or a car as the weapon, and not charging it as,
And that comes from, that's 775.087, right? The weapon bit, or is
I
that
think so.
782? I think it was this one.
I don't
And what that does is, with that being included here, if there will probably be a line on the verdict form that asks, like, do you also find that this was met? I think it needs to be specifically found, right?
Yeah, there is a special jury, that's why I was surprised you didn't mention that. There is a special jury verdict form where the jurors have to find that this was used as that the boat that the defendant used a dangerous weapon to inflict the death of Lucy, and there will be a separate, so the,
And this
um
adds on extra time to the sentencing exposure.
775, yeah. Yeah, that's the additional 15 years.
Oh, there we go.
782.01. Yeah.
There's a stream. Okay. Thank you, Big Brain Alley.
Well, I think that then the question is whether or not it's anything that could be waived. It may not be, I don't know if it is something that, I think it goes together with the entire introduction to homicide instructions. When you look under 7.1, yeah, it's part of the instruction, so I don't know of a case where part of it can be waived and part of it included. I think the way the instruction reads requires me to read the entire instruction on introduction to homicide in these two subparts.
So I don't understand why it would be read if this is not a case of, for example, self-defense or some other explanation. And I think it's just going to confuse
the jury.
Jury on the issues that are before it. Because justifiable homicide is actually an affirmative defense, I believe. So now we're raising it sort of implies that the defendant has to show justification in a case that has nothing to do with that.
But, Your Honor, like, if we were trying a case of, felony murder and there's no hint of any kind of self-defense in the case, the court would still be reading this instruction. It's not confusing. It's very easy to explain to the jury, and defense counsel and I can talk to the jurors about it, but you know, it's very clear, it's to be read in all murder and manslaughter cases. And when it's called Introduction to Homicide, I think it's kind of self-evident that it's any time that one person is charged with causing the death of another, that's a homicide.
When the prosecutor is talking about, is that what the book says that it's supposed to be done, or the Supreme Court is saying it's supposed to be done? I'm not sure. But what is it that the jury is supposed to do with that instruction? When they're deliberating, what are they supposed to do with it? Why would
They're
they
going to
even
have a
refer to
question about it, watch.
it? Giving them information that is supposed to be useful to them. How is that information to be used in the jury room? When they're talking about, okay, what do we do with this justifiable homicide business? Why are they talking about that in there? And if they're not supposed to be talking about it, why are we telling them about it?
He makes a good point. So, I mean, it is, it says read in all murder and manslaughter cases.
Can you send me what you're looking at?
Um,
Just shoot it over to me so I can.
all right, but you'll just be looking at the one page, like you won't be able to go to the next instruction. I
But
can just
does
put
the
it up. Why
judge-
don't I just put it up real quick? I'm
We
gonna
gotta
send it
send
to
it
you
to
too as
Kat.
well, babe.
You have to send it to Kat. I don't.
No, I don't.
Can I open it?
We've done
I
this
can't
before. No, I
Oh.
got it. Do you
Yeah,
want me
see,
to
I don't think I can
email
open
this to you
Westlaw.
too, though, babe?
No, if you're gonna put it up, I
Oh,
just want
okay.
to be able to look at it.
Okay, because then I gotta do a couple more
Is this
steps.
the right forum? Like, is this the judge's thing that she can decide not to do?
Well, that's what
what
she's
is
trying
the
to
language?
decide.
Is the prosecutor right about
So
the
here's what it
language?
says. First, it says read in all murder and manslaughter cases. Okay, but then it says, okay, chapter 776, 782.02, when considered together, cover the law of lawful use of deadly force. If the defendant is relying on a claim that his or her use of deadly force was lawful, appropriate parts of instruction 3.6F, which is not these, should be given in addition to this instruction,
Oh,
which kind of leaves it vague. Like it makes it sound like this instruction gets given no matter what. And then also 3.6F. Like I'm just surprised that it doesn't say here, like when applicable, because here it says given if only applicable. And that's that extra language we talked about an object can be used as even if it's not a deadly weapon, like the new definition. So the fact that it doesn't say, because here it says give degrees of homicide as applicable. So, you know, why would you be talking about first degree murder if there is no second degree murder? So if first degree murder includes a lesser, like why are we saying that if they're not charged with first degree murder?
you need to be
You
at
know,
this table in court,
yeah,
like
the
with this up
defendant
and
is
saying, by that logic, we'd have to read all of this.
right. The defendant is accused of whatever second degree murder in count blah or vessel homicide and whatever, and then you know like, how does this first part ever get read in this scenario? Like, you can't even change it to say second degree murder and manslaughter, all of which are unlawful.
Because it would
I
be
mean,
manslaughter, all of which are unlawful.
right. So
Right.
here is just them giving an explanation of homicide, period. First degree murder includes the lesser included crimes of second degree murder and manslaughter, all of which are unlawful. However, a
I have
killing that
is the bolding indicative of something that you might like pick and choose, or is it something that
no,
is fixed and must be
it's
given?
usually it's brackets. Like here, you see this third degree, it's like you're gonna throw that one in only if you need to. And then they unbold the stuff where you can add something specific. So if you find that would say Lucy was killed by George,
Yeah.
you will then consider the circumstances surrounding the killing to decide if the killing was. Now, this is why I don't understand why this isn't bracketed, Like they
Right.
only have the third degree bracketed, but it says give degrees of homicide as applicable. So here you would not be saying first degree murder, not even charged with that. You'd be saying second, you'd be saying manslaughter or vehicular homicide, which this is not even there, neither of which is here,
I don't know. They
or
can't
vessel
give that.
homicide.
They can't give that instruction that way. They can't include first degree murder language in there. It's
I
insane.
just don't think manslaughter under the culpable negligence is necessarily something that's supposed to be considered as a
Just
straight
manslaughter.
manslaughter. I mean, that's the only thing you can take from this because it doesn't make any sense. And then here, because it doesn't say if applicable, the model, standard jury instructions make it seem like the judge is supposed to read all of this. But the judge can use her own brain and say, I 100% agree. Justifiable homicide makes no sense. There's nothing for them to consider. It's not an issue here. There's no possible way that this was, justified at all. And I would kind of try to argue that this sentence here, up here, even though it's worded weird as shit, is only if. So if the defendant's relying on it, then you give this instruction in addition to 3.6. But you would think if that's the way they meant it, it would say if the defendant right here, if the defendant is relying on a claim that his or her deadly force was lawful, the justifiable homicide instruction should be given as well as appropriate parts of this and this. I mean,
What is 3.6F?
that's going to be a justifiable homicide thing. So, it's not even in this section. So 3, what is it?
3.6F.
Huh.
I notice this a lot when I'm trying to look up statutes, like some of it's
3.2.
just missing.
Yeah, that's not it.
It keeps going though. So there you go.
3.6F, justifiable use or threatened use of deadly force. So trial judges must give great caution in deciding which statutes apply and which sections of this instruction should and should not be given. For example,
That's what somebody needs to send to the judge.
right, now this is
exact
us, 782.02, all right, which I find that's justifiable use of justified deadly force. The use of deadly force is justified. Okay, so
Here, go back.
I am. I thought the numbers are also similar. It makes it hard for me to. Why didn't it?
It's very
When
small.
I click it, why isn't it going?
How
Oh,
can you read that? Do you have it blowed up?
on my
yeah.
screen, it's
Oh,
not
yeah.
small.
Oh yeah. Okay, I blew it up.
So, all right. Okay. When instructions should and should not be given. I mean that right there tells you that judges have to have some say. So
That's what I'm saying.
they're saying that and statutes within 776 adjust justifiable use or threatened use of deadly force. However, 78.02 does not address the concept of stand your ground and duty to retreat. All right. The situation where the defendant was in a dwelling. All right. So if it is a defense of a crime that the actions constituted justifiable or deadly force, then you define what deadly force means, what great bodily harm means. If the defendant is relying on, if applicable, give the elements of forcible homicide. No, I mean,
See, none of that's applicable here.
no.
I think that why isn't Howard giving her this instruction right there so she can just read that first sentence? Because that's what tells her she's got latitude, that she's got to use great caution deciding which statutes apply. Because I mean, that kind of contradicts a little bit of the language in the statute we were just looking at in terms of, when it should
Must.
apply,
This needs some cleanup. Like this is
Big time.
not how I think this was intended to work.
No.
Right. Let's see if there's something right in the very beginning.
Which, I mean, frankly, to me, speaks to the fact that the prosecution, the state is trying to
Charging.
nail.
They're
I
fitting
mean,
this
right?
case into a
They're trying to nail a round hole or a round peg into a square hole.
Exactly.
it's like
And
it
that
doesn't
really is the
fit.
issue. because they're starting, you know,
Well, and
all the
that's kind of why I feel like the way Laura Adams is arguing this, to me, it's more of it's almost like she wants to embrace that I wouldn't have brought these specific charges if it was just an excusable accident. Look, these jury instructions will define that for you. And I feel like she really wants to just bolster the idea in her closing arguments that they chose these charges specifically because they were the right ones.
yeah, I don't
Yeah,
know
for
where she gets
sure.
off thinking.
For sure. I mean, she's under the impression that this is a round peg into a round hole, but she can't really think that.
I mean, because even when you go to vessel homicide,
What is 776, babe?
what do you mean 77.6?
No, because in the intro to homicide, it says the first portion of the instruction it's got if in relation to two different statutes or here,
You
go
mean
back one more.
7.6?
No, go back one more.
Like you want to see the
Here, I'll show you if you go back one screen. It's the first sentence. It says chapter
right, chapter 776. I think that's the whole.
and 782.02 when considered together cover the lawful
Right,
use of deadly
it's
force.
justifiable use of homicide and deadly force. That's what those
So,
are. That's what
I
we
mean,
just
why are
saw.
we even talking about that here?
Right.
Letting
And
all murder
I
and
think what I would
manslaughter.
literally be arguing, because let's look at this, all right? So this is the homicide, all right? This says reading all murder and manslaughter
It
cases.
makes no goddamn sense. It's
So
crazy.
you've got this is murder, felony murder, manslaughter, aggravated, unnecessary, okay. But this has boating under the influence, manslaughter. So this is not, they choose words specifically. The boat, the vehicular homicide is not a murder or a homicide case under these instructions. Look at the instructions. The words matter. Okay. So
Exactly.
they could have just said for all homicide cases, all
That
homicide
gives you a
cases.
list of the manslaughter charges that it would apply to.
Right. So, and I think that because isn't this an upgrade of vessel homicide? Oh no, it's
There
culpable.
7.9 is in there though.
Yeah, it's manslaughter. No, but it's not called manslaughter, Bay.
No, I know. I get it, but it's yeah.
But 7.7 is that is manslaughter. But they're doing it so freaking weird. You know, it's a fundamental error not to instruct on justifiable. It's a fundamental error not to instruct on justifiable and excusable homicide in the absence of an express concession. There you go. There you go.
That's how you
Here's
do
the
it.
answer. That's your answer right there. That the defense can make an express concession that the homicide was not, well, I don't know about excusable because,
Yeah, we can't get rid of excusable.
well, we also can't use the excusable one that's in there. When you're talking about culpable negligence.
Can I see it again?
Yeah, it's insane. That's why I don't think that, but it says in all manslaughter cases.
Yeah, they need to catch up with it. And I don't think the judge has the room to go around this.
Well, they do for, at least we just found the room for justifiable.
All right, so excusable.
It's this one right here. Can I make it bigger? You guys see it?
No, I can see it. Wait, here, shrink it. You made it too big to fit in the screen.
Sorry.
Because I can just blow it up for me. It's still cutting it off a little bit.
I mean, the problem is what we said
Shrink it
before.
down just a hair more.
I'm trying. My computer's there, not cooperating.
Oh, okay.
It's just this sentence one. With the problem being in doing any lawful act. Okay, so driving the boat is lawful.
Yeah.
By lawful means, so the question becomes, is negligence lawful? But use of ordinary caution. I mean, there's no way that this can be excusable homicide, and if those are the 2 options the jury is given, it literally defies the logic of the second. Like, I mean, what I wanna see right now, I'm just gonna do a little research while we're doing here with, uh, culpable negligence in the same sentence as manslaughter, in the same paragraph as excusable homicide instruction, right? Excusable, is that what it's called?
Excusable homicide, yeah. By an accident and misfortune in doing any lawful act by lawful means. So they're fine there. But yeah, the usual ordinary caution is the problem.
Right. Oh, I forgot to put culpable negligence in quotes.
Babe, you
All right,
gotta
here we go.
find us a case that
Here's
defines what
something right
usual
here.
ordinary caution is.
The trial court committed fundamental error in failing to include definitions of justifiable and excusable homicide and culpable negligence as part of the manslaughter. But that I got to look at it because that might not been a um all right, let's keep listening and I'll look.
Sweet.
I have to reserve on that aspect. The rest of the instruction I would give
What's the rest of it?
on introduction to homicide. I'm going to reserve right now because I just want to look up a few things, see if there's, any cases on that. Because the purpose of the instruction is also to give the jury a clear statement of the law, but also not to confuse the jury. The same reasoning applies, for example, when anyone's making a request for special instruction, or there are some requests here, and I'll get to that in a minute. Whether the instruction itself clearly explains the law, but if it's something that is particularly not applicable given the facts of the case, are we putting the jury in a situation where it might be confusing?
Yeah. So that I'm trying to understand.
I've always I have to say, as a matter of, because it's in the same instruction, there's not 2 separate instructions, although they're highlighted as under different subsections of the statute. This is not a case of justifiable homicide.
Correct, and the way it's currently phrased, the very first page, end of the second paragraph, it says, after introducing the concept of justifiable use of deadly force, it says, if you find Luciana was killed by Pino, you will then consider the circumstances surrounding the killing in deciding if the killing was manslaughter or vessel homicide, or whether the killing was excusable homicide or resulted from the justifiable use of deadly force. Now, why are they going to be thinking about that at all? Why are we telling them?
I understand your point.
Good.
And I am going
Oh, get to the point about the issue with excusable
give
negligence.
consideration to excising it out, because again, the instructions, they're the standard instructions, but also not to confuse the jury. Or maybe some modified instruction that, this is not a case of, or reading the instruction and telling the jury, this is not a case for you to consider any kind of justifiable homicide. But I think that makes it.
You
Well,
might
why
as
would
well
we
just read the
conclude it?
instruction.
Matters that
Can
are
somebody text their friend
irrelevant for their consideration.
and tell her,
I'm gonna think about that.
look at the top
Okay.
of 7.7 instruction?
Excusable homicide, that will stay in.
We
If
could
I
have
could
live
address
chats.
That one.
Oh,
All
thank
right,
you.
here we're about to have the
Maybe some
excusable talk.
Cause for confusion. So
Yeah.
I'm reading the state's proposed instruction where it says the killing of a human being is excusable homicide and therefore lawful under any one of the following 3 circumstances.
Okay,
Okay, 2 and 3 do not apply in this case, because this
One
is
is
not
the
a
issue.
heat of passion case,
Get him,
and
Howard.
it's not sudden combat.
okay.
So,
Well, again, I'm not gonna get to the point where I'm then carving up what the standard
just let him
instructions are.
finish. He was
In
just making,
argument, in your final arguments to the jury, you'll have a copy of the instructions, and it would be an opportunity to, if you felt it necessary, to just explain that there's no, none of this applies. Something
all
along.
right, get to one though, Howard.
okay, so you understand my objection, and you'll rule
I
on
do.
that. But let's
I
go
do.
back to number 1.
Okay,
When the
Coach Bob.
killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. The phrase usual ordinary caution implies not negligent. That's ordinary caution, I believe. It's implying that something beyond that failure to, let me say that again. Negligence would render the homicide unlawful.
Right, it's in direct
That is,
contradiction to
that
the
person,
statute.
Mr. Pino did not exercise usual ordinary caution. That's, as I understand it,
well,
negligence.
that's your argument in terms of the defense to,
No,
you know.
no, no.
Whether the conduct rises to the level of culpable negligence.
It's in contradiction
I
to that.
agree, that's my argument. I'm afraid that this
It
jury
concludes-
instruction is suggesting that if he did not act with usual ordinary caution, he's guilty.
Guilty,
Right.
exactly.
The state has to prove that he did not act, they have to prove he acted culpably negligent or in vessel homicide reckless,
Right,
right? And so the way paragraph 1
Not just without
of the
usual
excusable
ordinary
homicide
caution.
instruction reads, as I read it, is that it's a defense so long as he was doing a lawful act by lawful means with usual ordinary caution, right? So he has to prove he was not
when it's
negligent.
committed by accident and misfortune.
Read the whole sentence,
Yes.
Judge.
But
So
an
long
accident
as-
can be mere negligence, right?
Okay.
Then tell her, then okay, strike the
So I'm not
rest.
sure what the issue is.
What? Oh my God, that's terrifying. Howard, you got to put up the two statutes.
Let me
You
just
got to
give
put
it
up
one
the
more
two
look.
instructions right next to each other. It's a total contradiction.
Yeah, because it's.
It's
Can you break it down? So, guys, when this is read, they're going to hear this part about the homicide first, and they're going to hear that this phrase, this particular phrase, that with usual or ordinary caution, it may be excusable. With the opposite being that if it's not with usual or ordinary caution, then it's not excusable. So, that instruction completely eviscerates any instruction that would apply to the two counts at hand here, where we need to either get the recklessness standard for the vessel homicide or the culpable negligence for the manslaughter by culpable negligence. Because
That-
this instruction
that's
is
exactly
already
right.
defining it as unlawful.
That's exactly right. I mean, it's
Unexcusable.
that simple. That if they are going to read this first, all right, because it's like kind of the umbrella, the homicide umbrella. They're going to read this instruction first, and the seed is planted with that particular language, which is lower. That's just no negligence. Let's say, like, look, I did everything right. Like there was no negligence here. So then when you get to the actual two statutes that he's been charged under, you have a complete contradiction of that particular standard. So it's like, I don't know what they're going to do with it. Like they can't include that language. And she's not seeing it, and she's going to
not.
include it.
And I can tell you, like, I'm looking at this case here. Now, this is an old case, and it was
Where's
like
your
my first.
face?
Oh, your dad went by, so I turned it
Oh,
off.
I missed your
Um,
face.
So it's an old case, right? And so the instructions have changed. And in this case, it's a little bit weird because the defendant is claiming that either it was an accident or it was self-defense, but it still leaves the excusable one the same, right? And why isn't it pulling up? Where is the ordinary caution part of this? Wait, ordinary. I highlighted ordinary.
I'm like, here, let's listen to Howard try to argue his way out of this, and then we'll discuss afterwards. I like
We'll discuss
he
after the judge doesn't budge.
right.
Okay. All
Maybe
right.
she will.
Sh-
Maybe
uh,
she'll come back later and change her mind after, like, maybe she'll agree to it like 2 seconds from now, but like an hour later, she'll be like, actually,
Right. It'll dawn on her.
Because mere negligence is not enough to convict.
Okay,
And this is implying that he has to be not negligent in
Right.
order to benefit from excusable homicide. Am I right? Yeah, negligence is the failure to use ordinary caution.
okay.
So unless I'm misreading it, I think what this is telling the jury is that to have the defense of excusable homicide, you must be acting with usual ordinary caution. That means you, Mr. Pino, must not be negligent to be excused. It's implying that if he was negligent, he's guilty.
plain
No,
negligent.
but he's not, your theory of defense is not that he
That's
should be
not the point.
excused, but rather he wasn't culpably negligent and or reckless.
You have conflicting
Yes, but this instruction
statements
seems
to the jury. Like I don't like you're gonna confuse the shit out of the jury. Like that's what she's not getting.
And what does this have to do with the theory? Because I get that the theory, we're not arguing justification, but what does the defense's theory here have to do with the plain definition of homicide?
Right.
Their theory comes into play when they're arguing the heightened standards for recklessness or culpable negligence, which makes no difference if you criminalize any of these acts and take away any possibility of excuse by a much lower standard.
If he gets convicted and she doesn't change these instructions and allows
We're
that
coming back.
instruction to come,
We're
we're
doing
coming
it
back.
again.
We're definitely doing it again because it's that big of a deal. It's that big of a deal because even the judge doesn't get it. I mean, that's pretty telling. The judge doesn't see the dilemma with it because I don't know if she's just in the right mindset or not in the right mind. I don't know why she's not understanding what he's saying because it's very clear. Like she's saying, okay, well, you're not even applying this defense. Okay, so
Because I think she's looking at excusable as justification. That's the only way I can make sense of this, that she's looking at excusable as some type of affirmative defense.
well, I don't know I don't know in Florida if that is a
It
affirmative
doesn't
defense.
sound like that from what the language that Ali's reading us.
And it's
Like,
even
to me,
scarier. You know what I mean? Because with an affirmative defense, you have to give notice that you're employing it. Like so for that, if it's just a proposition in the law, then it's even more terrifying because it's just out there automatically. You know what I'm saying? Whereas if it's an affirmative defense, like I said, we've got to file notice. Okay, we're going to be employing self-defense here or justifiable homicide, whatever the case may be. And we give notice to the other side and to the court that we're going to be employing that particular defense so that they can prepare for it. With that, like, so I don't know. Are you seeing whether or not it's a affirmative defense in Florida?
Justifiable? I don't think we're
No,
gonna have an
no,
issue.
excusable.
No, 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 no. Excusable negligence is built into, I mean, excusable justification is built into telling the jury that's not homicide.
Excusable homicide.
Right, that's not murder, you know? So,
But
right? I think the judge is interpreting somehow right now. She's got this bubble in her brain that's telling her that excusable homicide is the same as a defense putting forth an affirmative theory of defense.
and she's saying because you're not doing that, this thing matters not. But the problem is that the language is so confusing for a juror in terms of because they're using a standard that falls below negligence in order for that to apply. It's going to confuse the shit out of the jury. There's no question about it because it doesn't play well with the two statutes he's been charged under. It's like they're going to be saying, okay, well, remember that thing that said the first instruction where we read and it was, ordinary care or whatever it is, usual, ordinary, whatever that language is. He's like, he didn't do that. So therefore, he's guilty. I mean, that's the way they're going to look at it. Or they're going to have a question or several questions. How do we deal with these two competing? I
Right.
don't know. Let's see what Howard says. He's got to keep fighting this fight.
To say otherwise. It seems to say that excusal, meaning excusal requires that he use ordinary caution, which conflicts with the theory that the state has to prove culpable negligence or recklessness.
Aren't these affirmative defenses? Reading
told
in
you.
the context of what would be an affirmative defense?
I don't know, but it shouldn't be an affirmative defense. It's the state's burden to prove he acted with culpable negligence or recklessness. It's not our burden to prove that Mr. Pino
No, this is
acted
just, but in the definition of homicide, and where a homicide, when a death occurs in a homicide, okay, the individual accused would be excused from any kind of criminal liability if the killing was done by accident and misfortune while
not being negligent.
while using ordinary caution.
That term, ordinary caution.
Ordinary caution, not
without-
negligent.
Let's see what she said.
Ordinary caution.
That term, ordinary caution, means not negligent.
And without any unlawful intent.
You can ignore
have to
that,
have
Your Honor.
no
Just deal with-
unlawful intent.
So it's putting the burden on us, Mr. Pino, to prove he was acting with ordinary caution, meaning he was not negligent.
I don't think
When-
it shifts the burden.
Well, it says,
Your Honor, if I can just interject, this instruction comes straight from Florida statute 782.03. So maybe the defense wants to look at that statute because this instruction just mirrors what the statute is. So
Laura,
I don't know why
shut the
it's
fuck up.
enforcing that.
It's exactly what is in the statute. Review that. I hear your argument.
Oh, God, I
that
can't stand
this
her.
instruction
Of course, she
Your
wants it in.
contention
She knows
shifts the
exactly what the
burden.
problem is.
to the defense to do something, but
No,
I
it's a-
don't- I
it's a-
don't read it that way.
Don't use shift the burden out of it, although I see his complete point, and say it limits, it reduces the burden.
Yes,
It states an incorrect burden that the prosecution
Correct.
must meet.
right. It's in direct contradiction. I keep saying the words. It's in contradiction to the statutes that he's been charged under, which have a higher.
It's a misstatement of the law in this unusual scenario.
Because
However he wants.
I don't even know why that exists, because if that exists in the law, in terms of if the state's electing whether or not to bring charges, and that like I don't understand why that particular language is included at all, because
Yeah.
that goes earlier in the process when the state is electing whether or not they're going to charge the person based on the facts that they have in the evidence. And if it's clear that the person was acting within the, the confines of the law in terms of reasonable, but when you get to whether or not they were using ordinary care or caution, I mean, and you say, okay, well, yeah, I mean, he clearly wasn't negligent here. Whatever he was doing, it was legal all the way through. You're not charging him. So when does this ever come into play? If it's not to be employed as an affirmative defense, I don't understand in any case that actually makes it to trial where you're reading instruction, when would that ever be relevant? Because the person shouldn't have been charged. if it
Right.
was
That is a
excusable
little bit of
homicide.
I see what you're saying, but in reading all these cases, they're saying it's reversible error if you're charging. I even saw one for
Manslaughter.
manslaughter that said, I think had the words culpable negligence. I got to keep looking through it and not including the excusable, um, but I think what he should do again is go to that 7.7 where it says that if there's a, um, a, if there's an assertion, this is not excusable homicide as defined by the statute, as defined by, as meant in the jury instructions, because the burden on the state is they it, they have to prove more than he was not just that he was more. They have to prove that he was more than caution or used more was more reckless than ordinary caution. I mean, I just don't know why this is. I'm almost going to go back to that case that we looked at before and see if they had any jury instructions there. See if I can dig into it because where the one we went over before where he used a car, but in that case he was revving the engine at the like charging the guy with the car. So it's not there. There has never been, Bob, you weren't here for this day, and I'm going to repeat it for everyone now. I did research, and it is clear that there has never been, at least a Florida case that's been reported, like an appeal or whatever, a Florida case where and this was only for the upgrading part, upgraded manslaughter to, or upgraded it to that 15 years where the person didn't direct the vehicle or the vessel at a person, like
Right.
where they didn't
That's
direct.
that's clearly what they're talking. Like when they drafted up that statute, they were thinking of somebody that's in a car that's using it to run somebody over. Like that, like that's what they're talking about. I mean, yes, can it apply to a boat? I suppose if somebody's floating in an inner tube, like on the water, and you decide, oh, I want to kill this person, so I'm gonna plow
No,
over him with my boat.
right, or I'm gonna, mess around with him by going towards him. I'm gonna,
Well, whatever the case may be. I mean, like, I don't know that that's murder, that situation you're talking about. I mean, it could maybe second degree. I don't know. It's seriously, I'm just trying to figure out how they're going to get her off that. That's going to get him convicted. That language.
I'm going to send you guys something in the private chat. I think it's comments from a Florida Supreme Court justice taking issue with exactly this. And I'll show it quick on screen so you guys know what we're talking about.
actually,
But
I'm
they go through like issues with why excusable homicide conflicts with culpable negligence. But give Ali some time to look at that, Bob some time to look at that.
Kim, our Venmo angel, sent 25, like she always does. She's so delightful. She is our Sheriff Chuck.
yeah.
She every day she just showers us with love. And then Mary sent 25 as well. Thanks for explaining this case to us. Love your coverage of this and other cases. What email is the best way to contact Ali? Ali, you want to give it to her? It's a true crime podcast or pod. So a true crime pod at gmail.com.
I mean, none of the emails actually come to me. Not a true crime pod or
That's on
insiders.
you. That's on you. Like why you're not part of the insider thing.
Well,
I've been asking for 2 years. I'm like,
I
why
told you it's because it was set up. I don't have an email through that. Like that was set up as you and Darren, so you can't forward it to an outside. I'll figure it out. But yes, use a true crime thingy, and I'm just gonna have to figure out how to get that email to me so I can be looking at it. It's not like it's a secret, right? It's different than what I set up with you and Darren, babe. Like that's through like the workplace thing and
what?
nothing. But let's just keep going and I'll keep researching and then I'll look at what Kat sent.
Yeah, I mean, whatever I sent you, I take it it's something that was not implemented, but somebody was strongly advocating for it to be implemented to fix the confusion we're seeing play out right now. So.
Well, I understand what your point is. I don't read it that way. This is just, in defining what homicide and what would be, again, I'm using the word excusable. It's in the definition, and that's the definition of what would be considered an excusable death. I don't think it shifts the burden or puts any responsibility.
So maybe I should ask, what is an example of an excusable homicide that's not, let's say, justifiable homicide?
An excusable homicide might be a person is driving their car down the street in a lawful manner and a kid runs out in front of the car and the person runs the kid over and unfortunately the child dies, that would be considered an excusable homicide. If for some reason a prosecutor wanted to bring charges, then the defense would arguably be able to say, no, this is an excusable homicide because my client, this was an accident, this is misfortune, he was doing a lawful act by lawful means with ordinary caution without any unlawful intent. That's exactly what 782.03 envisions, and this statute, this instruction simply puts words to that statute.
If there's a presentation of an affirmative defense, there's no requirement on the defense to, there's still no requirement on the defense to present any affirmative evidence.
So if the court, hang on one second.
Oh,
Yeah, so our view is if the court is going to give us the choice between having that paragraph 1 and reject my suggestion that it should be modified, I would ask that no instruction be given on excusable homicide.
there you go.
Okay, that's your request. All right, what's the state's position?
Well, the
the
state's
easiest
position
solution.
Is that it has to be given because.
Nope.
it's-
Go to
Nope.
7.7.
782.03 couldn't be more clear.
Nope.
And
Nope.
Somebody tell
really,
Howard.
you know, if they don't want it to apply, that just seems,
Express concession.
I can't understand why the defense wouldn't want an instruction that's supposed to be read in all homicide cases. It's
Because it's
individual
not.
homicide. I guess they think it's maybe not good for their client, but we're not gonna stack the instructions to be pro-state or pro-defense. They're just supposed to.
But you are
acknowledge what
stacking
the
to be
law is.
pro-state, Laura.
I see the instructions.
You goofball.
So, under the circumstances, I'm required to give what would be standard instructions.
God
Okay.
bless it.
In
Read.
every case.
Babe, you
Whether
gotta find somebody to
this
email that
says,
to him and
of
tell him
course, in the
she's gotta read it.
instructions,
What case did we send the?
it's a manslaughter, and that's why I brought up the question of.
In case you were
vessel
watching and you sent the
homicide,
case. Oh, I can't
Because
remember
it
what it
doesn't say
was.
Yep. It's this thing has a it's got overruling risk, but it's still in the 2026. This is the 2026. I was looking at the case, but I mean, who do we email? I'll email somebody.
Somebody at Howard's firm.
Janelle.
How do we somebody give me your email address?
I'll look for it.
in every case, whether this says, of course, in the introduction to homicide, it's a manslaughter, and that's why I brought up the question of
I only see a
how
context.
vessel homicide, because it doesn't say specifically. I mean, a death occurs, but manslaughter and the elements of manslaughter are different, right, than the vessel homicide. So that's why I said that I don't know whether or not I would be including vessel homicide in the instruction. I would say manslaughter is unlawful. A killing that was excusable or that was committed by justifiable use of deadly force is lawful. And then I go, because if you read the instruction, do you have the book in front of you? Yeah,
No,
yeah.
but I can pull it up if you tell me where to look.
Yeah, it's 7.1. It's the 2026 standard instructions.
But hey, look at 7.22, idiots. I mean 7.7 at the top.
7.1.
So if you go through the 7.1 instruction.
You know what,
it will be
Kat?
read in all murder and manslaughter.
Pleadings usually
Okay,
have-
manslaughter.
Pleadings usually have a lawyer's email on them at the bottom of the signature page.
Oh yeah.
Oh, I still have my camera off.
So I have to object, and just as a point of reference, in the 11th Circuit, I had argued a case that the pattern instructions were mistaken, and the case resulted in a reversal, a case called United States versus Tackalaw, and the standard instructions were then changed because they were wrong. I don't think these instructions are that you must give them if they conflict with another instruction. So let's ask, how is the state going to use that instruction in its closing argument, and how is the jury supposed to use that phrase that we just talked about, where it says it's an excuse if the defendant is acting with ordinary caution, it implies that it's no excuse if he's acting negligently. And then, because that's what ordinary caution means.
No, but if the jury does not find something more than ordinary caution, then your client's not guilty.
Except that instruction seems to say otherwise. It seems to say he's only excused
If it's
he
ordinary.
acts with ordinary caution.
Correct.
There's other parts to that.
Well, then that's why I'm saying they conflict with each other.
I'm not sure I agree. But
Let's just hope the state doesn't argue in closing using that instruction and say, here it is right here. He's only excused if it's ordinary caution.
They will.
I would think that would be an improper argument.
Which is why I don't want the instructions submitted to the jury.
Exactly.
Like there's an echo.
Okay. I hear what you're saying.
Do
Hope
you
so, because sometimes you just say
hear
that.
it, but do you understand it? It's one thing to hear something, it's another thing to hear and understand it. I don't think
Well-
she's hearing it. Hopefully she's going to give it some thought. She's got a long weekend. Maybe one of her friends is watching this. Say, hey, you know, that Howard guy had a pretty interesting point. You might want to think about it. You know, and like we have the weekend, babe, to get Howard. He's got to read that language.
Yeah.
It's imperative. All right. I'll be back in a minute. I'll be
Alrighty.
listening.
He's gonna be screaming in the distance as he keeps listening.
Just to let you all know, while I ponder this,
Ponder.
I'm inclined to give the introduction to homicide instruction. I'm considering whether or not I would excise out justifiable homicide, because under no circumstances do I see
Still considering?
that even relevant to this case.
So just excise it now.
And in terms of the definition and excusable homicide, at this point I'm inclined to give the instruction as it appears in the standard instructions. Your objections are noted, and I'm still deciding whether or not, and I'm really not inclined to give justifiable homicide. I just think that might be a cause of confusion, and unnecessary confusion for the jury, and I don't see at all how, I think it's worse to put the onus on either party to argue to the jury in closing, by the way, you see these are the instructions, but disregard this, rather than just not have it there. I just don't see how at all excusable homicide applies. So,
What? Did she just
I mean
miss the
justifiable,
beat?
excuse me, justifiable homicide.
No, go
Yeah.
back and say that.
So-
It was
Right.
right.
But now excusable will stay in. I'm going to excise out justifiable homicide and give the rest of the instruction. Okay.
Objection noted, Your Honor.
Let's go to the instruction on manslaughter.
Maybe she'll click while we're going over this part.
Okay, I'm going to find the defense usual instructions.
So are you there, Judge?
I'm ready.
Also, did she not just concede that she can, because the state's position is you have
Exactly.
to give this instruction as is, but she just conceded that
Concede-
she can
right.
use
That she's
discretion
got-
to craft and
exactly.
curate.
Mm-hmm.
So I meant to pause and ask that.
And what I'm trying to figure out right now is when they say that the defendant has to expressly concede, I'm wondering if that means like by way of like to the jury, like by way of a thing that says that the defendant, agrees that this is not justified. I'm just trying to research it a little bit more.
Well, and it's almost like she acknowledged the kind of burden of persuasion argument just by touching on the confusion and saying that, neither party should have to deal with hey, we're reading an instruction, but we're also going to tell people to disregard that part that we just read. We don't want any party to deal with that. But that's on the flip side, what the parties need to deal with is what they have the burden to do. And here, since we're not doing anything that's an affirmative defense, there is no burden on the defense here. And including that excusable homicide, for the logic that the judge wants to include it, becomes a burden clarity problem.
Right.
So it's like she's like this close to getting it. I don't know. Maybe it's better that it's included because it's if people might convict just because of this mention of alcohol, which I think is also not properly following jury instructions. That's not really the elements here. Maybe who knows?
Okay.
Actually, I was going to propose, if it's the same to you, to start with vessel homicide, since manslaughter is supposed to be the instruction that has additional burdens on the state. So we can first understand what vessel homicide means, and then the court would decide what additional burdens the state has to meet to go to manslaughter from vessel homicide. That's
Okay. I hear what you're saying. I'm okay though, starting with the manslaughter. I'm just going through the elements that need to be established. And because you have, in the manslaughter, you have, and I understand why, you have included additional language that, in terms of definitional type of language, that you're gonna ask me to instruct the jury on, that are not part of the standard instruction.
That's right.
And the reason why, I'm gonna make an assumption, is because there has to be more that needs to be shown in terms of culpability. It's a greater amount of evidence in terms of culpability. Culpable negligence is
Not just
a
a failure to use
greater
ordinary
burden.
caution.
And in describing that, we don't have the same explanations provided in the vessel homicide.
So that's in theory correct, although, as I've indicated throughout the proceedings, there's, in my view, tremendous confusion, indeed vagueness, associated with these two different charges. I understand the Supreme Court of Florida in a case called McCreary, and then a subsequent case over dissenting justices' opinions, there's this, I would say, a minimum confusion over the differences. If nothing else, it's hopelessly vague, but we'll get to that. And so, yes, I agree with you with that caveat. It seems to me that, well, I guess we should start and then we'll go through manslaughter. if that's
Let's work
all
through
right.
it, okay?
So there is
So-
one issue I'd like to
Yeah.
flag for you. So manslaughter apparently has multiple ways of prosecuting it.
Correct.
The statute itself, we can just pull it up. So we've been talking a lot about, throughout the trial, about culpable negligence as one way to establish manslaughter.
Okay, so let's look at 7.7 under the standard instructions. Let's go ahead and look at that, okay?
Are you looking at 7.7 in the pattern?
Yes,
Okay.
2026 standard instructions.
Moment. Okay.
And if you notice there, there's some language there, that it's fundamental error not to instruct on justifiable and excusable homicide in the absence of an express concession that the homicide was not excusable or justified.
That sounds to me like it can be waived,
Well,
so it's not required to be given.
well,
Right.
express concession.
That's exactly what
How
we've
I
been talking
interpret
about, you
that,
guys.
Right?
And that's what I'm wondering. What's
Does the
express
state have an
concession?
objection to my excising out the portion of the instruction that I really think raises unnecessary points that are not applicable in this case?
No, I don't like it.
Which,
Okay. So,
But I would object to not including excusable homicide.
sorry?
I would object to not including excusable homicide.
Right, I'm
But if the
talking
defense
justifiable.
is affirmatively saying they do not want justifiable use of deadly force,
she's
Same-
aware of this concession. She's so
She just said it.
disingenuous.
Right.
She's known this whole damn time. She's so, I'm so mad.
And wait a minute.
Ugh.
I'm reading. Okay, this is from 1907 Supreme Court of Florida. 1907. The refusal to charge that culpable negligence.
Wait, is it on your screen?
Oh, you want
You
me
want me
to
to
put it
pull
on
it?
my screen?
Yeah, we can
Okay.
read it with you.
So this is just, I haven't even clicked into it. But the refusal to charge that culpable negligence is not merely an omission to use ordinary caution. That's literally the words, but must be the result of an intentional act done without ordinary caution. Is an error, as culpable negligence is not necessarily the result of an intentional act. Is not the result. Wait, why is that part? Must be the result of an intention. The refusal. Okay, that's not an error about the intentional act, but damn it, I thought that said, um, Here we go. It is not an essential element in the statutory definition of manslaughter when committed by culpable negligence in the charge predicated upon the theory that intent in every case is essential to a statutory crime of manslaughter. Da, 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 da. The refusal to charge. Oh no. But so let me see something because it's getting into a different point, although it says what I want it to say. It's getting into the fact that it doesn't have to say an intentional act, but it still confirms that it's yeah, not an error.
I mean, in any case,
Right. Yeah,
there's
yeah,
no
yeah.
way she was not aware of 7.7. It's like, well, they're going to use that concession I acted like didn't exist. I object. It's like she's playing on this judge because the judge is just like,
All right, I'll keep reading this because it seems like it's getting into what I'm thinking, but go ahead, keep going.
Okay. Let's run that back right here. This exchange from the last thing the defense said.
7.7 under the standard instructions. Let's go ahead and look at that, okay?
So we pull up 7.7. Look at her pretending to look through
Are
her
you looking at
papers.
7.7 in the pattern?
Yes.
Okay.
So
7.6,
Adrian Love.
standard instructions.
Already looking away.
Roll it.
And if you notice there, there's some language there, that it's fundamental error not to instruct on justifiable and excusable homicide in the absence of an express concession that the homicide was not excusable or justified.
That sounds to me like it can be waived.
Yes, that's what we've been saying. That's what we've been saying over here.
Oh, express concession. How do I interpret that, right?
That's the question. That's what I was wondering.
Does the state have an objection to my excising out the portion of the instruction that I really think raises unnecessary points that are not applicable in this case?
No, I don't mind.
Okay. So,
But I would object to not including excusable homicide.
sorry?
I would object to not including excusable homicide.
Right, I'm
But if the
talking
defense
justifiable.
is affirmatively saying they do not want justifiable use of deadly force to be instructed, then, okay, that's fine with me.
Okay, so I consider that a sufficient express concession by both parties on that,
On justifiable use, yes.
unjustifiable. Okay, so,
Is the defense,
Yes, I agree on justifiable homicide.
okay, good.
and beyond that, because the defendant is not here,
I'm gonna have to readdress this with Mr. Pino present before I'll put everything in kind of the best final form, and we're gonna convene, I think probably 9:30 on Monday, and 9:45 even, I think, having that express concession. I'm gonna have duplicates prepared for either way, just because I'm gonna roll it like that. So in the event that Mr. Pino doesn't agree, then I have the instructions completed. I'd like to have them completed, and we're gonna complete our charge conference today, is my plan, all right? Whatever is outstanding, throughout the course of the weekend, you'll hear from me, and I'm going to have prepared what I consider to be the final instructions. I'll put anything else on the record.
If that hits the
so
docket,
it should
we'll
be
share it.
available to you as you're giving your closing argument. The state's gonna start, and I guess you'll reserve time for a rebuttal argument anyway.
I'm
For
just wondering
sure.
if it's possible that the defendant could at least join us by Zoom or something so that the defense can consult with their client. These are really fundamental issues that might be a
That
little
you
bit
wanted to
boring.
ignore. That you wanted to ignore. And now she cares so much.
Right.
Oh, I'm gonna screenshot her face right now. Like, this is just blowing my mind, the way that people can switch up the way that they act so quickly.
The defense can consult with their client. These are really fundamental issues that might be a little bit boring for people that aren't in law, but this is the crux of the case. I don't understand why.
Well,
I
we
think
know.
the court excused him. I didn't realize the court had done that, which of course is within your honor's discretion, but
Well, I don't think they would be.
Look at Mark.
Well,
I mean, this is absolutely a fundamental part of the proceeding.
no, it is absolutely a fundamental part of the proceeding, because I have to get his acknowledgement, and I guess I'm comfortable that I'm going to get an acknowledgement and agreement Monday morning.
I'm
And-
certain that, I can say I'm certain that Mr. Pino is going to rely on our advice on these issues, without a doubt.
Okay,
If you'd like, Judge, today we can actually have him submit something in writing before Monday, if that would be helpful.
The problem is, Judge, that I'm quite confident that this defendant's attorneys have told him on multiple occasions to stop emoting during this trial, and he hasn't.
I'm sorry.
What
To stop emoting, to stop with the head nods and the head shakes and the gestures and all of that, and he has not stopped. So I just.
He hasn't
I know
stopped
his attorneys
back
are
in court.
operating in good faith, but I don't know what to expect from this defendant on Monday.
Okay. Once we get to the conclusion of this charge conference, before I sign off, I can summon via Zoom your client,
Sure.
and at least I would get something verbal, as far as that's concerned, and then I'll follow up with it, in person on Monday. Okay? All right. So let's get through the manslaughter, charge. Number one, the two elements must be proven is the victim is dead, so Luciana Cristina Fernandez is dead. And number two, give as applicable, so there's several subparts. A, defendant intentionally committed an act or acts that caused the death of the victim. Now, you've taken that out,
Yes.
okay?
We believe this case is about culpable negligence. That's the third prong, C. Charlie prong.
Okay,
And so A and B are not at issue in the case.
okay,
Judge, the information in count one alleges that the defendant did intentionally commit an act or acts and/or acted with culpable negligence. So that's why both prongs should be given to the jury. The court did not JOA on either prong.
you didn't,
No.
okay.
So let me begin by renewing then on the A prong of manslaughter. And then we're going to, if the court is overruling that, then we're going to have to spend some time understanding the difference between the two, because it's going to be complicated. But first, my motion is to judge judgment of acquittal on the A prong, intentionally committed an act or acts that caused the death of Lucy.
Which is what I heard yesterday, I think. That was part of.
That was part of it. Your Honor had asked some provocative questions about that. And,
Oh, thank you. Okay.
well, many of your questions are provocative, but on that subject, it caught our attention because
course.
what is the act, what is the difference between A and C? Let's ask the question that way. You would ask the question,
And I mean, I think I understood our conversations and what I based, my ruling on. I denied the judgment of acquittal. The state charged this in the alternative, right? And/or, it could be either. So manslaughter could be, in their charging document, if they're able to prove manslaughter either by Mr. Pino intentionally committing an act or acts that caused the death of Ms. Fernandez, and/or the death of Ms. Fernandez was caused by the culpable negligence of Mr. Pino.
Right.
And so your question was, and part of the argument was, what is the act or acts, well, that caused the death? The defense position is hitting the marker was the act that caused the death.
correct.
Okay,
Because absent the elision, there's no death.
okay, I understand. And I'm not gonna speak for the state, so I think I understood their argument was the act leading to the elision are the intentional acts that lead to the death, such as, Ms. Adams, I think you said, the change of course.
Right, we already litigated that, but yes.
Okay, so, and that's what the state argued would be the intentional act or acts that ultimately caused, that caused the death of Ms. Fernandez. Does that make sense?
Except that the change of course didn't cause the death. It was the elision that caused the death. I understood change of course is the culpable negligence, is putting it on a path towards an elision. It's not, it doesn't cause the death. So at the moment that he changed course, nobody died.
I can't charge the water with causing her death.
That what?
I can't charge the water with causing her death. I mean, we already litigated this. These are whether in the the charging document, the court denied the JOA. This is an accurate statement of the law.
So let's go down that rabbit trail. What is the jury under 2A, the act or acts that caused the death? The state is saying now it's enough that he changed course.
I'm not saying that.
I'm not sure what then the act is that caused the death if it's not the elision. Because typically culpable negligence, the whole course of conduct that puts the passengers in peril is what typically happens in culpable negligence, driving in a completely erratic way beyond the pale, and something happens, but it was not, there was no intention to crash in a culpable negligence case. If he intended to crash, if the driver intends to crash into the pole, if Mr. Pino intended to crash, let's say that a driver says, I think the Robalo can handle it. I'm going to hit the pole and prove that the Robalo is just as good as a Grady White, that other boat ramp. What is the crime? He didn't intend to kill anyone. He thought it was going to survive the crash. He's guilty of culpable negligence if the state proves he's acting with such depravity that even though he doesn't intend to kill someone, that act of elision causes the death.
Doesn't it go to whether something is foreseeable given the conduct?
It would be foreseeable that someone could die if you allied with a marker at 47 miles per hour. So if the person intentionally allied with the marker at 47 miles an hour, that would be manslaughter. It could be murder if it was his intention to kill everybody. If it was suicidal and homicidal, that was his intention. The state's not contending that. There's no evidence of that he intended to kill anyone. The state may be contending, I thought they were contending he wasn't intending to hit the marker at all. That's what they've said before in this courtroom. So if he was not intending to hit the marker, and he was simply intending to go back to Ocean Reef, but because of his failure to act with sufficient care, he was reckless in the way he operated, he accidentally hit the marker, accidentally meaning he didn't intend to, then he's perhaps, that's where the state is pursuing subsection C as a theory of manslaughter. That's how I view the difference between A and C. A was an intention to strike the marker, although without intention to kill him. C is no intention to hit the marker, but driving in such a reckless, forgive me for using that word, culpably negligent manner that it was predictable if you drive blindfolded while drunk at a high speed, you're going to hit something, even if you don't intend to. The best example that I could come up with in my mind in a car, somebody's running away from the police at 90 miles an hour down the interstate. He doesn't want to crash. He's trying to get away. But you go 90 miles down the interstate in the opposite lane through traffic, there's a high probability you're going to crash and kill someone, even though that's not your intent. That's culpable negligence at a minimum, perhaps.
Well, if you, in the driving example, if you're driving on the wrong side of the road, okay, it's foreseeable, reasonably foreseeable, that someone's going to come up on the other side.
Right, and that's culpable negligence.
Okay.
That's different than
But you don't need to be driving at 80 miles an hour to do that, or, you know, weaving or...
You may be right about just how reckless one has to be, but in either scenario, it was not the driver's intention to have a crash. It was his intention to avoid.
Is it reasonably foreseeable that a crash would result if you stay on the left side of the road instead of the right side of the road?
It could be, but that would be culpable negligence, not under A, an intentional act that causes the death. The causation of the death is the impact.
Okay.
Driving on the wrong side of the road may or may not result in a crash, depending on who's there.
Okay.
So
So
that's,
in your position, the only applicable subsection would be C.
that's right.
Okay.
Well,
And,
reserving my objection, of course, that they haven't proven even that.
Okay.
But A appears not to even be the theory of the state that he was trying to hit the marker.
okay. Now, understanding it's charged, and I'm going to run back to the state on this, oftentimes, you know, charged in the alternative, it seems that that's how it's charged. So, in terms of the evidence for intentionally committing an act or acts that caused the death of Ms. Fernandez. And one more time for me, the acts that caused the death, beyond the actual impact.
Can I just incorporate the arguments that I
Like,
made
she's
during
still not
both
clear.
the JOA
If the judge
JOAs?
still
I've already said
cannot-
it on multiple times. The court has denied the JOA. The court
I
has
know.
already
And
found as
let
a
me-
matter
let me-
of
let
law
me
that the
ask-
state has
in
proven
your
enough for it
argument-
to go to the jury.
Right. In your argument, and again, defense finds distinguishing, and there's no way, apparently, from the defense argument to distinguish.
It's still going. Why does it always freeze like this? See if it goes to that live view thing. I wanted to hear this so badly, Ali.
This is killing me. I mean, if the judge cannot understand what your theory of the case is, she should have, and she's just like, but you've already denied their judgment, their motion for judgment of acquittal, which
Yeah, but
just
maybe
proves
you
she
denied it
shouldn't
because we
have.
didn't get it.
Right, but she surely shouldn't have because she still doesn't get it.
It's gonna do that disconnect thing, guys. So it looks like we're missing about like a minute and a half here from when it first blinked out.
Because
And that live view comes from the equipment that's transmitting for all cameras, so it's not like we can just go find it on another feed.
manslaughter because this is manslaughter because it was established X, Y, and Z under subsection A, or alternatively, how they've established under culpable negligence that it's a manslaughter. That's what they're gonna argue. And you're gonna argue A there's no application at all, and there's no culpable negligence. I think that's how it's going to work out.
Except that, yes, except that there needs to be some understanding of what the word act is under A, that if as a matter of law, the act doesn't cause death.
Well, here's the thing. If there was some requirement, at least from a legal perspective, from the court's requirement of how to instruct the jury on the law, okay, there'd be a definition, right? And there's no definition here, there's nothing provided by defining what the act is. What the act is, okay?
It has to be that which caused the death.
Okay.
Under A, the act has to have caused the death. That's the definition.
Right.
And so
And what's the weapon? Is
maybe we
the
should,
post the weapon or the
we
boat?
move
How
down-
about this, if Mr. Pino, from the evidence, didn't change course, would there have been an elision? No.
you're saying at the 9-second mark, if you had stayed on the path before the
Well, I think
9-second
before- I
mark.
think before that, wasn't it?
No.
Wasn't there a change of course at like 30 something seconds?
I think the state's theory is that at about 9 seconds to impact, there was a change of course that put him on a collision course. That's the state's
Okay.
theory.
So that's the question, right? That's my question. If there was no change of course,
At 9 seconds, he would have
there would be
avoided.
no elision.
That's correct.
Okay, so I suspect what's going to be argued is that the act itself of changing course resulted in the elision.
Except,
Okay, we're gonna keep going back and forth on that. I certainly get your point. Over objection, I'm going to give subpart 2A and subpart, which would be C, but I'm gonna call it B. Because subpart B here does not apply. Okay?
We
Your
agree that-
objection is
we agree that B doesn't apply, preserving the objection is.
absolutely. Okay. Go to the next paragraph. Okay, I don't see any conflicts in what you provided. Then the paragraph that starts with to convict of manslaughter. I think I would be taking out, let's see. I'd be taking out justifiable, okay?
Yes.
We agree to that, but here's where the conflict then arises
Okay.
with excusable homicide.
Okay. It says not merely negligent. So it's already in there if Mr. Pino, if the jury finds Mr. Pino was merely negligent, then they can't convict him of manslaughter.
That should end it.
Okay,
There should not be the confusion about excusable homicide.
okay. And that is consistent with the argument you've already made about excising out excusable harm, not giving essentially not giving the definitions beyond the first paragraph definition on introduction of homicide.
That is correct, that is our
Gotcha.
position.
Okay.
And we would submit that there can be a combination of more than one negligent act that would still be insufficient to convict. And to the extent that this is implying he can have one negligent act, as long as it's clear let me stop a second.
I would say an act or acts, but these, again, when I'm going through and looking at the standard instruction, and, the points you're raising, and if I'm not agreeing with it, you've preserved, obviously, and whether, right now I'm continuing to follow what the current standard instructions are. You're talking here, commit an act or acts that were not merely negligent.
I think the simpler way to read, for it to read would be, George Pino cannot be guilty of manslaughter by committing acts that were merely negligent.
Well, that's kind of an interesting point, right? Let's say there are multiple negligent acts, okay? Does it become the case that multiple negligent acts, maybe individually in and of themselves, would not rise to the level of the type of culpable negligence that would need to be proven for there to be a manslaughter conviction? But the cumulative nature of multiple negligent acts combine to establish the level of culpability necessary to establish culpable negligence and manslaughter.
I have not seen a case that says that you add up failure to act with ordinary care, that a combination of failures rises to the level of culpable negligence. I just haven't seen that case.
I'm just, this is kind of a mental exercise.
Because what we're getting back to is it one act or is it multiple acts? Is it the operation of the vessel as one act? Or is it speed plus X plus Y plus Z, none of which per se rise to the level of culpable negligence?
Well, isn't that what a lot of the cases that when you're talking, the cases that you've cited?
Right.
It's that it's not, there's a combination of factors that led to the conclusion, at least for that jury that was affirmed on cases, or a combination of factors that would either support or not support the verdict.
Right, in many of those cases there were multiple acts and the courts of appeals said not enough.
Okay, right.
So that the combination of multiple failures of the defendant do not combine to reach the culpability.
Depending on what you look at the totality of the circumstances, right? You have to look at the totality of the circumstances. You can't just look at it in a vacuum. Each case is very fact specific.
Right, so the combination of conduct, I suppose, is either negligent or not. And if it's negligent, then is it culpably negligent? Meaning it's not mere negligence, it's got to rise to the level of that willful, wanton, because by definition, mere negligence is not an affirmative decision one makes, it's a failure to exercise care. It's not a willful and wanton disregard. That's where we get into the higher level of, mens rea.
Mm-hmm.
Right? So I forgot my keys. I did a whole bunch of things where I was not paying attention, and I still didn't act with, mens rea. It was just.
Well, again, depends on the circumstances that you place yourself in, or that are created, right? So, I think that's the whole point of, one of the points of this case, isn't it?
So we could just go through we can do our sort of closing argument in deciding how to evaluate this, but ultimately the event that, as we've said already, the event that causes death is the elision. Anything short of that won't, as you pointed out, if you stayed on course at that speed with those life preservers, with everything else the state is focusing on, there's no death. So that's why I'm struggling with the theory that the state is advancing, and it can't be enough that the state is going to say the flares you should consider that he had expired flares on his boat in deciding whether he was acting with wantonness or willfulness in his operation of the motor vessel, that he forgot to update his flares, and you should consider that. It has nothing to do with the cause of death. Nothing. Zero. He doesn't use a kill switch. He could have been more careful. All of these arguments that the state is trying to advance, none of which contribute to the cause of death.
Okay. So where am I going on act or acts?
We propose the language. If you're going to overrule it, then it just remains the pattern.
Any comment from the state?
Well, I just want to make sure of the standard instruction after Your Honor reads the two elements of manslaughter.
Mm-hmm.
Every person has a duty to react reasonably toward others. Are we in agreement with that sentence?
Yep. No, that paragraph, I don't think that there was any dispute.
I'm just, we're talking about a lot of different things. I'm just trying to narrow down. Are we in agreement with that first sentence? If so, then let's go to the next sentence if we're in agreement on that, because otherwise we'll be here until, really late trying to get standard instructions on two relatively simple counts of manslaughter and vessel homicide.
Are they?
All right.
If you don't know your theory?
Then in the first paragraph, the defense believes that it should just be a merely negligent act, and then
Why is she rushing
not
the court
have
anyway?
anything.
Like, is it appropriate for her to try to rush the court?
Not remotely. Not
Especially
remotely.
when you're like, can we get the defendant here? Because I want him to confirm that we're actually going to do this thing that I don't want you to do. But now
Right.
let's hurry up. We shouldn't be taking all day to do this. It's simple.
Right. It's not I mean, the defense has been saying we're going to have this problem at at the conference charge conference, because the statutes, the rules, the instructions, the way they're written now aren't applicable here. They're not in harmony for what we're looking to do here. And I, you know, I haven't, because I can't really pay attention and research, so I haven't really looked into if they defined what an express concession is, because in some of the cases I'm looking at, they're comparing it to, like, when a defendant kind of concedes one of the elements of the offense, which is not what's happening here. But an express concession that it's not, I think, would be him just saying, "This case doesn't," on the record, "This case does not involve excusable homicide as it is defined by statute."
And we don't want this instruction. It's an express
Right,
concession to not include the language, not an affirmative, we did this element.
right, right. So, but there's in any event, like you said, like you aptly pointed out, when the judge says, "I have the discretion to remove the justifiable homicide instruction," then she sure as shit has the discretion to remove the the excusable homicide instruction. But there is a lot of case law, which is why she felt more comfortable when she read that concession thing that says
It must be given.
it must be given. Um, but not in a factual scenario where it literally doesn't make any sense, you know? So, but yeah, that I think that the prosecution knew damn well that it said, you know, the consent,
I,
like
I don't think you were looking at the screen, but she like boop looked through her books, went like this, and then started looking over at Borscht. Like she wasn't even trying to read it. She already knew.
right. Yeah,
Already knew. So
she already knew. But it's like the jury instructions, like a lot of times this becomes second nature. So you're not reading every single one every single time to remember like what are the little things that they have said. But in this situation, when you know that that's an issue, I'm just shocked that these lawyers wouldn't have been looking at every single thing about this. They should have been armed with case law, with everything. They knew that this is a like, case blowing up situation. Like it is
with these
everything.
charges that are fitting like a novel scenario, at
Right.
least in the way that they're being applied to this specific set of facts.
Right.
So, and I think the confusion with that express concession is my view of it is I'm actually not sure how Florida works, but New York and California, for example, when it comes to justification is the type of thing in those states where if there's evidence on the record to support it, in New York and in California, there's the bench notes that the judge must give an instruction on justification. Even if it's not requested by the parties, that can be considered an error on appeal if the judge fails to sua sponte include this instruction on possible justification or excuse, even if the defense, their strategy in the case was not to rely on an affirmative defense. So in that context, I can see why there might be some concession language where, maybe you don't want that included at all because you're not explicitly, your theory isn't arguing justification. You're also kind of still arguing you didn't even do the thing you're being accused of, that the injury was caused by something else and not you. But if the jury does find that maybe it was caused by you, that it was inadvertent, it wasn't intentional, doesn't meet the other elements. And I think that's what that language is designed for. Those circumstances where the justification could come into play because it's supported by the record, but it's not the explicit affirmative defense of the party.
Right. And this thing that you sent me, the one where you were like, they made comments exactly like this, that's that SC 110.113.
Yeah, the attorney griping that this is confusing. That's kind of what I saw as a quick
I want
glance.
to see if I can find that case to see what they ended up doing.
Yeah, because that guy, it's like several pages of like, this is going to be confusing.
Yeah. Okay.
So.
About if the killing was either justifiable or excusable homicide, as I have previously instructed you, we agreed on taking out justifiable.
Agreed.
Over defense objection, I'm going to give the best in terms of the standard. The next paragraph, to convict of manslaughter, it is not necessary for the state to prove that George Pino had an intent to cause death, only to commit an act that was not merely negligent. I'm taking out justified or excusable, and I'm going to leave in, again, the standard or excusable and which caused death. Okay? Go to the next page, where there's a definition of culpable negligence.
Judge, so the paragraph you just read,
Yes.
which begins with to convict of manslaughter, that paragraph, at least under the old instructions, made clear that that is a reference to the subsection A theory.
Correct.
Okay, so we object to that for the same reasons we object to
Correct.
the 2A theory. So we
Correct.
think that entire paragraph beginning with to convict of manslaughter, it is not necessary for the state to prove that George Pino had an intent to cause death, only an intent to commit an act that was not merely negligent, et cetera, et cetera.
Correct.
We object to that entire paragraph.
All right, very good.
So they're not
Let's look
going under 2A at all. They're just going under C. The death was caused by the culpable negligence of defendant. And I mean,
Wait, I actually just missed that. So
so under
I,
the manslaughter charge.
the two theories.
So, but did she just say she's only going under the one? Because he said,
Let's run that back.
yeah.
Judge, so the paragraph you just read.
That paragraph, at least under the old instructions, made clear that that is a reference to the subsection A theory.
Correct.
Okay, so we object to that for the same reasons we object to
Correct.
the 2A theory. So we
Correct.
think that entire paragraph beginning with to convict of manslaughter, it is not necessary for the state to prove that George Pino had an intent to cause death, only an intent to commit an act that was not merely negligent, et cetera, et cetera.
Correct.
We object to that entire paragraph.
All right, very good. Let's look at the next one.
I think they just didn't
Now,
want to mismatch
What
languages.
the defense has requested is, do you have the defense?
Yes, Judge.
Okay. Requested that essentially I include what would be facts, or facts that the jury would have to find, in further impressing upon the jury that there has to be a showing of culpable negligence, not merely negligence. I think that's the way I read the paragraph you want to include. Correct?
That's correct.
Okay. All right. Any comment from the state?
Yes, Your Honor. The standard jury instruction does in fact define culpable negligence. The state's proposed instruction follows that standard instruction to the letter.
That's what I
And I
thought.
would also point out that in the Stevens versus State case at 787 Southern 2nd 747, 2001 Florida
Look at it.
Supreme Court case,
10.
it indicates that in order to be entitled to a special jury instruction, the defendant must prove the special instruction was supported by the evidence, that the standard instruction did not adequately cover the theory of defense, and that the special instruction was a correct statement of the law and not misleading or confusing. And I think for the defense, where they kind of fall down is that the instruction of what culpable negligence is, and the definition that it is given is a correct statement of the law, and I don't see that what the defense has added clarifies the law. I don't think that it's necessary based on the evidence, and if anything, I think it makes the instruction a lot more complicated than it needs to be.
So
Okay, but that's the rest of it after the definition of culpable negligence, right?
Yes.
The paragraph before that, where the defense is proposing that I tell the jury they must determine whether the state has proven beyond a reasonable doubt that Mr. Pino's act.
Judge, I'm going to withdraw that paragraph to
Okay.
avoid confusion. So we're withdrawing the paragraph that
Okay,
begins with the
let's
phrase
go
in this
then.
case.
Then it would be, there'd be a definition of culpable negligence, okay, which is the defense is proposing that I include the word merely negligence. On sentence 1,
I see it, Your Honor.
you see it, right?
Yes.
Merely, where,
Okay.
wait.
Any comment from the state?
Yes, I don't think that it's necessary because the standard instruction indicates that if there's a violation without any conscious intention to harm, that's negligence.
Right.
Culpable negligence.
No, hold on.
I don't think that
Including the word merely. Do you have any comment on that?
Yes, I object. There's no reason to inject that into a standard instruction when the standard instruction adequately informs the jury what the law is.
Okay. All right, I understand the request. I'm going to deny the request over objection. I take the word merely out because it's not part of the standard. I think the instruction correctly defines the law and
But he can still make these arguments in closing,
confused.
right?
Yeah, but I'm so confused about where this word she's taking the word merely merely out, but I don't see that in his like he just has the standard instruction there. Um and then asks for but it already says like I don't understand where this culpable negligence is a course of conduct showing reckless disregard for human life or for the safety. Why is he adding that? Culpable negligence, reckless disregard for or gross or for the safeties of persons exposed to its or such an entire want of care to raise presumption of conscious indifference to the consequences. All right, that's 8.9. So I don't get it if they're taking it out of 7.7 because they're at like there's a 7.7 instruction for culpable negligence, and then there's like a whole separate instruction for culpable negligence. And
You just read this one, right? The 8-9.
yeah, well, I'm reading it from his. Let me see what you're showing. Yeah. So, but 7.7 is what it says above that. So I don't know where she's talking about this merely degree of negligence of a gross and flagrant character, convincing reckless disregard, or where there is an entire. I don't know. It's like I don't. I
Oh, you're
can't.
saying that because the language is actually in this, why the prosecutor's saying that word isn't there and that we're going to take it out of the request over objection?
Well, the judge is saying we're going to take the word merely out because it's not supposed to be there
But
over
it
the
is.
over the prosecution's objection. But when they say that it is, I don't know if what they're doing is going from a lot of times what they'll do is go from the state's jury instructions. And that's what we use as like the form. So then you make your objections and changes based on what the state put out. So maybe that's
It's
what's
almost like
happening
jury
here.
deselection. We start
Right.
with the state's template of instructions and
Right.
have to
So
fight to change it.
I just wonder where the state snuck the word merely anyway. But all right, I guess let's just keep going. But he's got a lot of more here about speed and all of that. I guess she's going to get to that next.
again, I think that's for argument that the defense can make, but I'm going to instruct the jury consistent in this paragraph with what the standard is. All right, then we get to the negligent act or omission must have been committed with an utter disregard for the safety of another. Culpable negligence is consciously doing an act or following a course of conduct that the defendant knew or reasonably should have known was likely to cause death or great bodily injury. So you both agree on that. There's been no change there.
Agreed, Your Honor.
Then that would, now in terms of the standard, that's the conclusion of the standard. What the defense has asked, I guess as part of it would be a special instruction, would be additional language and additional definition. Okay?
No, 8.9 is in there. So what you talking about?
You're making a reference to 8.9.
Oh, but it
which
comes
is
under
proof of the
assault,
crime of
battery.
culpable negligence.
But then you get the
So
using the
I guess
weapon
the
thing in
question
there, which
is-
kind of makes it.
It looks like in for 784.05, which is the standard is 8.9, which is you're referencing.
It's for battery.
The
Whispering.
definition of culpable negligence seems to be a different, more expansive in the 8.9 instruction than 7.7 under manslaughter. Okay. So that's that first paragraph that you're asking in terms of the special instruction for me to include.
Judge, could you read the first sentence that you're referring to so I'm following along?
Okay, so you're asking me to include culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows, you know where I am now, right?
Yes.
Okay, and you're referring back to 784.05 under the standard instructions 8.9. All right, so let me ask the state.
What's up, y'all?
Came back loud.
I did. Let's
Your
see.
thoughts on that, which provides
Huh. I'm at 53. I don't know.
incorporates essentially 8.9 into 7.7, and under a different statute. So if you look at 784.05,
I'm gonna speed up the readings, but if she says a
this is the
statute,
culpable negligence, the second degree misdemeanor.
and do you want me to like catch the statute, let me know, Ali.
And culpable negligence is a lesser included offense, category 2 lesser included offense of manslaughter. So,
Judge, the reason why what I would suggest to the court is this. If the court looks at the instruction 7.7 for manslaughter,
yes,
at the bottom it says it was last amended on September 12th of 2025.
right,
If we look at the definition of culpable negligence under Florida statute 784.05, which is in 8.9,
yes,
it indicates that the last time it was amended was in 1985.
yes.
So I would submit to the court that the September 12th, 2025 instruction for manslaughter's culpable negligence definition is the proper one for the court to give.
Okay. I am going to give the 7.7. My question would be, though, when you look at under manslaughter, category 2 lesser.
Yes.
Okay. So category 2 lesser is culpable negligence.
They're charging
However,
that.
the non-homicide lesser included offenses are do not need to be given if the parties agree that causation is not in dispute and that the victim is dead. And that's from Carver v. State.
Do not have to be given, right, under Carver.
Oh. It just took off the privacy screen.
And it was last amended in September of 2025, right? As you said, the manslaughter stuff.
I think they're just looking at that 7-7 manslaughter one, or maybe that's a culpable negligence. I'm blind.
I guess the question is causation an issue?
Yes.
And whether the defense
Absolutely.
would be seeking culpable negligence as a category 2 lesser.
What?
I was gonna pause and ask you, but are you confused? Because to me, it's how it's charged. They're already charging manslaughter by culpable negligence. So
Yeah,
is
but
there
there's
a
a s-
difference for the
there's a different
manslaughter?
crime called culpable negligence, and it's a it's a misdemeanor. So whoever through culpable negligence exposes another to personal injury commits a misdemeanor of the second degree, punishable as provided in
Is that where they're pulling the definition? Like if you're
yes,
looking at Howard's
yes, it's
codes
under.
instruction,
So here, why don't you guys let me
is
share
that
let me
78?
share
Is
my
that
screen.
784.05?
I'm going to show you right now. I'll share my screen.
Yeah,
Okay.
that's what they're looking at right now. It
Do
looks
you have
like on
my
their
screen up?
Yeah.
Yep.
Okay, hold on. I'm going to go back. I'm looking at the statute now. So here is the jury instructions. Let's look at the table of contents. So you have this is instructions on crime. So they list the crimes. Homicide is 7, and that's where 7.7 is where you've got manslaughter and within there culpable negligence. But when you go back and you find this 8.9, it comes under a completely different crime and maybe a crime that they should be asking for. So it's under assault, battery, stalking, culpable negligence. So these are different crimes. And when you go to culpable negligence and it takes you to the statute, it's a misdemeanor.
What does it
So
read?
the statute says because I don't think a
Expose.
misdemeanor can do the extra 15. You know what I mean? So it would be this one. Whoever through culpable negligence inflicts actual personal injury on another commits a misdemeanor of the first degree. Let's just make sure there's not one that says causes the death.
See, but that's
But
got
would this be
that's
that the
got
death
mens
was
rea. That's got intent there. This particular this has intent, whereas the
No, the
man.
definition is sort of similar. Let me just see what the punishment is. 775.02.
Well, for one, where it says through culpable negligence exposes somebody.
See, look, except as provided in paragraph B, a person who has been convicted of a capital felony. What are we talking about? We're talking about
Eh,
where's
eh.
I don't know why misdemeanor in the so it's not a misdemeanor of the first degree, not to exceed a year. So, I mean, maybe they should be asking for this lesser included, but I don't know if it applies if the victim's dead. A person who actually killed.
could it apply if there's a theory that her cause of death was not from the culpable negligence? He caused culpable negligence that caused the injury, but like, is there a way to say that you can distance the steps in time and place
Yeah.
reasonably? Like she gets unconscious on the boat, but it was the boat sinking that caused it, and they don't find him more than culpably negligent for causing the injury. They think the death itself was an accident because it's happen chance that you get knocked unconscious while you're on a boat that's submerging.
Well, see, my whole thing with this case is that I think there's no question, and they're trying to build it in through his familiarity with the area and having ridden through that channel or boated through that channel on many occasions, that he somehow knows exactly where that channel is, even without seeing it. That's what they're implying, that because he's done it so many times that, and we're assuming he saw channel marker 13, 13A, that he knows he has a feeling, a spidey sense that he knows where that thing is, because under no set of circumstances have they been able to prove that he changed course knowing that he was heading towards that channel marker. Like, that's why it moves it out of, that's why they're trying to use all the other shit. Oh, well, there was 1,000 pounds of, precious cargo on the front of the boat. Oh, you were supplying the girls with booze, like all that other shit makes no difference to me in the sense that they needed to prove to me that he was aware that the channel marker was there, and with an utter disregard decided to I'm just gonna cut into the flats because that's where I'm going anyway. And he took the shot and he missed and he grazed the channel marker, which upended the boat and ended up impaling the boat and tearing through the side of it. Like, that's where I'm at with this case. Like, there has to be him having knowledge that the marker was there and making a decision that, I'm gonna cut in. I'm gonna cut in before we hit that marker. I'm just gonna swing in there. And they just haven't proven that to me. If he's not aware
Well,
for
and you
whatever
might have missed
reason.
it, but they're permitted to argue like two different theories where they don't need to prove that. And the defense renewed their motion for a JOA on the first theory of the intentional steering at the channel marker,
Right.
and
So,
it was denied.
but
So
even, yeah, I heard that. So even with the second one though, like, the reality is they still, in my mind, if I'm a juror, they still need to be proving that he was aware that it was there. And that it was just a wanton disregard, that it at that point, then I begin my analysis as to whether or not he was culpably negligent. As long as he knew that it was there, like beyond a frame of reference that the thing exists in the world based on other occasions of being out there. That he saw it in his path and he made a choice to try to just slip in before he got to it and he miscalculated it. I mean, like, this is an accident if I've ever seen an accident. Like, there's just, it's like you misjudge shit sometimes. If he did see it, if he didn't see it, that's not culpable negligence. Like, the fact of the matter that there were 11 girls on the boat makes no difference to me. That boat, that's within the capacity of that boat. The speed that he was going is normal for regular boaters. Like, there was nothing
So
crazy about the speed.
here's what I want to say. What they are alleging here, because the um like the culpable negligence definition in the crime of culpable negligence does not include the requirement that the conduct be of the type likely to cause death or bodily harm. Okay, so and
the
that's what
causation issue.
right, that's what, if we share this tab instead, in the standard 7.7 manslaughter one, it says right here. He engaged in an act of course of conduct that the defendant knew or reasonably should have known was likely to cause death or great bodily injury. That is an element that the state must prove. In regular old culpable negligence, this one, you just have to show that you engaged in conduct showing a reckless disregard for human life or for the safety of persons exposed to its dangerous effects, and it being indifference to the consequences. It is a lower standard. They should only, what they like here is this part, that it shows indifference to the rights of others is equivalent to an intentional violation of such rights.
Indifference and
But
intent.
what was reckless about what he was doing, other than the fact that he happened to
My
hit that piece of metal that was
Well,
sticking out of the
aside from
water?
arguing like the theories and facts of the case, the question right now in the jury instruction conference is
Are
Look,
you asking for a lesser included?
yes, are you going to ask for a lesser included? I think it's going to be, if you allow us to use the language we're requesting, we would like this lesser
Oh, yeah,
included.
if they are right, if it the
What
only
is the
reason to
lesser
request a
included?
lesser included would be to get this jury instruction in,
What
but
is the
it's
lesser included?
I
This
just
this
told you
thing?
it's regular culpable negligence where instead of like here, you're following a course of conduct that you know was likely to cause death or serious bodily injury. I don't know if me highlighting it here, if you can see what my mouse is doing or not. And then this is from the 8.9, and they only need wanton and recklessness that shows a disregard for the safety and welfare of the public. But what they like, I think the defense likes about it, is it requires that it says it is the equivalent to an intentional violation of such rights. But they should be asking for it as a lesser included because then it's a misdemeanor. Unless I'm missing something that would apply, it looks like that would be a misdemeanor, and they wouldn't be it would be a year, and that would be it.
Well, he could get up to a year,
Up
right?
to a year, right.
Yeah.
I mean,
And
no
it's not
judge
a
in the world.
felony. You don't have a
It's
felony
not a
on your record.
felony, they can't up it, but to ask for the defense to just ask for this language in addition to the manslaughter language is
Without
ridiculous
asking for the
because
lesser included.
right, because it's a
Yeah.
lower the state does not the state that would mean the state does not have to prove that it was, you were ignoring a known risk of actual death, you know?
Yeah. Well, I mean, so the issue, I think the confusion is the judge is not getting the distinction that, or maybe she's not clear that what the defense is asking for,
I
right?
think
Because it was,
she's saying, "Are you?" Because it doesn't. This does not make it clear that the defense is asking for a lesser included of culpable negligence
yeah, because
under
she
this
brought it up. She said,
7-8.
are you also requesting 8-9? Because she started by saying, is causation an issue here? And she wanted both parties to answer, and then looked at the defense and said, because are you requesting 8-9? And that's
Right,
where we started.
and I think causation is an issue because the prosecution's trying to throw every piece of so-called negligent behavior, like letting the kids drink and having expired thingamajigs that have no causation. They're not causally connected to the
And what
injury
you did after.
and all of that, right, what he did after. Um, but this should be, definitely should be a lesser included. Um,
I think I would want it. If my exposure is 30 years and I have a fear that the jury might want to split the baby if they feel like, hey, it's not an accident, but he should have done something better.
See, like
I would
even
love for them to have this choice.
this case here, this is a Florida case from 2018. They're talking about that the um culpable negligence of another because the end result of manslaughter is the death of a human being. Culpable negligence is of the type involved in a manslaughter case by definition involves conduct likely to cause death or bodily harm. But the statutory element of death under the manslaughter statute exists separately from the additional element of culpable negligence, which speaks to the state of mind underlying the defense's conduct. Thus, it does not follow that culpable negligence involved in prosecution for a felony that requires death of a person must be identical to culpable negligence involved in a prosecution of a second degree misdemeanor that only requires exposure to personal injury. On the contrary, the jury instructions for the two offenses demonstrate culpable negligence in the manslaughter instruction requires the jury to find that the defendant knew or should have known his conduct was likely to cause death or great bodily injury, while the instruction for the culpable negligence offense contains no such requirement. So if
Would
this
you argue if under the knew or should have known, um, that he has to be aware that he's coming up on that marker? As opposed to relying on past knowledge from, you know what I'm that's where I keep getting stuck on this case is that, and I understand, Kat, what you're saying, but
I
the
think it
fact
requires
still
he knew
remains.
or should have known he was going to allied with it,
Right, but that's
not
making my
just that it was
point.
there.
That
Right.
but that makes my point exactly. That
Right.
that that means that he saw it, that he's aware that at some point in that before prior to that 9 seconds
Was
taking
he aware
place,
of where he
that he
was?
sees
Like,
it.
But he can be
not the
aware,
marker,
right, he
his
can be
position relative to marker.
right, he can be aware that I'm in the
Exists in the
vicinity,
world.
right,
Right.
but not be aware that he's on a path of an elision path with
That's
it.
what I'm saying.
Right.
Like we're all saying the same thing. In this particular circumstance, they're relying on his knowledge of the area and imputing that he had to have known that that marker was there on that day at that time because of his prior knowledge without having to prove that he actually saw it
Right, and
and
knew where he
consciously
was
made the decision
to
to
head
cut it
towards.
close to it and get into the flats.
Right.
Like, I mean, that's where my whole problem with this thing is that for whatever reason, and we'll never know now because George didn't testify, and George may not remember, frankly, as to what caused the distraction, that he didn't see it at that point until it was too late. You know, he sees it at like the 3-second mark and you know, and tries to change course as much as he
Well,
can. I don't
you're not
care what the GPS is showing because if it's a very short, quick, you know, just veering a little bit at the last second, I don't necessarily know that the GPS is going to pick it up like that anyway. So, like in terms of a course correction, but you know, I mean, clearly, and unless he was just like it hit exactly where he was heading, and he just never saw it. You know what I mean? Which I assume is possible as well. You know, if he just never caught sight of it and it was too late. You know, the problem is I would have liked to have seen a demonstrative that had the exact dimensions of George's boat at the time, the exact time of the evening that it was. So we were at the exact wherever the tide level was. So we
with the
could see
sun.
where that marker is on the boat. Like it's like such a it's like a weird mystery that was never really addressed in a trial that's all about hitting that marker. Like
And the sun glare, because I felt like I was in like I felt like my guess of like, well, that sun glare looks really bright when they're doing the rescue in the body cam.
yeah, we
But
both
what
said that,
position were the
right?
things? And the state was asking questions of witnesses to dismiss and disconnect any possibility of a sun glare coming into play. And then we find out when Howard's doing some questioning when they recalled Paul Albert that George Pino was actually traveling in a southwest direction, which means sun would be setting at that point in time. So unlike what Laura Adams was trying to establish, that he wouldn't have been traveling in the direction of the sunset, that's untrue.
That's a huge thing, and I hope Howard hammers that in closing. You know, I mean, in closing arguments, like why, Cat, explain to me why doesn't there not exist one defense photograph of where the sun is? Like, why don't we have any kind of proof of what it looked like that night when they go out with their own expert and they take photographs from the same location at the same time of evening so that we have an idea of what it actually looked like that night? Like, we should not be having to guess what the sun coming off the water
I
looked like.
hope he pulls a frame from the rescue video and just shows the way that that one boat, you could see like one boat, but it was hard to distinguish that there were actually three boats in the picture because it all just blurred together with the sun glare until you really looked at it.
Yeah, I
And
mean,
those are big objects. Those are big objects. And granted, that was about an hour after the elision actually occurred. But
I
still,
hear
you
you. I
still,
mean, as a fallback, but my question still remains, like,
with on the record with like explicit
why didn't
questions,
right, why didn't they get somebody to go out there and
or
at the
just ask
exact time?
Bruto. Ask Bruto. There's a lot of sun in this picture, right?
Yeah, right. Pretty glary,
Yeah, super glary, would you say?
super glary.
All right. Ali, thank you again for doing super research here, law librarian.
I mean, I'm
Uh,
anxious to see what they decide. The only reason, I mean, just like you said, Kate, Kat, if it was me, I would say, look, if we ask for this other definition, there's a damn good chance they'll find that you committed this offense. I mean, shit, he committed that offense as to the kid whose father testified at the end that she was, injured. But there's a risk that they're gonna find you committed the manslaughter and you get 30 years. And this way, if they do think it, at least you're only getting 1 year, you know?
I'm inclined
Because
to agree.
God forbid they think that he was acting with gross, flagrant, and reckless disregard for the safety of others, then you've got 2 choices. Did he know or have reason to know it was likely going to cause death? Or did he just know he was or did he just have reason to know that he was
Joe.
exposing people to serious, personal injury? And that I think is much
Yeah, but I'm on a YouTube live right
and
now.
we can, and you're talking to us too.
I'll mute
I
him.
was gonna mute him for him. So let's see what he says here on the lesser included.
So I think that's the question for the defense. I'm gonna give the standard 7.7. I'm not going to, that first paragraph at least, I'm not going to give that as part of a special instruction to 7.7. The
But
question's gonna be whether or not the defense believes it's appropriate for me to give a category 2 lesser of culpable negligence,
yep.
but with the caveat that,
Mhm.
oh, but that's a non-homicide lesser.
Doesn't matter.
And so we have a homicide, so it's not applicable.
Wait,
just-
I
Kind of talked in a circle, but since this is homicide,
I don't think that's agreeable because remember what I was saying earlier? Couldn't you find that the death itself wasn't part of what you think George Pino did? Like a reasonable juror could say like we don't blame him necessarily for thinking that there's this manslaughter, there's this death, but we could find that the crash itself, we think that there was culpable negligence for the crash. Which I know
Right.
kind of seems counterintuitive, but if you think it through, you can come up with ways to think that. So is it a permissible or not a
I
lesser
don't know.
included?
I was actually researching that precise
While we were
thing, like when
talking?
she said it. Yeah, but I was starting to think that it didn't look like there was anything in the statute that prevented that charge when there was a death. Um, but I gotta see if um but the
Or maybe
first case that I'm coming up on was the case where they were trying to use that definition in a regular culpable negligence case. And they were like, that's not the definition in a regular culpable negligence case, but it doesn't look like the victim died. Um,
we'll see, maybe they'll bring it up.
the lesser doesn't apply.
I understand the principle. This is where it gets back to the issue if the state is focusing on acts which did not cause that did not cause the death. Our view is it's the elision, not these other,
yep.
like speed, for example. They're claiming speed, that he accelerated. That's the culpably negligent act. And absent the elision, there's no death. So that's the rub. I also recall that culpable negligence, I think, is a lesser included offense, that misdemeanor is a lesser included offense of vessel homicide.
Well, we'll get to that when we get to vessel homicide. Okay. So, over objection, I'm not going to give a special on paragraph 1 in the defense request. And then there is additional explanation that you cite to the Jackson case from 1958, and also to, oh, it's the same, okay. Definition of the speed, it's about the operator drinking or to some degree under the influence. It's not proof in and of itself of culpable negligence. And the state must prove under Miller, 1954 case, that the act was not the result of a momentary lapse of memory, inattention, or mistake of judgment. Okay. All right, any response from the state?
Yes, Judge, I don't believe that those should be given.
All right. Beyond the fact that I do believe that the standard instructions are a correct statement of the law, I don't think it's appropriate, and I'm not going to give the additional language and case law citation in the jury instructions. I think that could be part of argument, if you wish to use that as part of argument, but in terms of the instructions are sufficient to define culpable negligence. So I'm not gonna give what's been requested.
To make sure that I've adequately explained, we weren't expecting you would put the case citations in the jury instructions.
No, I know that. You put the citations to support the additional explanatory language of what culpable negligence is, what it isn't, and to further enhance, I think that's the position of the defense, that the instruction given, the standard instruction is not sufficient.
That's right. I just wanted to make sure you knew where we sourced the language. So our
Of
request
course.
would be over, I understand you overruled it, that each sentence that we have submitted for as a proposed instruction be given to the jury individually and in combination or in combination with the other sentences. If there's any one sentence you think would be acceptable, we'll take it. But it sounds to me like the court is not going to give any one sentence or the combination of sentences. And so I think we've adequately preserved the objection.
Yes.
Understanding we weren't asking you to give the jury the actual case.
No, I understood that was for me to know where the language comes from.
Thank you, Judge.
And appreciate that. The standard instructions, in fact, the state had noted, but they hadn't been amended as recently as September 12th, 2025. So,
Actually, Judge, I believe they were just amended 6 days ago on June 12th.
I'm sorry, I don't hear you.
6 days ago.
This client is saying that it appears on our computer that while we've been in trial, the rules,
June 12th. The
the
proposed
instructions have been amended yet again.
Hey,
That's the
oh,
reasonable doubt instruction. The reasonable
Which
doubt
one?
instruction was,
all of them.
yeah,
Almost every standard instruction that I'm downloading today
Uh-huh.
has been amended on June 12th, 2026, so last
let me
week.
see what I'm looking
okay,
at.
so why don't you print out, because the only one that I have, that we got a copy of, is a reasonable doubt instruction with any substantive amendments that would impact our case. Is the reasonable doubt instruction, I have that as the updated instruction. I'm not sure if that was in your packet or not.
I think so.
Yeah, we have that. Thank you on that. But there were no amendments to manslaughter instruction or the other instructions. Okay. All right, so I took care of that in terms of the manslaughter instruction. Let's go ahead to the vehicular homicide instruction, okay?
No, mine are only good through June
Oh,
1st.
excuse me, not vehicular. Vessel homicide, excuse me. All right.
And remember, the defense wanted to start here because this is where there is going to be a culpable negligence, lesser included misdemeanor, it seems like. And they thought it would be more intuitive to start with this and then work up to
Judge.
the
Sir?
manslaughter
So that
discussion.
we're not confused. We understand that the instructions that we provided to the court were standard proposed instruction,
Correct.
came from the pattern instruction
8.9.
8.9 regarding culpable negligence.
Yes, it's, 7.7A.
It's not clear to
was
us when it was
amended.
amended. We think it was amended recently, but in any event, you have the benefit of the language that we took from what was at least at some point in time the pattern instruction. And over our objection, the court is going to do.
Well, yes, a different subsection, which was 8.9. I would say. Okay. And Ms. Pino was not charged with culpable negligence. And that goes back to what I said, that it would be considered a second.
It says right here in the updated ones. So now this is for 7.7A,
Wait,
which
are you
is,
sharing? You have
oh,
one?
yeah, let me just see. Why doesn't it? Okay. All right, so this is aggravated manslaughter. So it's obviously higher than regular manslaughter. Category 1 manslaughter, non-homicide lessers with an asterisk. Non-homicide lesser included offenses do not have to be given if the parties agree causation is not in dispute and the victim is dead. So this doesn't seem to say that it can't be, oh, right here. Boom, 8.9, lesser included. If it's a lesser included of aggravated manslaughter, it's a lesser included of this one. I want to see what
Manslaughter, yeah.
7.7A says right now. 7.7A, aggravated manslaughter. Oh, I don't know if there will be like a chart for lesser includeds anyway. Oh, yeah, it is. So, and it's already in there as a lesser included. Literally says lesser wait, am I share this tab instead? It's same thing it says there. Lesser included offenses, non-homicide lesser included do not have to be given. There is no statutory requirement that the defendant have knowledge. No, this instruction was adopted in 2017 and amended on September 20. So this might be a new amendment on September 12th, 2025, because there's not this little chart for 7.7 regular, but 7.7A is basically a continuation of, you know, 7.7 culpable negligence inflicting harm, 78405.2. Where do I have it open already?
Back on here. Hey, Bob.
So, babe, is he back?
Yes. Well, sort of.
And both of them are here. Culpable negligence, inflicting injury, culpable negligence, exposing someone to injury. Lesser included offenses.
Well, good eye by the attorney at the defense table.
I
And
mean,
of course, we have these updates right in the middle of trial.
but this was here already. This one shows that it has not, this is current amendments through June 1st. And in the amendment, I don't know what the difference is, where I don't know what the difference, like, the difference is probably somewhere, like, way up. Oh, share this tab instead. Now I'm going back to the update, it's probably something, like, way up here that has nothing to do with, you know, in the absence of an express concession that homicide was not excusable or justified, the trial must also read 7.1. They took that out in the absence of an express concession that homicide was not, the judge must also read. So does that mean the judge must also read it now? But they didn't change 7.7. So, which is kind of, see, this goes to show how they do shit that's weird, you know?
Yeah.
Like
So, like, if
if
we ended
they
up
just
using something that was a lesser here, could there then be the concession language coming back in just for the purpose of that
right, if he's like,
count?
"Hey, look at the chart over here you know, for
7.7A
lessers."
verse
Right.
8.9.
And if it's, I mean, either way, if it's a lesser included of aggravated manslaughter, it's a lesser included of manslaughter, period. So I don't know why she was saying it has to be, you know, why that it's a non-homicide lesser. Um, so it's not available, but it is. I guess maybe we have to figure out what's required in order for it to be, um, because I saw non,
Where are they at in the courtroom? Like, are they still bickering about this?
They just got to, well, they were about to start with vessel homicide, but then right before they started discussing vessel homicide, one of the defense attorneys pointed out that there were a bunch of amendments to the same things that they're relying on the standards for. There's been amendments from June 12th. So within the last few days, the last week. So they're saying like, hey, we provided this stuff before I
and she
think, right?
said none of
She's
the,
saying we provided it before the 12.
right, and the judge is saying none of the amendments matter here, and here's what the amendments are. So they're not, aggravated manslaughter was changed, and BUI manslaughter, be interesting to see,
The
uh,
includeds could
yeah,
change. It could be
what that is. Let's just check that. So what is that? 7.8A.
All right, I'll keep listening. I gotta go back to get scout.
What? You just got back.
The camp is from 2 to 3:30. I mean, it is what it is.
Maybe it doesn't say it down there. BUI. Why isn't it moving? Why isn't it? All right. I don't get it.
bad interface.
It's weird. All right, so this is 7.8, driving under the influence.
There you go.
Yep.
That
All
was
right.
boating.
Oh, so this is boating?
Yeah, it starts in a weird page
Right.
break.
To prove boating, the state must prove. Okay. The defendant operated while operating. Give A or B or both. Was under the influence to the extent that his normal faculties were impaired. Had a blood alcohol level of, I think that that's the
That
same.
wouldn't apply
Right.
because we did test.
So this is the conduct of the victim is a defense to this crime only when the conduct was the sole cause of the crash. Okay, so that is something new that doesn't apply. Doesn't look like there's any other changes here to that.
Yes, I don't think they could include this because it wasn't.
No, but I was just wondering if there were changes in 7.8 that would like have some, like you'd be like, look, they even changed it to say this, so makes it
To
even
correct the
more
intention.
right. Focuses on the men's matter and the death was inflicted in immediate circumstances where the victim experiences the tortious anxiety of fear. Okay. All right, let's go back and see what they say. But I think we need to go back to getting these people's email about the lesser includeds.
Category 2 lesser, but that's for non-homicide. So I don't see that it's applicable here. Okay, so let's go ahead and look at vessel homicide. All right. All right, who's upon a vessel homicide, which is 7.9.
So with vessel homicide, this will be a bit simpler because we did not propose any changes to the pattern, but we have proposed supplemental instruction.
Right, which I would consider as requested for special instruction. So the question is going to be back to whether the standard instruction sufficiently defines, is sufficient in its language and correct, and the standard adequately conveys the theory of defense. So let's go ahead and look at it. I don't think you were proposing that I include a citation to the Lizardo case.
Correct.
You just put that in there for my information.
It happens to be in the pattern itself, like
Yeah,
coincidence.
no, it is.
I don't think the jury's ever heard of the case, so I don't think it matters.
All right, so let's state, why don't you pull up, please, if you would, the defense request after the definition of operate. There's a request for, let's see, there's about 2 pages of special instruction.
Well, I think they're great defense arguments, but I don't think that they should be given under the Stevens case because the actual standard definition is very clear about what recklessness is. Reckless requires the state to prove more than a failure to use ordinary care. It means in a willful or wanton disregard for the safety of persons or property, and then both willful and wanton are defined.
He's talking about the definition of
And it
operate.
just seems to me that what the defense has done is just taken a lot of different ways to try to, I don't know, put into jury instructions things which should be arguments. What should be the jury instructions is what adheres to the actual statutory definition. The way that case law has been decided or the way that judges have written certain appellate opinions does not transform those into instructions that should be given.
Okay.
Is she saying there's no such thing as a special instruction ever?
Do you have anything you want to tell me? I mean, I've read, you further define in terms of argument also, citing to an 11th Circuit case and Black's Law Dictionary what reckless means. And then the next paragraph, it's, a request, I guess, in instructing the jury for me to elaborate on what the jurors' responsibilities are. You have anything you want to say about either of those paragraphs?
Nothing additional.
Okay, all right. I'm going to decline to include the special request, but they are included as part of the record in your special requested instruction. You should have a clean copy and include that in part of the record.
So today we will file one of the emails to you so that everybody's operating under the same paper.
And then on Monday morning, just make a reminder that, just for purposes of the record, that your requested instructions are documented and included in the record, but they're not anything for the jury.
Understood.
Okay. Let's go to the next page, if you would, where there's further request for the court to further define what is sufficient for the state to be able to sustain a conviction for vessel homicide. Again, that first paragraph, I see this as, and again, you're giving me the citations to cases, it wouldn't be part of the request, but further explanation in the instructions, and I am going to find that the instructions given as the standard instructions are sufficient and sufficiently defined, what elements the jury would have to find for them to come to a conclusion that Mr. Pino was guilty of vessel homicide. And a lot of this I find to be argument, and certainly you can make these arguments, but I'm going to decline to give that as well, and we'll include that as part of the your special requested instructions.
May I turn the court's attention to just a couple more that are in here that I'd like the court to give additional attention to.
Sure.
So you just reviewed the page that begins with the sentence, neither carelessness nor ordinary negligence.
Correct.
That cites to Lizardo, it cites to Warehan, W-E-R-H-A-N, and it cites to Esposito. I understand the court's overruled our request. Then the next one I'd like the court to look at with additional attention is the citation is Strackar versus State, where it reads, the state must prove that George Pino, quote, in an intentional, knowing, and purposeful manner was operating the vessel at the time of the incident in a manner demonstrating a conscious and intentional indifference to consequences, and with knowledge that damage is likely to be done to persons or property. I'd also like the court to consider the instruction that we took from Santisteban versus State, S-A-N-T-I-S-T-E-B-A-N. And this one says, speed alone does not constitute reckless conduct unless the speed is shown to be grossly excessive. Let me stop there, Judge, because that's an important issue for this case, since the state is focusing on speed and there is no speed limit posted. We would argue that it creates a bit of a vagueness problem, not a bit, a serious vagueness problem for the operator of the vessel, because speed now becomes at the discretion of the law enforcement officer or the prosecutor handling the case as to what they personally think the speed limit should be under a particular condition. And the jury needs to know it's not even enough that the speed might be deemed excessive. Under those cases, it has to be grossly excessive.
Well, let me ask you, sorry to interrupt. How you, doesn't it depend again on the circumstances of what could be a grossly excessive speed under the circumstances?
Yeah.
Because a speed of 20 miles per hour under certain conditions could be considered grossly excessive under those circumstances. A speed of 80 miles an hour under the totality of the circumstances may not be considered grossly excessive. Does that make sense for
I agree with you. That's why the jury needs to know speed has to be not just excessive, it has to be grossly
No, but
excessive.
I'm still using the word grossly. It could be grossly at 30 miles an hour, depending on the circumstances, the additional circumstances. I mean,
That's
would
fine.
you agree with
can-
that?
If you feel that it would be helpful to add that speed alone does not constitute reckless conduct unless the speed is shown to be grossly excessive under the circumstances,
Yeah.
I'm okay with that.
Okay, I'm not inclined to do that.
Oh.
I just brought it up for, our discussion.
Right, and the reason I'm addressing it is because the state is arguing the speed was excessive. The rule that was presented to the jury, the safe speed rule, implies that there is a particular threshold for safe speed, above
the
which a
navigational
speed would
rule.
be excessive. And yet that's still not enough to convict under the case law. It would have to be grossly excessive.
Okay.
And the jury needs to know
I think this is
excessive
critical.
speed alone is not enough. It's got to be grossly excessive. And because there is no posted speed limit or any legislative finding on what is an appropriate speed, we're now turning this over to 6 people to decide what an appropriate speed would have been. But they need to know it's not enough that it's an inappropriate speed. It needs to be grossly excessive. Lizardo was the case where the driver was doing 83.9 miles down, I think, Cayojo, and that didn't give the driver enough time to avoid colliding with a car. And the court said even that speed, which was, I forget, 30-something miles above the speed limit, did not support a finding of vehicular homicide. So that's why we need to make sure the jury understands the speed by law needs to be grossly excessive to support a conviction.
Do you have anything you want to respond to?
Of course, I object to that. I don't think that that is a proper statement of the law because, first off, Luzardo just said on these particular facts, and there weren't many facts other than there was only the speeding. We have a lot more than that here. And beyond that,
None
the
that matter.
definitions of wanton and willful more than sufficiently cover the concepts that defense counsel is trying to somehow, have this court instruct the jury. The jury
I
is
don't
the one
think
that's
that-
supposed to decide.
And I'm going to decline the request, to look at, speed, the weather conditions, this, that, the other thing. I don't think it's appropriate for me to include that as part of what will be the standard instructions. I think the instructions is given properly define what the law is, and this is part of argument. So while I understand why you're requesting it, I'm going to decline to give that. And also there's something about, I think the next paragraph as well.
So the next,
Alcohol.
the next paragraph, we just took a direct quote from a case. What we would like is either just an instruction that consumption of alcohol, absent impairment, does not constitute recklessness or culpable negligence. That's what we're requesting. Because obviously the state is presenting evidence of the 2 beers, and I assume they'll be arguing that that somehow is relevant to the analysis of recklessness and or culpable negligence. I think the jury is entitled to know that the courts of appeals, they don't need to know it came from there, but that the law allows alcohol to be consumed, and that the mere consumption of the alcohol, absent some impairment, does not establish recklessness or culpable negligence.
Okay.
So, Ali, is she not giving the speed alone does not constitute reckless conduct unless the speed is shown to be grossly excessive for the circumstances? She wanted to add the circumstances phrase, but she's actually not giving any of that at all, right?
It's what it sounded like. I'm not sure why she would not.
I have a problem with this because this is like an instruction about mere presence is not enough. To me, this is the same type of clarifying point that you would need to give to a jury, especially when one of the state's theories is that, the combination of factors, the totality of these factors. I think you need an instruction that speed alone is not enough. The presence of whatever is not enough.
Right, but
And
they also
I don't
have
see anything in the standard that necessarily clarifies that.
right. He also wants the one that, drinking is not enough. So the question becomes, does the 2 of them combine matter? If the drinking is a non-issue, does it even stack on top of the speeding?
Yeah, and maybe to a fault it would hurt if you give these explicit instructions, then you get the jury just go, well, if speed's not enough and that's not enough, but we think both are there, then we're there.
Right.
But I don't know. The reason I'm so focused on the speed one is because there was opinion testimony with this conclusion that something was violated with the speed, that this was unnecessary. It wasn't a reasonable speed to be going, and it was thus a violation of these navigational rules that I'm not sure if the judge is going to grant the state's request to include special instructions that they want for these navigational rules about the speed, but I kind of have a feeling we might get some. So if that ends up being granted and this is being denied, I think that's a huge problem.
For sure.
And then look at his face here. That's how I feel. Like, 'cause I just feel like that's what's going to end up happening.
Anything to respond to?
I would object.
Okay. I'm going to decline to give the special requested instruction, but again, it's included as part of the record. Okay. And I think that would, looking at simple inattentiveness, citing to the Esposito case, I think that was your next request.
That's right. So, you know, inattentiveness is insufficient to establish reckless driving. That's what we're asking for. That is what we believe the state is going to argue caused the accident. Mr. Pino was not paying attention in those last 9 seconds as the vessel was approaching and then ultimately collided with the marker. And just as a small footnote, we were talking earlier, you were asking about how the boat, with 9 seconds to impact, made that veer southbound. 9 seconds later, there was the impact. But roughly 1 second before impact, there was another, apparently, data point drop. I believe the expert, Mr. Albert, said that there was some effort to, there was a change of course, that apparently the inference would be that Mr. Pino, with a second to go, realized the marker was there, tried to take evasive action, and was unable to avoid the marker. That's what I understood him to say.
Okay.
And so it's clear to me that the state's theory is that Mr. Pino was inattentive in the last 9 seconds. And the case law seems to be clear that lack of attention in and of itself is not sufficient to establish recklessness, much less culpable negligence. And so we'd like the court to instruct on that. It comes right from the case law. And so we would ask the court to give an instruction.
Okay. Do you have any comments on that?
Yes, Judge, I think it's a great argument for counsel to make, but it's not the law that the court should be giving.
Judge, may I ask this? Isn't that what courts of appeals do? They write the law as it applies under facts similar to those that are before the trial courts. And so we know from all the cases with Doral onward, many courts have said speed alone, unless it's grossly excessive, doesn't support recklessness or gross negligence. Alcohol consumption alone, absent impairment, does not support recklessness or culpable negligence. Mere inattentiveness does not support recklessness or culpable negligence. Those are principles of law. That's what the court is supposed to explain to the jury. How otherwise will they understand what to look for in the evidence, if not by instructing them that the law says those matters of evidence that have been presented to them under the law do not suffice. If you don't tell them that, they're leaving it to lawyers to tell them that. But the courts of appeals have said that when lawyers have tried to argue that, it's led to wrongful convictions. So I'm asking you to instruct the jury to avoid a wrongful conviction, as was the case in these 14 cases plus that we have cited to the court.
Understanding absolutely what your point is, and a number of the cases that were cited go back for many years, right?
That's right.
And so, staying in my lane, I'm not going to include language from beyond the standard instructions for further definition, because that's a different branch of government that's responsible for making those changes. And so in these cases, whatever
Well,
efforts
talking
are
about
made, we see
legislation.
amendments all the time. I think these issues, again, they're a good argument, and I suspect these are the arguments you're going to make, but I believe that the instructions as they exist sufficiently define what the law is, and those changes should be made, if they should be made at all, not by me.
So,
But I understand your point.
and I appreciate it.
Why did she veer to talking about the legislation? Really what she's saying here is, I'll let the Court of Appeals deal with it, as judges often seem to do. I will kick the can down the road. But why is she talking about legislation when he was clearly talking about case law?
I mean, she's just she's doing I don't know why she's like understanding or claiming to understand the issues, but then like just sidestepping them and making like various excuses. It I mean, but I guess she's just going back to the statute because that's what the case law is interpreting, you know? and that they could have
But it's
put it
almost
in
like
the statute.
the state's position is that case law never matters, and the judge is adopting the state's position without. I really, maybe this is just my stance, but I feel like this is a case where the judge is just going to accept. Again, we're starting with the state's template for these jury instructions. We're going to modify them as we might find necessary. We haven't found any modifications necessary, except taking a word out that seemed to have helped the defense. The word merely negligent is not enough.
Right.
And now it's like, well, I'm gonna, just like the state was pointing out earlier, it's not in the pattern instruction, it shouldn't be included. But that's not true. You can have special jury instructions. You, state, are asking for special jury instructions. So when it's the defense's time at bat to argue for their special and jury instructions, for your position to be, well, it's not in the legislation, so it just shouldn't be, it's just so
Right.
disingenuous. And the judge is adopting that here. That's what I'm hearing from the judge.
Well, we have all their email addresses, so we're gonna have to think about what we want to send them. They're all in this pleading that you gave me.
Just me screaming.
We're willing to have the dialogue. This is why in the 11th Circuit they had to change the instruction because the standard was inadequate to inform the jury of the law. That's why I believe there were 14 wrongful convictions, because the then instructions were insufficient to guide the jury. Jury instructions come from case law. That's where whoever writes those instructions, they get them from the judges who have ruled on cases.
Sure, and they change, and things change constantly.
And let me reveal my ignorance. Who actually writes the state jury instructions, if I may ask? Is it
Well,
Whitbread?
actually,
Committees that are designated by the Florida Supreme Court, they promulgate the rules and then the court adopts them.
So it is the judicial branch after
Well, it's
all.
not actually now. Actually, the Florida Bar, the Florida Supreme Court.
But they're adopted by a court. They're ultimately adopted by the Supreme Court. He's saying who promulgates them, because she's trying to, like you just said, go back to statutes. And he's saying, so this is the judiciary because these amendments get adopted by the Supreme Court. So like what we're looking at right now, the proposed amendments, the Supreme Court Committee on Standard Jury Instructions in Criminal Cases submits the following new and amended instructions for comment. Okay, so they may use the Bar Association to help, but at the end of the day, the Supreme Court Committee, amends them, and then the Supreme Court adopts them. So it says the committee invites all interested persons to comment on the proposals and it goes to the Florida Bar. But at the end of the day, and I think they'll get into it, it's still the court that adopts these.
Yeah, but if you acknowledge that it's the judiciary, then we go back to the whole thing where the judge earlier didn't want to, and the state was emphasizing, the state is like statutory language, the legislation this entire time. You must give this instruction. I'm going to act like 7-7 doesn't exist. And the judge is like, I have to give the whole thing. Oh, wait, later I'm going to use discretion and not do the justification. And then I'm going to ignore that my stance earlier was that the legislation required me to. And I'm somehow going to selectively apply that to justification, but not the excusable homicide, until finally, like 30 minutes later, we get to 7-7. And if you are willing to make a concession here, we can excise the excusable homicide. And so to me, this entire jury conference has been a prosecutor who probably is familiar with this judge, expects that this judge will lean into what the statute says and not care if something's going to become an appellate issue, and play into that. And I just think that this is where you have the prosecution and the judiciary, who's supposed to be the referee, on the same side. And a defense who every bit of the defense's advocacy is just being like, nope, somebody else can consider that later and tell me if I'm wrong.
Right.
And it's just, I guess my bigger point is that this isn't unusual. That's my gripe.
Not engage in the creation of, making committee recommendations. Go see the Florida Bar Committee on jury instructions, and that's how. Yeah.
Well, then more of a reason not to simply accept them as the law, since the Florida Bar doesn't trump Your Honor's road by any standard of imagination. So I urge you to reconsider.
I appreciate that, but I'm gonna decline the invitation.
Kick the can.
But we'll have a copy of all of this, of course, in the record. And there are not a lot of vessel homicide cases, so I don't know where we're gonna go. Right.
There's one other instruction we proposed in this section, based on the McCreary Supreme Court of Florida case, that says if you find that George Pino is not guilty of vessel homicide, you must also find him not guilty of manslaughter by culpable negligence. It's either should come as a form of an instruction, because that is the law. If he's not guilty of vessel homicide, he can't be guilty of the greater offense of culpable negligence.
Well, I want to ask the state about that because, you know, that's a point we had already touched on, and whether or not, you know, there would be potential for an inconsistent verdict.
So what I think,
Ali, can you explain that quick? Why, like, recklessness and culpable negligence, why it would be inconsistent if we had both?
Well, because so you only need recklessness for the vessel homicide, and it's supposed to be a higher standard, this culpable negligence. So, I mean, recklessness is usually like you think of it as worse than negligent, even though it's kind of encompassed in negligence, like that you recklessly, that you recklessly do something. So the way they're using it, they could think it's you only need recklessness when you really need culpable negligence, which is more than recklessness.
And then you'll end up with convictions on both when you don't really know if that's actually what the jury found, because they're confused on the definition
Right.
or the meaning, the required elements for the culpable negligence.
Right.
And maybe they should get some special jury instructions that could help clarify that. I don't know.
the simplest way to do it is that the jury shouldn't even deliberate on manslaughter unless they have first found that he is guilty of reckless driving, i.e. vessel homicide. They don't even get to it. So what I would propose is that the court instruct you first must decide if the state has proven count two. If they haven't, then you find him not guilty and your deliberations have come to an end. There's nothing to
Sounds
go.
like the instructions in a capital case.
I've never done it.
If you don't find an aggravator, you're done in terms of in second phase. Jury doesn't find unanimously an aggravator exists in a capital case. They do not proceed and the sentence is life. So I think what you're saying is something similar to that, not in the context of what would be an inconsistent verdict, but how the verdict forms would read. And so I am going to ask the state about that because I was curious about that issue and when we get to the verdict forms, how they should read.
Judge, there was a case, it's State versus Perez. It's at 718 Southern 2nd, 912. It's a 1998 case out of the 5th District Court of Appeal. And in that case, the defendant was charged with...
You said the 5th District, right?
Yes, Your Honor.
And what year did you say? I'm sorry.
1998.
Thank you.
The defendant had been charged with 1 count of vehicular homicide and 1 count of reckless driving. The state charged them as 2 separate crimes as opposed to vehicular homicide with reckless as the lesser.
Okay.
And in that case, the jury came back guilty on vehicular homicide and not guilty on the reckless driving. And in that case, the court found that that was not an inconsistent...
Well, because they came back on the higher charge.
Right, but they found him not guilty of the lower charge.
Right.
And so the argument was, well, if they didn't find him guilty of reckless driving, then they could not have found
I
him
see what
guilty
you're saying. Okay.
of vehicular homicide.
Okay.
And the appellate court in that case said that, in point of fact, these are not truly inconsistent verdicts because there can always be the possibility that the jury just decided to agree on some kind of jury pardon or a compromise type of a verdict.
Okay.
So I don't think that the claim that the defense is making that if they don't find recklessness, they can't find culpable negligence is not supported by the law.
Well, okay, because is vessel homicide a necessarily lesser included of the manslaughter?
No, it's a category 2, and it depends on how the charges are pled.
Okay. Okay.
And so the state, in this case, opted not to charge manslaughter with vessel homicide as lesser. We opted to charge each count by itself.
I see, okay. All right.
I haven't read the case, we'll read it, maybe we can take a few minutes, but I'm guessing that that's a case that deals with the principle of law that on appeal, the courts do not reverse convictions where there appears to have been an inconsistency in the verdict form, and the courts have said they'll ascribe that inconsistency to some jury nullification, some other reason other than an actual inconsistency. What we're proposing is to even avoid that possibility. I understand that if it happens, then the defense would lose on appeal on the principle that too bad, so sad, the jury likely just cut your client a break by.
Aren't there different elements though?
In this case, the theory of prosecution is that manslaughter was committed with a vessel. So I don't see any other theory of manslaughter other than it was committed vessel homicide plus a greater level of mens rea. That's what the McCreary case said in the Supreme Court of Florida. Specifically said that vehicular, not vessel, but vehicular homicide is a lesser included of manslaughter.
Well, doesn't that go back to the way the state is charged as an alternate theory? It's not just by culpable negligence on the manslaughter?
I don't see why that.
Because McCreary, is it McCreary just a culpable negligence, manslaughter by culpable negligence charge?
So let's assume it was either act or culpable negligence, either 2A or 2C. If it's 2A and it was an intentional act to crash, that would be reckless per se. There'd be no doubt about that, right?
Okay.
If you do it intentionally, it's beyond reckless. So manslaughter, as I am understanding it, you've got culpable negligence and then you've got outright intent to. So it's just what they've pled is two different degrees of intent within the manslaughter, both of which are greater than reckless.
Yeah, well, why is it not a category 1 lesser?
I don't know. I haven't studied it, but if you give me 5 minutes, I'm sure we can give you the answer.
This is going to go to also my verdict forms, our verdict forms, how I think it would be appropriate. And we have count 1, the manslaughter verdict form, and then we have count 2, the vessel homicide.
I'm sorry, can you please repeat that?
The verdict forms, I don't have a draft of the verdict form, but we will.
I sent one to the court. I can send
Oh,
one
did
to
you send it?
everyone
I'm
else.
sorry. Why did I not? No. Okay,
I'll send them to everybody again.
that's great. Francesca, can you, where am I finding it? Can you send it to Carolina?
Yes.
Okay. What's that? No, I just need a copy from you. All right, I'm gonna pass on the rest of this right now, so we can, let's finish up with, what we have in terms of the instructions.
Forgive me, Judge, what are you going to pass on?
I'm gonna pass on this question of whether I'm going to consider any addition to the instruction of whether, if the jury finds that Mr. Pino is not guilty of vessel homicide, that necessarily precludes the jury from coming back with a guilty finding on the manslaughter. So I'm going to pass on that for a moment, okay? Then you're making a request for my further explaining what ordinary negligence is. I'm taking this as a separate special instruction. Like
Yes.
apart from the vessel homicide, the language you included, apart from the manslaughter language that you included, this is now another separate special instruction request.
Yes, please.
Okay, that ordinary negligence is not sufficient for a criminal conviction. Okay,
That's the title of our section.
that's the title of the special instruction. Okay, and then I'll jump back.
To be clear, we're not asking you to put the title in front of the jury. It's just to guide your review. It's the page that is titled "Ordinary Negligence is not sufficient for criminal conviction."
Okay, so as a special instruction, you don't want a
If you
heading?
if you give it to us, we'll take it.
Okay,
Yeah.
all right. State, do you know where I am on this?
Yes, Judge.
Oh,
And I would object to that instruction, Your Honor, because the standard instructions talk about that recklessness is, requires the state to prove more than a failure to use ordinary care. So the jury instruction for vessel homicide just like the jury instruction for manslaughter makes it very clear that neither recklessness nor culpable negligence can be proven with simple negligence.
Cannot be proven.
Correct.
Okay. I'm going to decline to give the additional special instruction on further explanation of that ordinary negligence is insufficient to support a criminal conviction.
Understood. And to be clear, we would ask for each sentence to be considered alone and in combination, or, let me rephrase it.
Correct.
Each be considered alone. We prefer that they be given in combination, but we'll take as few or as many as the court will give us.
Look at criminal cases are different from civil trials. Any comment from the state?
Yes, one moment, please, Ron. That instruction is part of the instructions that are given at the commencement of a civil trial. And that instruction is from Florida Standard Jury Instructions for civil cases. I think the court has already gone over with the jury during jury selection that this is not a civil case. And it seemed to me that there was nobody on the jury that was confused about that.
All right, I'm not going to give that instruction, but it's preserved and it's part of your record.
Thank you, Judge.
Oh.
Same, let me just have a standing statement
Yes,
that
of
I
course.
ask the court to consider each sentence
If I
alone.
decline to give it.
Sorry?
If I decline your request, it's still over your objection,
Right, and then I've asked you to consider each sentence alone.
correct? Yes, you have it paragraph by paragraph, so individually and cumulatively for the subsection on criminal cases are different from civil trials. I'm not going to give that. Failure to exercise every possible precaution does not constitute recklessness or culpable negligence. And then we have is this part of the civil jury instructions?
It is.
Where I got.
Okay, all right, yeah, okay, I'm just double checking here. All right, I'm going to decline to give the requested civil instruction on failure to exercise every possible precaution does not constitute recklessness or culpable negligence.
And Judge, the court would, I just want to remind the court that the state has introduced evidence of all the things that George Pino could have done, even if not required by rule or regulation. For example, he could have had passengers wear life-saving devices. That's going to be the next one. You know, he could have had them sit somewhere else on the boat. He could have had the flares that are not expired. So that's going to be a theme throughout.
There you go. That's what we
I
were
believe, the
talking
closing
about.
argument.
There it
I
is.
think you're going to make objections that you think are appropriate, if that's part of the closing arguments.
How about you instruct now that the parties should not do something that would be objectionable during closing arguments, instead of welcoming, let them do it, and then you object to it.
Right. But he's making the point about causation we were making before. Like, she's got all these other things in here. Because that's what the lesser included seemed to, if there's an argument as to causation.
Look at Mark all tired and over it.
But how the state, this is only one here. Oh, no, how the state would tie that in to their burden will be part of their argument, and then you'll make objections you think are proper. To the
Yes,
argument.
but unless the court sustains them and instructs, then I'm going to look like I'm making a frivolous objection. So if If my objection is, you're expecting my
Well,
objection?
I might sustain and instruct. It really depends on how the argument is made, right?
Right, and so I anticipate the argument that they're going to make, for example, that none of the girls were wearing flotation devices, and then ask the jury to imagine maybe the decedent would have survived if she had a flotation device on. Perfect example. Not required by law, but the state's made that a feature of their case, and they're going to ask the jury to find the defendant guilty because he could have had her wear a flotation device, and had she worn one, we might not be here on a manslaughter.
I'm not sure that would be a proper argument.
That's why I'm asking the court now, rather than for us to have to interrupt the state to rule on that issue and properly instruct the jury or the state that that's not a proper argument.
Okay. Do you have anything you want to comment on?
I'm not sure I'm understanding what he says I shouldn't argue.
She's gonna do it. She's gonna do it,
We're trying to
100%.
anticipate what closing argument's going to be.
No, I understand that, but I'm not sure what he's saying that I can't say about a life jacket. I'm
Yeah.
certainly not going to ask them to convict him of these homicide charges because the girls on the boat were not wearing life jackets.
Then you shouldn't argue it in
And,
closing.
you know, like many other factors in this case, that's a factor that the jury can take into account.
No, it's
There's
not.
evidence of it.
No,
Take
it's not
into account
relevant.
To determine what?
To determine if the defendant was either reckless and or culpably negligent.
No.
Reckless in
Look at Howard.
or culpably negligent in the operation
What?
of the vessel?
Yes, because he's got a vessel that has passengers on it, that if something terrible were to happen.
You know what, Judge? You
they're
let
not
her get
wearing
it in.
life preservers.
That's the problem. It should have never gotten in. That's why you're sitting there dumbfounded.
So how
So
is
tell
that-
her.
Go,
No.
Allie, go, Allie.
If
Improper.
you have a crash and you've got a baby that's not in a car seat
Oh, back to this egg thing.
and the baby dies, what
Oh, I thought she was going to do
There,
the
there
egg
are
thing.
laws about a car seat too. This is not even an egg thing. This is worse because she's comparing something where there's no legal requirement for those girls of their age to have been wearing a protection device.
Yeah, she might as well say if the baby gets into an accident in a car where there was no car seat, okay? No, okay, where there was no car seat, but also the seatbelt on the other side didn't work. Why is that relevant? So if the baby gets in an accident, let's say, counsel, if the baby got into an accident and there was a car seat, but the other side of the seatbelt was completely non-functional, why would that come into evidence? Ay,
I
ay,
don't
ay.
know. I feel like some of this started because she might not have known that the seats on the boat were actual flotation devices. So I feel like she had it in her head in the very start. They didn't even have devices that could save, but he did. And she just didn't realize that that's how boats work. So she had to stick with this narrative because it's always been in her head that he didn't have flotation devices. But he did. So- Oh, let's run it back so we can hear it in full. I don't understand.
a vessel that has passengers on it.
Look at the
that if
defense
something
lean back.
terrible-
Watch them lean back,
because
Allie.
he's got-
Reckless in or culpably negligent in the operation of the vessel?
Yes, because he's got a vessel that has passengers on it, that
Right,
if something
they're all
terrible
like,
were to happen,
what is
they're
she's
not
going
wearing
through?
life preservers.
Okay.
Why don't they say
So
something?
how is that?
Okay, good. Causally
If you
connected.
have a crash and you've got a baby that's not in a car seat and the baby dies, would the
Okay.
prosecution be prohibited from talking about the fact that the baby wasn't in a car seat?
No.
And, you know, the state's not even permitted in a situation like that to say, oh, well, he violated that law, so you convict. But it's a factor that goes into the mix, just like it's a
You
factor
have
if
to
the
be in a car
defendant had
seat, as
alcohol on
Kat
board.
said.
Just like it's a factor how fast he was going. It's a factor of how much weight was on his vessel.
And this, say that again?
It was exactly what you said, that there is an actual law that you have to have a kid in a seatbelt. And the fact that they're not in a seatbelt would have contributed to the accident.
It's not comparable, and also you just fought against the special jury instructions that clarify for the jury that this one thing alone is not enough.
Right. Because then we might as well have jury instructions. If she's allowed to say that, then I guess we need jury instructions that say
She
the
could just
girls were
improv
not
the jury
required to.
instructions.
Right. The
Just
girls
let
were
her
not
give 'em.
required to have on life jackets. The little stupid expired thingies had nothing to do with this accident. All of the things.
I would add, I mean, I know that the judge, when closings happen, this is going to be objectionable. And she'll probably save certain arguments for rebuttal. So his only opportunity will be for him to object. And he's going to have to try to ask if an objection is sustained for a curative instruction during
Or
the
a
middle
mistrial.
of this woman's rebuttals. Well, and
And
we'll end a mistrial, but I don't think that would be granted.
Right, and I
So,
think really, I do think these arguments that the state is making can allow the defendant to say that causation is at issue, and we want the lesser included non-homicide jury instruction, because if she's going to get into things that didn't cause the death, but could have but are, sufficient to put a person at risk for injury, an injury that ultimately didn't happen, then we need this lesser included. And then she can shut up and not put any of that stuff in, because it gives them that way to get that lesser
yeah,
included
make
in.
your choice. Make your choice. You either, prosecution, you either don't cross this line, which you shouldn't be doing anyway. We shouldn't need to
I'd
negotiate
rather
and
them
bargain with
cross it
you.
and get the
And
get the lesser
yeah.
included. Keep going. And if they do,
Oh,
if you're listening, that should be your curative request, is for the charge on culpable
it's
negligence
not enough.
misdemeanor.
And it's also like this one thing is also not enough, because she is going to argue that
Yeah, that
each
too,
of these factors, she'll also argue the totality. But I already know she's going to weaponize her two alternating theories to wash away from the totality being enough, and hinting that one factor would be enough. She won't say it explicitly, but she'll do it in a way that's only partially objectionable and the judge might not sustain.
Direction he was heading, what speed he was traveling at, all those things, the conditions of his passengers that were, some of them, by their own testimony, were at a minimum buzzed. I think all of those things are factors in the way that this vessel is being operated, because it's not just where you're steering, it's who you're steering and who you're endangering. That all factors into whether or not you're reckless. And the Martinez case, Judge substantiates that, because in Martinez, whether somebody's consumed alcohol or not isn't in and of itself reckless operation of a motor vehicle. But in the Martinez case, the 3rd District Court of Appeals said whether somebody had alcohol on board is a factor. It had nothing to do with the driving, but it had to do with the overall factual scenario that was taking place. And so if they can find that person's consumption of alcohol, even if the state can't prove it was an unlawful amount, that's still a factor that the jury can take into consideration.
In determining whether or not the operation was reckless.
Correct, in a vehicular homicide case. So if we just transfer that onto the water, if one of the factors might have been that he consumed alcohol, okay, the 3rd says that's okay. So let's look at other things that happened that endangered other people.
Well, don't you look to the actions of Mr. Pino, or the inaction of Mr. Pino, right?
Yes, and he's the
So
captain
the
of
inaction of Mr. Pino in not requiring the girls to wear life jackets.
He required them to sit down when he started going faster. He obviously recognized that things were not going to be as safe once he started moving at a faster rate of speed. I'm not saying he's guilty
is that
because he
on the
didn't make them
record?
wear life.
And was that testimony that he ordered them all to sit down because he realized he was not driving safely, operating safely?
She's just taking,
Creative licensing.
right. He told them to sit down, and then she's making up the because, as she's been doing throughout this trial.
Life jackets, I know there's no law that requires it, and that was made clear to the jury. But it's a factor.
You just
And
gave
I,
an example
feel
that
like
was
when
a
we were
car seat.
litigating the sworn motion to dismiss, the court seemed to
gonna
indicate by Your Honor's ruling
Take a-
that the court was understanding the state's perspective that this isn't just as simple as a speed alone case. And as I argued in the first JOA, where there wasn't much argument with the second JOA, but in a situation like this, it's the state's position that, yes, of course this is reckless. If there weren't all those girls on the boat, if the defendant didn't even have any alcohol on board, if all he did was operate his vessel at that rate of speed in that direction, where unless he deviated course, he was going to slam into that channel marker, and he didn't do anything, if his wife had died, if she was the only one on the vessel, if Lucy was the only one on the vessel, he would be guilty of vessel homicide, no two ways about it. But you have all these added factors that endangered so many people that, to me, it didn't seem appropriate to only charge the vehicular homicide, because this isn't just reckless. This is something more than reckless. It's in the level of culpable negligence. And the jury can make a decision if they agree with my decision on how to charge it or not. But, in terms of the arguments that go into the mix of what's reckless, what's culpably negligent, those were arguments that were made that it seemed the court was sustaining when it denied the motion to dismiss and denied both of the JOAs.
Judge, may I just make sure that we're distinguishing between, I think the state's conflating conduct that affects the operation of the vessel versus inaction that could, had it been done, might have mitigated the consequences of the elision. So a life preserved, by way of example, has absolutely nothing to do with whether there would be an elision or not.
But it has to do with whether or not there could be a potential for death, and remembering that the instruction is that the operation means an intentional, wanton means with a conscious and intentional difference to the consequences, and with the knowledge that damage is likely to be done to persons or property. So the consequences of that recklessness also means if your passengers...
If you're not prepared, or you have your passengers prepared for what would be a foreseeable consequence of the conduct, and that is, from the state's argument, ties into viable evidence that the jury can consider.
She can't even spit it out. She's hard. She can't grasp it herself. What about causation? All right, let's see if he says.
The state's position is just yell and interrupt.
Viable evidence that the jury can consider.
That is their position, and that's just not a correct statement of the law, because, but now that they're imposing upon Mr. Pino a duty of extraordinary care, the law doesn't require life preservers. So that's the simple example.
No, I don't think it's extraordinary. I don't see it. I'm not sure I agree with that. Given all of the
He's too polite.
circumstances,
She doesn't
choosing
mind.
the course of conduct.
She doesn't mind like chiming in and pushing back with the judge, and then he is like very deferential, which is the way you should be, but except when you shouldn't. And he
Yeah,
needs to say
especially
the
with
words
critical issues
causation.
like this.
Right, that you can't just point to negligence, that he goes back to his race ipsa loquitur argument he made at his first judgment of acquittal argument. Like, she's throwing in acts of negligence that are unrelated to the cause of the accident.
I miss the chat. They would just be
But
going
is she
bananas
saying
right
that
now, I
all
feel
of that,
like.
if she's saying that all of that can be considered when you're trying to decide whether he acted in conscious disregard for the life of others? Does all of that come into to be considered for conscious disregard? I don't know.
In this case in particular, to go from point A to point B, there were certain decisions made, and the jury can find or not find that these were conscious, intentional, not in an evil way, but in intentional conduct, that it would be foreseeable that death or great bodily harm could result because of the actions or inactions of Mr. Pino.
So,
Sounds like
I
regular
think that's what I
negligence.
understood the argument to be.
All right, so
So-
where did the
can't
flotation, where did
compare
the
consumption of alcohol, which, if enough of it is consumed, it would impair the driver and affect the operation of the vessel, to, for example, failing to go beyond what the law requires and force the passengers to wear a life preserver, by way of example. The law doesn't require it, you'll see that's our next instruction, but the state will argue to the jury, apparently, that he acted recklessly by not having the passengers all wear life preservers. Had he not alighted, the life preservers would have had no relevance to this at all. At all. Of course,
argue better?
Yeah, I'm not sure I understand what you're saying. I'm not sure that, I'm not going to speak for, and I've already heard just a general summary of what the argument is. I'm sure there's going to be much more to the state's argument, and we're not, previewing closing arguments here, but,
Maybe you need to.
and again, whether or not there was evidence presented about there were enough life preservers and they weren't wearing them, okay, and the evidence, if I remember, Mr. Pino had the girl sit down knowing he was going to increase the speed of the vessel, I don't know if that was the evidence.
No, I think the testimony was at some point he asked the girls to sit down while they go underway.
She adopted the because. That was just creative license by the prosecutor.
Oh my gosh.
This renew the JOA again. I was like thinking in my head, be petty and just renew it, because you just heard the state like go through this whole monologue where they're showing that they're arguing. The state just made an argument that he actually took a precaution by, under her theory, which I do not think was any testimony on the record, that he asked the girls to sit down because it would be dangerous for them to be standing while the boat was going a certain speed. Right? That's a precaution. That's someone exercising care. So I'm like, that's contradictory. Renew the JOA. But now you have the judge adopting argument. And was she using argument or what's actually on the record to weigh her JOA? Because I think she adopted argument as fact, including things that are not actually on the record.
Which is a prudent thing to do.
Okay.
I think the officer, the lieutenant agrees.
Okay.
I don't know what.
And I don't know what happened, has to do with the speed at all, or whether or not being prepared for what could be potential consequences to the actions that were taken.
Well, it also improves visibility, because if the girls are standing, it would obstruct his visibility.
Okay.
So there may be two reasons why it would be appropriate to have the girls seated.
I guess you could argue that, right?
But I'm okay with that.
Yeah.
That one doesn't bother me, right? He has everybody seated and he's being prudent. No one's going to say he's imprudent by having them seated. That's not the issue. The issue is these other have an engine cutoff switch.
Okay.
Not required. No relationship between.
Okay. But that doesn't go to what was relevant evidence, and the weight or significance of whatever any of this evidence was. That's part of the argument, right? That jury doesn't. Your position would be, well, what value does that have at all to how Mr. Pino was operating or failing to operate the boat in appropriate?
For some reason, in civil cases, the court gives this instruction.
Okay.
You would think if it's appropriate in a civil case, it would certainly be appropriate in a criminal case.
Okay.
You surely
And
would.
that's also, they're going to argue that Mr. Pino could have done many more things to improve safety. We all could do more. The law just doesn't require it, much less allow that a conviction stand based on the failure to do more than that which is required by law.
Okay. Thanks. All right. I'm not going to give the failure to exercise every possible precaution does not constitute recklessness or culpable negligence, and then the fact that the Florida law does not require persons to wear personal flotation devices on vessels more than 26 feet in length. That is argument, and I'm not going to give that instruction. And the engine cutoff switch, let me see here.
I think it's undisputed the law does not require an engine cutoff switch under these circumstances, just like the law doesn't require anyone to wear a personal flotation device.
Right.
Our recollection is you told the jury you would be instructing on this. That's our recollection. But
I think that has to do with the navigational rules.
my recollection is not as good as my colleague. They recall that there was a point in the examination where I was trying to extract these points of law, and the court told the jury that you would instruct on those points of law.
I think I would tell the jury that I would instruct on the law. I don't know if it meant that on whatever you were discussing, I was going to instruct on what you were discussing. I sustained an objection, and I'll instruct them on whatever the law is. What you're asking me to do, though, in terms of the instruction, is not an instruction that I'm going to give in this case in terms of a special instruction. Okay?
If we can find it, I'll let you know why that's our recollection, whether that changes your mind or not.
All right. And state if you see it, if you see something or you know something. If I made a statement to the jury with regard to the cutoff, it's the cutoff switch, right?
Somebody called it a kill switch. Either way.
If I made a statement to the jury that I would be instructing them on what the law is on a kill switch or cutoff switch, I don't remember.
I seem to recall that on cross-examination, defense counsel asked Mr. Albert if there's any legal requirement to wear a kill switch, and I believe he said no. But we can double check the transcripts. But I think the jury already knows. already knows that that's not.
The
a
jury
requirement.
knows that it's not a legal requirement.
Correct.
But whether I advise them that I would then instruct them,
I don't
I
remember
don't
that, but-
remember. I'm not sure if it was in that context. Oftentimes I will say, the court will instruct you on the
Right.
law. And I don't know if it was specific as to
Navigational
kill
rules.
switch, what the laws on kill switch, what the laws on
Life jackets.
life jackets. In terms of, I believe, when we were discussing, and I allowed evidence regarding the navigational rules, okay, I gave them an instruction over objection about the rules in general, that specifically advising them that a violation of any of those rules, individually or cumulatively, is not in and of itself evidence of a culpable negligence or recklessness. I think I gave them that instruction over your objection, because I think the objection was that I should not have allowed any evidence of the navigational rules. I think that that's what occurred during the trial, which I allowed the state to introduce evidence of the navigational rules with that limiting instruction. And we're going to get to that in a
Give that
minute, because
again.
then the state is asked as part of the final instructions for me to instruct the jury.
Yes.
And it's very similar to the instruction I had already given to the jury on how, if at all, they can consider the navigational rules. So I'll get to that in a minute, okay? In fact, I'm going to get to it right now, because this is the point to do it. Because next we would be talking about weighing the evidence. Okay, so.
Actually, Your Honor, the state had put in the jury instructions that I sent to everyone today, that after Your Honor would instruct on the vessel homicide charge, that the next charge the state would be seeking was a charge on the navigational rules. And it's largely the same as what I had put forward previously.
And it has to, I think, and I agreed to instruct the jury over defense objection, and I think similarly, in the final instructions, there has to be a boundary or limiting instruction as to, so the jury is clear that a rule violation does not mean any kind of criminal culpability. It doesn't translate into either individually or cumulatively criminal culpability. So,
So on page 9 of the proposed instructions that I sent, I think it's an accurate reflection of the case of Logan, which is at 592 Southern 2nd 295, because in that case, the defendant...
so I'm not gonna read the rules specifically.
No, I understand that, Judge.
No, I'm
only
asking you, you're not
for-
asking me to read the rule specifically.
No, if the court looks on page 9, the request from the state is for the following instruction. In the state of Florida, the law requires operators of vessels upon its waters to follow the navigational rules. However, a violation of these rules is not sufficient by itself to constitute culpable negligence or recklessness. In order for you to include a violation of any of the navigational rules in your deliberations, you must also find that such a violation was accompanied by a thoughtless disregard of the consequences or an indifference to the safety of others and caused or contributed to the cause of death of Luciana Cristina Fernandez.
All right, now you've already objected, but can you look at the language that's proposed and,
I'm going to object to the first two sentences, but then I do object to the remainder of the paragraph, because that's now the court telling them how to use these rules in their deliberation. And if the court is not inclined to rely on Third District Court of Appeal and other courts of appeal case law when we propose instructions on how to guide deliberations on the important elements of the case, and so too.
yeah, I'm gonna
If
modify
the-
the language a little bit there.
If the court would prefer that, and the defense would prefer in order for you to include a violation, if both parties, I know the defense is gonna object under any circumstances, but if it makes it less objectionable to remove that final sentence, I'm happy to do that, and the court just advised that although the law requires operators to follow navigational rules, a violation of these rules is not sufficient by itself to constitute culpable negligence or recklessness.
Ali, you want to explain why I just threw my hands up?
I can't
That
because
would.
I was just reading a case and I was half
Oh, okay.
listening.
So we're now going on to the defense responding to the special jury instructions requested by the state.
For the Okay, so
And
we still haven't gotten to the weapon one yet, to the
no, we're
special verdict
we're on like the special instructions that the
the state's asking for.
state wants for like navigational rules. And we just went through a whole little bit about like one thing isn't enough, even though we declined all those instructions. And now the defense attorney is like, look, I'll just let you listen to it. Look, we're fine with this one part, that's fine, but the rest of this paragraph, and listen to the reason why.
So, Judge, I don't have an objection to the first two sentences, but then I do object to the remainder of the paragraph, because that's now the court telling them how to use these rules in their deliberation. And if the court is not inclined to rely on Third District Court of Appeal and other courts of appeal case law when we propose instructions on how to guide deliberations on the important elements in the case.
Look at Laura's face.
So to,
Yeah, I'm gonna modify the language a little bit there.
If the court would prefer that, and the defense would prefer in order for you to include a violation, if both parties, I know the defense is gonna object under any circumstances, but if it makes it less objectionable to remove that final sentence, I'm happy to do that. And the court just advised that although the law requires operators to follow navigational rules, a violation of these rules is not sufficient by itself to constitute culpable negligence or recklessness. Sorry.
So what did Howard just call out there?
That she's like literally doing the same thing that she wants a special instruction when it fits her, and she still wants to encompass all these navigational rule supposed violations. It's I was just reading her whole thing, and it's kind of outrageous. And of course the judge started to tell her no, and she just
She cut her
bites
off.
in. Right. And the defense just sits quietly and patiently being respectful at all times.
Then that's fine. I'll take that out.
That's not what they want. Defense, say something. She's looking to you.
Because I think the less the better here, anyway, because it is
Just
a gray area,
Reject it.
frankly. Again, not a standard
Look at
instruction.
look at this attorney. Watch this attorney, guys.
She needs to be saying to him, just tell her to reject it.
Yes.
Period.
And I need to make sure when I instruct the jury that there is a fair balance on,
Right. So say no.
on not telling them how or whether they should, but just leave it as the simple explanation of they do not constitute culpable negligence or recklessness in and of themselves.
Period. Not even in and of
So
themselves.
over the objection to giving a special instruction at all, I'm going to take out I'm just going to leave the first two sentences in that. Okay? Okay. Then I would have the reasonable doubt instruction. And that was just recently amended. In fact, we just got one additional amendment change that I've included. And this is June 12th. And I think yesterday also. There was something
on
that
this
that's already
list.
been included. So,
There was
let me
an
look at
amended
the
one.
states.
I know, but I don't
requested
see it on
instructions.
this
I think that
list.
you had included the
I'm looking at
amended instruction.
That's correct, Your Honor.
so I would request that the court include language from the 11th Circuit U.S. Court of Appeals pattern instruction.
Oh yeah.
See, one moment, Ron.
Okay.
Hmm.
Forgive me, Ron, just one more second. says proof. So the 11th Circuit U.S. Court of Appeals instruction says proof beyond a reasonable doubt is proof so convincing that you would be willing to rely and act on it without hesitation in the most important of your own affairs. I would ask that that language be included in the instructions to this jury.
Okay. You have any comment?
This has been kind of laborious, so I'll just make a little half-hearted joke that maybe Mr. Shrevenick got off at the wrong exit, because we're to the west of I-95, not to the east in the federal courthouse building. But I mean, as much as, just as recently as last week, we've been given a new reasonable doubt instruction to be used in all Florida criminal cases. I don't see us bringing in the federal standard for a case like this.
I'm going to decline the request, but you might want to type that up also. And if you can mark it and include it in part of the record as well.
I think we have a court reporter who
That's fine.
heard what I said, but
Okay.
and she's nodding, so I think we're good. And I can just tell the court it's easily attainable at the 11th Circuit pattern jury instruction.
That's fine. All right. Then we're going to get to weighing the evidence.
And also notice, Ali, you might not have been paying attention, but the judge wanted to move into weighing the evidence. And the state was like, no, I was actually hoping that we could go right into navigational rules because that's how I want the jury instructions to read. We go right into the navigational rules when we're done reading the vessel homicide charges. So the judge obliged that and steered course, but wouldn't switch the direction earlier when the defense attorney is like, well, if we argue vessel homicide first, we can get through the definitions, the building block definitions of certain terms and work our way up. She didn't want to change course.
I mean, this is the reality that same as it ever was. Just play that in the background.
Standard, I took out, let's see, this is an opportunity to see and know the things about which the witness testified. Did the witness seem to have an accurate memory? Number 2. Number 3, was the witness honest and straightforward in answering the attorney's questions? Number 4, did the witness have some interest in how the case should be decided? Number 5, does the witness's testimony agree with the other testimony and other evidence in the case? Number 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify?
The state wants that, and it looks like the defense wants it.
Sorry?
The state wants that instruction to be included. It looks like the defense does not.
I'm not sure it has any application. I don't see what the application is in this case. I think that's typically when you have a cooperating witness. Prisoners.
We have a witness that was offered money.
Sorry?
We did have a witness that testified for the defense that was offered money, so I think that that should be a factor that the jury can take into account.
Okay.
So that's why I'm asking for that
I
instruction to be
mean,
included.
didn't you have a paid expert?
Yeah, both sides did.
Okay. I understand what the defense is saying in the context of more of like a cooperating witness. Over objection, I'm going to give number 6. And did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? I'm going to give that. I think that's it. And I'm going to, I'll give the expert witness instruction. I don't see any changes in terms of, from the language of the standard.
I'm sorry, where are we now?
On page, I've just finished I finished number 7, and I renumbered them. And then whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. Okay? And then I move down to the law enforcement witnesses. female law enforcement witnesses that testified? What's it say about her? I'm just asking.
Oh, we can take out the her.
Okay. Expert witnesses, I'm gonna give that instruction. And let's see, his or her opinion. Didn't we have female expert?
Yes.
Okay, so it'll be his or her. And the next paragraph, it's okay for a lawyer to talk to a witness. I don't see any changes there. And the last paragraph, there's been no changes there. So, we'll leave that. Then the next instruction is defendant not testifying. Do you want both paragraphs?
Judge, I would ask that in the second paragraph, second to last line, after the name George Pino, two words did or should be removed, because in this case, Mr. Pino did not take the witness stand. So the last sentence would
Oh, I
read,
see what you're saying, okay.
No problem, Judge, we agree.
Okay. Okay. You're also asking that I put your client's name where it says defendant.
it's fine, as you wish.
Any objection from the state? I would say against the defendant, George Pino.
Well, in the other places in the instructions where it called for us to use his name rather than the defendant,
Right.
it's listed in the
Is
same
it
way that it's
bracketed?
charged in the information, so
Yeah.
it'd be George I. Pino.
Yeah. So it's highlighted in the other standard instructions that you should actually put the specific name, but in this instruction,
Does not.
3.9, just so we're clear, and let me double check that. A.
If you look at the standard, it doesn't ask for the
Yeah,
defendant's
okay.
name in the way that it does like for the statement of the charge.
Right. All right, I'm gonna just, on the first sentence, just say defendant George Pino, then the rest of it will be the defendant. Put his name there, okay? Look at the next instruction, which is defendant statements.
Hello, Your Honor.
I think that's the standard, and I think you agree with the standard from what I'm reading in your requested instructions.
Yes, sir, I'm trying to process one other issue. 1 second.
Okay. Unless you're okay, we break? You want to take a minute?
We're almost done, right?
I think you already wanted me to.
I'm sorry. We're almost done. I'm good.
Okay, whatever, okay. Point 9B,
That in proposed instruction 3.9B, Bravo, defendant statement.
3.9B,
Is that what it is? So I said,
defendant statements, yes, okay,
in the middle of the page, it has two factors to consider.
yes.
We would propose a third one, and that is Mr. Pino's mental and physical condition at the time of the statement.
Your Honor, the state would object to that. The purpose of 3.9b is to ensure that the statement was freely and voluntarily made, not that it was also necessarily intelligently made,
Okay,
or that it was made by a person, that had a particular physical condition or non-condition. It talks about to make sure that it was freely and voluntarily made. That's the issue. There's no
okay,
allegation.
part of the argument,
They can argue.
part of your argument's gonna be, it wasn't freely or voluntarily made because Mr. Pino was suffering the effects of a medical event, a concussion, or, right, okay. The instruction says, though, whether they were freely and voluntarily made. So, including but not limited to. So I am gonna decline your request. But certainly goes into the argument of whether it was freely or voluntarily made. And other things that, you know, and this is in the context of where you see these instructions, is when there is a statement against interest, when there's a confession, when there's, so, yeah, I'm not gonna add a third paragraph to the standard. But that'll be part of your argument as to why it was not freely and voluntarily made. Okay. Look at rules for deliberation. And I think we agree that since this is not a penalty phase, a capital case, that there were certain paragraphs that are taken out. Everything else, what I'm reading from the defense version and the state version look to be consistent.
Okay, Your Honor.
And there are seven paragraphs that the jury should consider in the rules for deliberation. Let me know when you're ready.
I'm ready.
Okay. Cautionary instruction. I think it's consistent with the state and the defense with the standard instruction, and nothing, there were no special requested instructions. Verdict.
I'm not sure I understand.
There's no lesser, so that first paragraph is out on what would have been the standard, because I'm not instructing them on any lesser, so I'm gonna take that paragraph. That was in your draft?
Yes, but
All right, then I have the verdict form, which I'll go over in a minute, but just keep finishing up with the instructions here.
with regard to the verdict instruction,
Yes.
you have under consideration the issue that we raised earlier about that if the jury were to find Mr. Pino not guilty of vessel homicide, that would necessarily end the deliberations, because vessel homicide is the lesser offense than manslaughter. So you still have that under consideration.
Right, so, and I think that if I'm gonna make any changes or amendments to the standard, it would be at this point, because I still haven't decided that yet. Okay? Okay.
And so the request for the, what I'll call the special verdict form regarding not having the jury deliberate on manslaughter if the jury has found that Mr. Pino is not guilty of vessel homicide, that would then affect what is now, I think, 3.12A alpha, single defendant, multiple count of informations.
Yes. I see, yes, I agree. If I'm going to add any language, it would impact that as well.
And then you'll see our next proposed instruction, 3.12D delta, legally interlocking counts.
Okay. All right, Dave, have you had a chance at all, because I don't know if you have, to look at the request on the 3.12 legally interlocking counts?
Yes, and it's not a correct statement of the law for a variety of reasons. First of all, even if the jury finds the defendant not guilty of vessel homicide, they still could find him guilty of manslaughter because, number one, they are not considered truly inconsistent under the Perez case, and number two, the state has charged the defendant with manslaughter under both the culpable negligence and intentional act theory. So telling the jury that they cannot find the defendant guilty of the crime of manslaughter if he is found not guilty of vehicular homicide is an inaccurate statement of the law.
Okay, so this actually then boils down to, when we go back to how the state charged the manslaughter with alternative theories.
I don't agree. I think whether it's alternative A or B, the state cannot achieve a manslaughter conviction if the jury finds that the defendant was not guilty of vessel homicide, because a finding of not guilty on vessel homicide is that the defendant did not act recklessly, much less culpably negligent, much less intentionally.
Your Honor, I know that only in today's discussion about the jury instructions have I made reference to the State versus Perez case. But I think if we, just even broke for 5 minutes, it's a very, short opinion. But there the defendant was charged both with reckless driving and vehicular homicide. The jury found not guilty of reckless driving, found guilty of vehicular homicide. So the defense said, well, if the jury said he wasn't driving recklessly, then how can it be vehicular homicide? And the court said that we would conclude that the doctrine of lenity or of jury pardon should apply. There was abundant evidence to support the conviction of vehicular homicide as discussed above. Had the jury been instructed that reckless driving was a lesser included offense homicide, as perhaps it should have been, the result would have been the same, guilty of the greater charge. In this case, it appears that the jury may have analyzed the problem of overlapping charges better than the defense, prosecution, and the judge, and it dealt with it by finding him not guilty of the lesser, but may have sought to punish him twice for essentially the same series of acts. So in this particular case, where the state has charged 2 separate offenses rather than charging one and relying on the second as a lesser, the jury should be able to make their own findings as to each charge. And if ultimately, if the jury were to come back guilty on both, okay, then maybe we won't have a double jeopardy issue. If they come back guilty on manslaughter but not on vehicular homicide, I would cite to the Perez case saying it's not an inconsistent verdict. If they came back guilty on vessel homicide but not guilty on manslaughter, okay, and obviously if they come back not guilty on everything, we got nothing to
Well, do you
discuss.
think that this should be a special verdict as to either theory on manslaughter?
No,
Okay.
because just like you don't have to have a special verdict on first
Felony
degree murder
murder
if
or
it's
murder.
premeditated or felony murder.
Yeah.
However you want to slice it, the jurors can half and half find, there's no basis for a special verdict. This isn't like, oh, we're going to get an enhancement if there's a firearm or something like that.
Okay. Okay. Now, what was that? Give me the
Of
citation.
course, Your Honor. It's State versus Perez, 718 Southern 2nd, 912. It is a 5th District Court of Appeal case from 1998.
Judge, if we can respond to that case. So in Perez, the 2 charges were vehicular homicide and reckless driving, which reckless driving had no death component to it. So the difference in between that case and this case is the driver in Perez committed a series of acts which could have been considered by the jury to have been reckless. And the court said the jury, and I'll read the quote to you, in this case, the jury could have concluded speed and pass cars in a no passing zone was not reckless, which is why, as to reckless driving, no death resulted from that action. The jury could have acquitted him. But his final decision, the one that did cause death, to try to pass the last car after seeing the approaching van, was reckless. So it wasn't a truly inconsistent verdict, whereas in Mr. Pino's case, both manslaughter, the culpable negligence component of that, and the intentional act component of that, as well as vessel homicide, must be an action that results in death.
Go ahead, Ali.
So they do have the intentional act. I thought she said they were taking out the intentional act because the jury instruction says, A, B, or C. A is he committed
They
an
want A
intention.
and C.
Right. And I thought that they said at some point they were talking like she's not doing A. So because he made that argument about, well, we don't want A, we don't want that stuff there because A is not in, but maybe I misunderstood him.
I think you're thinking of the judge like saying hypothetically.
Maybe.
So if the jury finds Mr. Pino was not reckless, and therefore his quote-unquote reckless conduct did not cause death, they necessarily are finding that a higher mens rea did not cause death. It's different. It's not as if he's charged with manslaughter on count 1 and culpable negligence generally on count 2, whereas they could find, an action of his along the way was or was not culpable negligence, but did not cause death. Does that make sense?
Makes sense what you're saying. I hear it. I understand that.
Right.
Well, first of all, the appellate court is hypothesizing what that particular jury may have done, that they could have said, well, we're going to give him a pass, so to speak, for some conduct, but not for others. But either way, the court right there is just kind of speculating on what the jury would have done, but they recognize that regardless of what the reason was, it could have been a doctrine of lenity or it could have been a jury pardon. It could have been any of those things. And the appellate court still said it's not an inconsistent verdict.
But under the manslaughter resulting in death, under either theory.
Yes, and that's the other reason why this case assures us that there's no reason for the court to instruct the jury. You cannot find him guilty of manslaughter if you don't find him guilty of of vessel homicide. That there's no basis in the law to instruct the jury that way. Manslaughter we can
That's
prove
why they
by
want
culpable
both
negligence
theories.
and or intentional act. Vessel homicide is only with recklessness, and even if reckless is somewhat of a lesser of culpable negligence, reckless driving is a lesser of vehicular homicide. Yet in this Perez case, when the jury came back not guilty on reckless driving, but guilty on vehicular homicide, the court said that's not an inconsistent verdict.
This is
Because there were
still
two different
arguments,
fact patterns.
but this is an argument over what would need a special verdict for, right? For a jury to explicitly say that we think this was met.
But it also seems like it's going to carry over when he gets to the lesser included on vessel homicide, because this culpable negligence, the misdemeanor, is which is why it makes no sense that this wouldn't be. So I did find that there is a rule that it says that non-homicide lessers can only come into play when there is a factual dispute about causation, meaning an intervening cause, which clearly there's not an intervening cause here. Like, yeah, I was doing these things negligent, but then this other boat came by. I mean, that would have been an intervening cause, I guess. So maybe they could argue it that there's this evidence that another boat came by with a wake and that was the intervening cause. Maybe they should do that, but it just doesn't make any sense why, when the manslaughter is charged, and it's by a vessel or a vehicle, that it's not also a lesser there as well. I mean, I don't know.
Two important points. One is that the Supreme Court of Florida has specifically said in the query, the legislator intended and did create a lesser included offense with a lesser standard of proof required for conviction. There's no doubt the Supreme Court has said that. That's how they've upheld this distinction between the two statutes. Second, in Perez, there was a theory of consistency, and that is that he may have been reckless at one moment in time, not causing death. He may have been reckless at another moment in time, actually causing death. And the jury could evaluate the two scenarios independently. More importantly, the Court of Appeals seemed to say it wouldn't matter anyway, because on appeal, standard of review, we assume the jury acted out of lenity, not logically. Going forward, though, looking prospectively, the court should be trying to make sure the jury does act logically. And to say that it's okay, let's send it in there and we'll let the Court of Appeals justify an illogical outcome seems to be a result-oriented approach that is not what the law should be.
No, but isn't it because there are both theories that the state operates under in making an argument, okay? If vessel homicide, recklessness needs to be proven.
Only recklessness needs to be
Okay,
proven.
right, okay. And that is in line with what would be the greater offense, manslaughter, under culpable negligence, right?
So
No,
far, so good, I agree.
But
Wait. No, I meant wait, like I was not for me. Sorry. But
if the jury does not find vessel homicide under only recklessness,
Yep.
okay, that line, why couldn't a jury still find manslaughter under intentional act?
Because intentional is even more serious than
Reckless.
reckless and culpable negligence. It's intentional. It was an intentional act to strike the marker, not as a result of just driving culpably negligent or recklessly. So that's should be the absolute highest level of mens rea. It's like voluntary manslaughter. as opposed to involuntary manslaughter.
That is what the case law says too.
Just, it makes no logical sense. It's not a possibility logically or legally that a court of appeals will sustain it and forgive the jury for acting
No,
illogically.
but intentionally committed an act or acts that caused the death. Again, I think it's the difference in the intentional acts being the intentional act of speeding or going fast, the intentional act of
Yeah, good luck finding another one, Your Honor.
It has to be an intentional
Just
act
stay
that caused the death.
silent. I hate when he does
That's why we had
that.
this conversation
When
2
she
hours
can't-
ago.
That's right.
And now it comes to a head.
If she looks confused, then
Right, and she's sitting there trying to come up with another act. What's the other act that he could have done? Like, just let her sit there and try and realize she cannot come up with one.
Totally. Struggle bus all the way there. Like, why are you helping her reach some kind of answer when she clearly can't do it? I've been
So,
listening.
babe,
Frustrating. It's
oh,
very
so-
frustrating.
Did you hear me clarify that it's like the law in Florida is clear that the non-homicide lesser included, like the culpable manslaughter, although a lesser included of vessel homicide and vehicular homicide is not an available lesser included to manslaughter unless there's a dispute about an intervening cause.
So wait, you're saying that
That whole misdemeanor culpable negligence thing we were talking about?
you're talking about 78 or 784.05.
Right.
That's the
Exactly.
misdemeanor.
Wow, how'd you remember that?
Because I'm like I just play stupid.
Oh, you never
know
play
that.
stupid. I know how
Uh-huh,
smart you
uh-huh.
are, but still, that
Yeah.
was like the statute number.
Yeah. Well, I had been reading when they were trying to potentially adopt the definition of culpable negligence from that. I was I read through it multiple times, so it just for whatever reason stuck. Yeah, I'm worried. I'm worried with how this is going. Like, this is going to be a perfect example of how jury instructions lead to a conviction.
and then get kicked up to the appeals court.
Yeah, which, if we're to take anything from the 13 or 14 cases Howard cited in his JOA, it's going to get kicked back. She doesn't care. It's like, I don't know if you were on yet yesterday, Kat, when I asked Judge Erskine about that concept. Like, I'd always been curious with regard to judges, how much them getting kicked back on a reversal mattered to them in terms of kind of their appellate record. And at least Judge Erskine was like, look, if it's a borderline thing and I'm feeling it, I'm willing to take the shot. You know what I'm saying? It's like, because I was giving an example.
I think
wherein-
that's rare, though. I think her stance that if it's borderline, I mean, that just sounds like a narrow. If your discretion is this, you're like, oh, if it's borderline, that's narrow. I think that's very different than the judges that are like, well, I'm gonna go like right here, and I'm gonna see if they can tell me if I'm wrong,
Right.
rather than
Right.
actually looking at case law and trying to figure out if I actually have the discretion to do this.
Yeah. I mean, Judge Mendez here is just, Tinkler Mendez is just going from the gut. Like, she's just adopting everything that the state says. It's super annoying.
Yeah.
Like, because, I cannot stand how disingenuous Laura Adams is. Like acting like, everything that's falling the state's way, which is almost, to me, ensuring a guilty verdict here on one for sure. Yeah, like, because it's that thing where I agree with Howard, like the bullshit with the life jackets and the fact that there was booze being like, none of that has anything to do with whether or not he was culpably negligent in terms of hitting that pylon. Nothing. That's all after the fact shit. I'm sure if you were to ask George Pino today, hey man, like, what do you think? Should the girls wear life jackets? Yeah. Should you maybe slow down to like 30? Maybe. He'd say, yeah, probably in retrospect. But hindsight's always 2020. You know, to me, there was nothing unusual about the speed he was doing. Every single boater out there does the same shit. Every single boater has tons of kids on their shit all the time. Like nothing that was happening was out of the ordinary or extraordinary at all. If we were to go down to there, like to that area this weekend, I guarantee you I could film all day. Boats filled
Father's Day
with
weekend.
I mean, that's just there's nothing unusual about what was happening. There was nothing that was inherently negligent in what he was doing, and Howard's point about you're trying to use things that aren't the law, such as a requirement that they have. Like in Illinois, we have certain laws about wearing life jackets, when you're on a boat. Like so every state is different and they're trying to impute negligence on him for something that's not a law. You know what I'm saying? It's like, and they're doing it over and over and over again. And whether or not the girls would have been in, a better, I'd say, but for the intervening cause of her hitting her head, which seems apparent because of the fiberglass that they found in her like embedded into her skull. She's surviving. It was the injury, I think, to the head that knocked her out to the point where, I mean, I missed the ME. What was the actual cause of death? Was it drowning?
Complications from drowning.
What does that mean? That sounds
He
like
said it's basically the same thing as drowning, but they were able to restart her heart and they tried to keep her alive, but she never actually regained consciousness. And she ultimately died from those complications, but it was the drowning that caused those organ failures that she could never recover from. And then, yeah.
And
So
so
it's drowning.
ultimately,
He said it's the same thing as drowning, but he likes to be more precise.
was there an actual wound on the head?
There were several wounds on the head, contusions he was describing. But so his cause of death was not blunt force trauma, but the point that you're trying to illustrate is the blunt force trauma occurred. Maybe she knocked out, and then that's why she couldn't get to the surface like the other girls were able to do. And, if everybody's looking for people flailing in the water and trying to make sure they can pull them up and get them onto this rescue boat, this Good Samaritan boat that came about, she also wouldn't have been visible because she wasn't capable of making the motion.
Right. I mean,
and I guess that's where the argument of a life jacket could come into play. Like maybe she would float, but if the boat's capsizing and you're still
she's
on the
underneath
boat,
the boat, her floating means nothing.
you're going to be not visible either.
Well, and she's pinned under if she's pinned under the boat, she's pinned under the boat. The life vest isn't going to do anything about that.
It might make it worse.
It probably would make it worse. It's like there's those situations where wearing a seatbelt in a certain type of crash pins you in the car. I mean, it's like it's not all like in terms of you going through the front windshield. Yes, it's helpful. In terms of if you're T-boned, I don't know that it's helpful. Because it like if you're T-boned, it's as soon as the contact hits, if you have the kind of seatbelts that restrict automatically, you're trapped. Like you're trapped in that position where you might otherwise be able to lean over if you're passenger side into the driver's side so you're not getting killed. You know what I mean? So it's like, I don't know.
I think the problem is her argument, and she's going to argue it during closing. Even if there's objections, she's going to argue it. It could very well appeal to the jurors, even though it's not like if the girls were wearing life jackets, would that have stopped the elision?
No.
And that's really the question, right? And
Exactly.
the defense, Howard has tried to clarify the question over and over
and over and over
question,
again.
even according to the state's theory, is that the issue is the elision, that he was negligent in causing this crash. But the state keeps turning it into Lucy would not have lost her life if you did these other things that aren't directly related to the cause of the crash.
After the fact. Ex post facto. None of that shit matters. Because at the end of the day, what he's on trial for is the collision itself, not the aftermath. The aftermath is what caused him to be charged because somebody died. But the issue that the jury needs to decide is the elision itself. And if he did anything that was, culpably negligent, which I still don't know what it means. I still don't know what it means. If he doesn't see, I'm going to die on this hill. If he doesn't see that thing, then I don't know how you're, for whatever reason, I don't know. Glare. He looked down. He was distracted. Being distracted, that's straight up just negligence. Like that is not culpable negligence. That's not rising to that level. It's just not. And I think it's abundantly clear something distracted that man. I don't know what it was. I have no idea, but it's clear to me he didn't see it. Otherwise he would have clearly avoided it. Like that, no one's arguing to me that he was so intoxicated that he was seeing two. Oh, I was seeing two of my double vision. I couldn't tell which one was which, and I guessed wrong. That's not the thing here. I mean, he was not. I mean, I guess I can't say definitively because of the shitty investigation, but 3 hours later, a 0.00 is pretty indicative that this guy wasn't hammered. Like that's just not how the BAC is going to work. It's going to take longer. If he's 2 times the legal limit, like a 0.16, he's still going to have booze in his blood 3 hours later. I would argue even at
But we didn't get into
0.08.
that on the record.
Hmm?
That didn't really come in on the record, so that was
I
just
know.
like outside of court.
I know. Well, it's like, I mean, how was it? How was it going to come in? Like they could, it was like the mentions of 2 beers. That's the evidence. Oh yeah, he had a couple of beers. Like they didn't put any evidence. They couldn't put any evidence on it. Otherwise they're charging with the BUI. It's a confounding case. It's like, are you telling the people, honey, that usually jury instruction conference as is to really 2 instructions typically doesn't take 5 hours? You're muted. It's like,
I have not been telling them that, but yes, your point is very well taken.
it goes to the heart of the problem with this case. It just does. You've got a judge who is clearly pliable to the state. They can kind of form her however they want, like a little Play-Doh doll up there. And, she's not doing any independent thinking. And I agree with Ali. It's one thing to give great deference to the court as a general proposition, but sometimes you got to get in that
fight.
ass. You got to get in that ass.
Exactly.
I mean,
Get in that
you
ass.
do get in that ass. Like, I'm like, Judge, I love you, but and then go at her. You got to make the arguments like more forcefully, because she cuts him off a lot, assuming she knows what he's going to say.
Or
Like the
she
thing
rules
where he's like,
before you
"Oh, I'm
speak.
going to start with the one thing," and then she's like, instead of starting with number 1, remember that, like early on, he's like, he went to like number 2 or number 3 contained within the statute, and then so she immediately jumped to some assumption that was wrong. And I'm like, dude, just stick with 1. Stick with what the issue is. Like, don't try to clarify the other shit that we don't care about. Go right to the issue that is the issue first. I mean, my vote, based on everything that I've heard, is guilty. Not because I think that he is. I think that he is
Because
not
they're
guilty.
basically making it a regular negligence can get you there.
I mean, what did they ever decide? What did she rule on with respect to the homicide instruction, the straight up homicide
For
instruction?
the excusable.
Yeah.
So, well, I clipped that part. I linked you to it on X to go watch. So the judge realized that under 7.7, the defense can make the concession that they don't want that language instructed, finally.
So they
And
got it.
immediately when that happened, the state was like, oh, but that's such an important thing. George Pino really needs to consent to that, and he's not here today. So, and then we get into the judge is
Wow.
like, well, I would expect that we'll get confirmation, but I expect that the defense attorneys expect that he'll agree
Oh yeah.
with this
Thank-
guidance. And that's when the state was like, oh, but he hasn't been good this whole trial of following the instructions because he's been emoting in the court.
Wow. She is such a schmuck. I can't like she just rubs me the wrong way. Like
It's in the private
she's
chat if
like
you want to
she's
watch
trying to
it.
come off like a do-gooder, you know, like the pearl clutching do-gooder who's acting like George Pino's Hannibal Lecter. She's trying to turn him into a monster. This isn't a he's a monster case. It's just not. I mean,
But the way she's charging it, because she's charging it up here, she needs it to be a monster case.
100%. But there's a disconnect because he's not a monster. And he loved all those girls that were on the boat. It would be the exact same thing as every one of Scarlett's little friends that have been growing up in our house, around our house for years. And God forbid, like I had taken them out for Scarlett's birthday last year where we went on a boat. God forbid I did something that ended up in one of the kids getting maimed or worse. You know, I'd be destroyed. I'd be absolutely destroyed. You know what I mean? It's like, I don't know. I don't know.
Yeah, and I think it's totally valid for a parent to be like to be dealing with grief and look at the other parent who may have caused something and be like, well, you still have your daughter. But I think it's wholly inappropriate for a prosecutor to elicit that as testimony in front of a jury.
Repeatedly.
Yeah. Like, 'cause
Vanna
it's just
Whiting a
sympathy.
picture of Lucy in front of the jury repeatedly. I mean, how many times? Why Howard's not objecting every time she was parading Lucy's giant, shiny picture in front of the jury as she walks down the entire row of folks, you know, over and over and over again. It's like it doesn't have to be different photographs in order to reach that level of more prejudicial than probative. It can be showing the same photograph over and over and over again. You know what I mean? Because it's accomplishing the same thing. I would argue that that photograph in particular is the most damaging. It's
Yeah,
like
and I would argue that it's implicitly an argument that but for the question that we just asked where somebody just testified that, oh yeah, 45, 47 would be like full throttle for that boat with those girls, which is a conclusion of an opinion. That's an opinion, not anything that's like tangibly established. And then parading a picture like that, do you recognize this girl? It just makes it seem like she'd still be here, except for the thing we just asked you about in the previous set of questions.
right.
And again, that takes us away from culpable negligence causing a lesion to culpable negligence, Lucy gone.
Yeah, I mean, I'm with you. I'm 100% with you. Yeah, so I think Discord is pointing out that he took a precaution according to her argument. Oh, by telling the girls to sit?
Yeah, so wouldn't that be? And she took creative licensing with that and said
Who
that
did,
he said
Laura?
that because he was going to speed. Yeah, she said she was arguing that he even instructed the girls to sit down because he was about to go faster, when that wasn't the testimony.
What was the
She
testimony?
inserted just that he had us sit down. It was just, did he have you sit down on the boat?
Yeah. I mean,
So she took creative licensing to give it a because, and then the judge, like randomly later, repeated that argument for another matter.
right.
Like she
he made it like
adopted it.
like
It's
it
not
was
even on the
some kind
record.
of major announcement. I mean, I can tell you, like on the occasions that I am captaining a boat, and like again, if we're doing tubing or whatever, I've got 5 or 6 girls in there. When I'm about to hit the throttle, I'm like, y'all might want to sit down. I'm about to start going. You know what I mean? It's a super casual. It's not everyone must sit. It's not some kind of major
We who
declaration or
labor here.
precaution. I'm like, you might end up flying off the boat when I gun the throttle here. You know what I'm saying? So it's just it's a thing, you know.
Well, but if
That
you're taking precautions, you're not just
yeah,
like that. That seems like
culpably
you're
negligent.
taking reasonable care.
Right. It seems like it. It seems like it. It seems like that's the opposite of culpable negligence. I mean, what's good for the goose is good for the gander. I mean, Howard should certainly argue it that way. If they're going to make it sound like that, like he was, you know, like I'm making a captain speaking.
He can
Everyone
only do
needs
that
to
if
get
she
into
does
their
it in
spaces.
closing. She like, because it's not really on the record, so she would have to make the argument in closing. And I wonder if he would object.
I'm saying Howard should adopt it.
But can he adopt it before Laura actually argues it?
Well, I mean, it depends. I don't know. In Florida, what do they do? Do they do the state defense rebuttal, or is it defense state?
They're gonna. I'm sure the state's gonna take the option to do a rebuttal. So they have the option. I'm sure they'll take it. I'm sure it could be just as long as their initial argument.
Totally. Well, I mean, she's gonna, she's obviously. I mean, there's no part of you that thinks that she's handing the reins to either of those closings over to what's his face, right? Yeah, she's doing all of it. I'd be willing to bet on it. She's definitely not handing any of that over to him. Like, you could tell. Like, has he done anything? Like, did he direct like maybe two witnesses?
He directed a witness, and then Laura took over on redirect. You don't remember that?
Yeah, I do remember that.
Like, just metaphorically shoving him out of the way and saying, "I got this, borscht."
Yeah, it's all right, champ. Good try. The queen's gonna take over now. You need to go sit in your chair.
Well, I'm hitting play.
Do it.
Let's go, Bob.
Because the state is resisting the reality of McCreary, not reality, but the stated position of the Supreme Court of Florida McCreary, that vessel homicide is a lesser included offense of the manslaughter.
But what I don't think is connecting right now is that the state is not relying on that as a lesser included. We've separately charged it so that the jury can make their own finding as to each count, as to each charge and the information.
Okay, so let me ask this. Could the defense, if they asked for a lesser under manslaughter, could they ask for a lesser of culpable negligence?
If they wanted to, as a category 2, have a lesser, yes. I just didn't hear them asking for a lesser
I'm
under
just
instruction.
right.
I wouldn't fight against that. If they want culpable negligence as a lesser of manslaughter, no problem.
I thought that Allison said they couldn't do it.
Look at borscht.
Didn't Allison say they couldn't do that? That they couldn't put the misdemeanor?
But that would go back to the instruction that you had proposed as a special rather than a separate.
Could you please repeat that? I'm sorry.
And it wouldn't apply because
Can't hear her.
the lesser one isn't included when it's not to be used unless there's a death here, so it can't be a lesser.
But speaking of lessers, there is the original misdemeanor charge that was brought against Mr. Pino, that failure to abide by the navigation rules resulting in an accident or in a boat crash that causes death. We would submit, particularly given now that the jury is hearing navigation rules, that lesser included offense be made available to Mr. Pino.
Okay.
Under manslaughter as a lesser? It's not a cat 1 or cat 2. It's not a lesser included of.
Vessel homicide.
Is it a lesser included of vessel homicide? Did you check and see? Vessel homicide is 7.9, right?
I think it's characterized as a permissive lesser included.
No, it's not. It's not a statutory lesser. It's not.
Judge, the statute is 327.33.
What's that? I'm sorry?
The statute is 327.33
Right.
under, which is listed here on this table, under reckless driving.
That's a separate charge though. It's not a lesser of vessel homicide or the state didn't charge it. So it's not a lesser. It's not a lesser of vessel homicide.
No, but counsel's right, Judge. 327.33 is the statute that provides the misdemeanor that if a defendant violates a navigational rule without operating the vessel recklessly and death or serious bodily injury results, that is a violation of 327.
Well, that's what your special instruction is. Well, your special instruction talks about navigation rules. 327. Go ahead. Oh, I see what you're saying. Reckless operation of vehicle, okay.
And under
28.19. As a category 2 lesser. 28.19. I don't think I've ever used this. Let's find it. 2819. Reckless. Okay, do you want, are you requesting that as a lesser?
What if they say no because Laura wanted it? What if it's reverse psychology?
I suppose we better confer with Mr. Pino about this, so we'll do that.
Oh, yeah, okay.
That makes things a little tricky, Judge, because, you know, we need to be able to plan our closing arguments based on what the jury instructions were gonna be, which I
Yeah, I
thought we
know,
would be
okay.
able
We'll
to.
do it
So-
today, we'll do it now.
Okay.
We take a break, we can do it.
Yeah,
now.
so I think we're ready to take a break.
Perfect.
Why don't you go, let's take a break.
Oh. If your court has one more minute, Mr. Arbolino located where the court discussed the issue of instructing the jury on the personal flotation devices.
Uh-huh.
Yeah, if you want it, I can play the video for you from court.
Sure.
Put it on the microphone, I guess. Are these on?
You just put, you want to just,
Or just so we should- Okay. So this is from day 3 on Court
Gonna
TV on
play it.
YouTube at 5 hours, 11 minutes.
okay.
What is the law in Florida as to who must wear a personal flotation device? Minors under a certain age.
That was from Sergeant Delgado. I'm not sure if that was also broached with Officer Alver, with Paul Alver.
I think that was a different witness, right?
Correct, that was Sergeant Delgado, not
It was.
Paul Alver.
But the question was, what is the law in Florida as to personal flotation devices? And the court sustained an objection to that question and noted to the jury that it would be instructed.
I'm not going to instruct the jury because I'm not going to do that. I anticipated and knew actually also that would come out through what's his name, Albert. So,
What?
but you found out that it wasn't intended at that point at all that I would instruct the jury, special, because I knew that was going to be coming up later on.
We still requested it based on that.
Okay, that's fine. Thank you. And if you find the portion of when Albert was testifying about it, and there were questions about it, then you'll find in the record that the jury did hear that it is not the law, and in fact there was more detail. Only a person under the age of whatever details he went into are required to wear a personal flotation device. So the jury heard it without objection through the witness, and so I don't need to instruct them specifically. Thank you. All right, so you gonna let me know about 28.19?
Yes. Can we recess for
Yeah.
15 minutes?
Sure. Because we're pretty much finished with the instructions. At this point, I think other than whether, well, I need to know that, I need to have him on Zoom basically to let me know about everything in terms of what we discussed on the instructor charge conference today, and specifically on the lesser.
Your Honor, the instruction 28.19
Yes.
is as to 327.33 subsection 1.
Okay.
But the provision that they're talking about is 327.33 subsection 3.
Oh,
And so I don't think that there is a standard jury instruction for that offense. I mean, certainly we can craft one if the defense wants that as a lesser. But the
Oh, I see.
28.19 is reckless operation of a vessel, which is not the same as violating a navigational rule, but not operating recklessly, and a death or serious bodily injury results.
yeah, that's the only one that actually makes reference, but it's a different subsection of the statute. But again, if you craft one, and we'll review it, if your client wants that, to be included as a category 2 lesser. I guess the question's gonna be, I guess I'll consider that down the road. You know, what a potential punishment would be if a jury came back on a crafted lesser.
Well, it would be a second-degree misdemeanor. That particular subsection is a second-degree misdemeanor.
Okay, well, that's what it was originally charged as, right?
Yes, Your Honor.
Okay. Okay. Because it was you were charged under subsection 3.
Yes.
3, I think,
3A.
3A.
Okay. All right, well, let's take a break. Thank you.
Take a break.
Take a break.
What?
They want to add a different lesser included now under 327.33.
The navigational
subsection
rules.
3A. Yes, which is what he was initially charged with.
Yeah,
Second degree
it kind of
misdemeanor.
makes me nervous that Laura Adams was like, "Oh,
So happy
oh,
about it.
Yeah, okay, fine, good." She's like,
I think her stance is that it's going to spell out the navigational rules and get her the jury instruction, the special instructions on the navigational rules in. Because now the jury needs to understand what that would entail.
"Yeah, Howard may want to rethink that one." Because I think that murks all the shit up.
I
Like-
think they're worried at this point because remember this is going to attach under the I believe under the manslaughter because that got confusing there. I think they might be pivoting to this strategy because everything else was denied. Nothing that they've asked for has been granted, and it looks like whatever the state asked for is going to be granted anyway. So maybe it's a strategic decision at this point based on how everything else has proceeded. If it was initially the strategy, I believe they would have asked for it when they were discussing the manslaughter. So, but
Yeah.
maybe not. Maybe it's
No,
just like,
I
oh,
don't
we just
disagree
saw
with
this
that
thing.
proposition at all. I think that's probably what's going through your head. I mean, it's not too far afield from what they did with Reed. You know, I mean, that was ultimately the defense asking for that DUI charge
Yeah.
to be included, and ultimately that gave the jury the thing to hang their hat on, which they did. You know, and ultimately it's kind of the same concept here. I'm sure George would be fine with taking the ding on the what does that carry? That's a misdemeanor, right?
Yeah, so it can't be more than a year.
Correct.
So
And that's you know, like, I don't know what this judge would do, but you know, if I'm the judge in this case and he was convicted on a misdemeanor, I'm looking at the fact that this guy is paid huge amounts of restitution. He's clearly going through it. You know, I mean, it is, if you're to believe the testimony of his wife, which I have no reason not to, he's a different person. You know, this like altered his life in a profound way. You know, I mean, sticking his ass in jail for 6 months ain't doing shit. You know, it's like I don't know. Sometimes the conviction itself is enough. You know, maybe you throw on some community service shit. I don't know. He's got to serve on some kind of victim impact panel for 6 months, talking about boating safety or whatever. I don't know.
would they have him serve? Would they have the perpetrator serve on an impact panel?
They could.
Why's he got a hat? Hold on. What is this?
Yeah, they absolutely. Wow. It's like a beanie. thinks
He knows he's walking in to show it off. He's waiting for people to acknowledge it, I think. Look at him.
He's like, "What's up? What's up?"
Right now, he reminds me of Teddy from Bob's Burgers. The chat just wanted to bloop through that, I'm sure.
Oh,
Look
chat.
what we would have missed.
Oh yeah.
He's
We
like,
would've-
he's about to put himself at the podium.
Well, if Allie was here, she would
So
definitely.
we spoke to Mr. Pino. Ready to go on the record?
Yes.
Okay, we spoke to Mr. Pino, and he's going to decline the lesser included offense.
Okay, he's declining it.
There were a couple of other things that,
Wait.
The concession.
a few other things.
Pino declined.
So
Pino
he,
doesn't want to do
he
it.
declined the navigational lesser included.
And I think the judge is about to ask about the next thing for the concession for the excusable homicide language.
Exactly. That's the
Discuss
more
with Mr.
important.
Pino.
I told him that there were jury instructions that we had requested, He made very clear he's deferring to his legal counsel because he doesn't have legal training, and so he is putting his confidence in our legal team.
Okay, so I'll get that confirmation, I guess.
We can do it now. He's available by phone, or we can have him go in by Zoom as you wish, Judge.
Okay. Yeah, let him come on Zoom.
Okay?
I have the Zoom open.
Okay.
So it says in the you can send them a Zoom.
Sure. Also, just look at,
We want to put him on our Zoom.
I want to make sure, again, you know, because I don't recall a circumstance where I've had a trial where there was a death where I did not instruct on both justifiable and excusable homicide. I don't remember ever not instructing. Now, I understand that you all agree and stipulate, but I don't want this to come back around where it's fundamental error not to instruct when there's a manslaughter charge on justifiable homicide, even if it's not applicable.
I thought I heard you read something that made it sound like it can be waived.
7.7.
Yes.
I did read something like that, but I'm just sharing with you the slight
Concern.
hesitation I have. And that's something that I'm going to ask Mr. Pino as well, because should there be, you know, I don't know, I want to make sure that's not, would be a fundamental issue. And I don't know if you've seen anything on that. I want to confirm it's not fundamental.
Yeah, you're gonna ask
I
the
will tell
defendant
court,
if he's
I am
convicted.
very uncomfortable with the
gonna
court
get an
not giving
automatic,
the entire
retrial.
introduction to
He's gonna
homicide.
care.
and
Okay, good luck with that. Sure. I mean, if they're going to convict me and put me in prison, you're telling me I can get an automatic redo because structural error. I'll take it. Thank you. Yes, I want you to definitely not include the justifiable homicide instruction. Thank you. The judge is
I don't know.
still, babe, is still, you know,
The
kerfuffling.
judge is asking the state to tell her if there's any way she can not pay attention to the 7.7 permissible concession.
I mean, I think she's doing it because she doesn't think that there is. Maybe.
I want to make sure that's not, would be a fundamental issue. And I don't know if you've seen anything on that. I want to confirm it's not fundamental.
It says it
will
right
tell the
there.
court, I am very uncomfortable with the court not giving the entire introduction to homicide instruction.
Okay.
I'm very uncomfortable with it. I do think that the defense potentially can waive that, but I think it leaves us with a possibility if something
don't
were to
want-
happen, if he was convicted, that there could be some kind of post-trial litigation on that issue. I think the safe thing to do is do what the instructions tell the court to do, which is to give in all, I mean, it's called introduction to homicide, not,
Okay. I'm gonna probably continue to mull that over. I don't think it's gonna necessarily
But then you're not going to be able to ask
cause
him for
a
permission today.
impact anyone's closing argument. Other than if I choose to give the full instruction as part of the standard, I don't want to be in a position where there's potential fundamental error. That's where my issue, that's where I was thinking about while we took a break, even if there's a waiver. And even if I did read something, because it made it seem like it can be done, but
Then how can it be structural? No appellate court's gonna, if
over
it
the
can be
weekend I'll
done,
probably
they're not gonna
be sending you all an email to,
find it to be a structural error. I mean, I thought that language was very clear.
Yeah.
advise you what.
Laura does it.
No, I think it's, you know, very
What's
good.
getting like her all worked up is that, you know, the language from 7.7 section 782.07 where it says it is fundamental error not to instruct on justifiable and excusable homicide in the absence of an express, like as soon as she sees the fundamental error, she stops reading. She doesn't care what the rest of the sentence says.
It's crazy.
Even though she asked, but then when she read that earlier, she stopped and asked for a concession specifically on the justifiable part to get both parties to say it was a concession. But then, what I felt like she was doing in that moment was like she was, then once she finally did get past the word fundamental and read that there's an option where there can be a defense concession,
Right.
she morphed it to it should probably be both parties agreeing to it. And if not, then I can't read this statute to say what it actually says.
Yeah. Yeah.
I mean, but it also says it's, like, not a fundamental error instead of saying, like, it's not an error. It's like, you still shouldn't do it, but it's not gonna be fundamental, is, like, kind of what that might be triggering as well, but it's clear that it's not a fundamental error.
Yeah, I mean, if anything, it's harmless, is provided that they have the express concession. I
Right.
don't disagree with her getting both parties to, to make the concession. I think is a good idea. The state and Pino, I mean, I think that bolsters the argument, like that there was no reason to read either of those instructions because they're inapplicable.
Well, but I'm saying like if it comes down to the state opposes this being, the state wants this read
Yeah,
as
for
is.
sure. Right.
So the state's not going to give a concession on this. But does that mean the defense can't waive?
Oh, yeah. I mean,
And that's what I'm saying. I think that's what
it's a
the
little
judge is leaning
vague.
into.
It's a little vague as to who has to give the concession. Is it one? Is it the other, or is it both? Vagueness in the law is never good. Vagueness in the law is never good. Void for vagueness.
As you might guess, we'll be working all weekend, and if there's a time the court wants to do a Zoom or phone with us, we'll be available at your call, whenever you'd like to do that.
Okay, all right.
And we're getting Mr. Pino on the Zoom.
Okay, good.
All right, I'm out. I'll see you.
Why?
I'm going to watch our Metro tournament, even though
He's
we're
on
not-
your Zoom.
Yeah.
What?
Okay.
going to watch our community's team. Like
Oh,
I
okay.
coach 7 of the girls on the team. I want to go watch those games.
Well,
Oh,
when does
okay.
it start?
All right,
5:45.
very good.
Where is it?
Mr. Pino,
Prairie.
Well, it's about to end. Just wait for
Hold on
me.
one second, Mr. Pino, we're gonna get the
let's get the audio,
volume.
we'll get the audio set up. Can you hear me? Okay, I can't hear you yet. I'm working
Hold on, Mr. Pino, we cannot hear you.
Maybe he's on mute.
Get a speaker on that.
You know, if Mr. Pino wants to come into my Zoom, he can come into my Zoom. And then,
Can you send Mr. Pino the Zoom address for the judge? What's that, Bill?
Put the volume up.
it might just be easier to do that. Mr. Pino, you can hear me, but we can't hear you, so I'm trying to make this easier.
Yeah, it ends in like 2 seconds,
Make
guys.
sure you're not on mute, Mr. Pino.
He's not.
She going.
He's not.
Wow.
Let's see if when they actually get them on.
You said no?
Well,
Thank you.
Jordan number that I sent it to Arthur.
Man, he's really sporting that do-rag a lot. He's leaning into that thing.
Oh, he's coming out. Best time. Yeah, he's on. Zoom? Hi, okay, good. All right, so I see Mr. Pino, he's
Sorry.
on my Zoom, and just gonna ask a couple of questions. Can you raise your right hand, sir? You swear affirm any testimony you will be the truth, whole truth, nothing but the truth?
I do, Your Honor.
Very well, thank you. You can put your hand down. So we've been going
Thank you, Your
through,
Honor.
we've been going through this afternoon the jury instructions, and we spent several hours on them. And I wanted to confirm a few things. Counsel, why don't you ask your client the questions for me?
Sure.
Okay.
Mr. Pino, can you hear me? This is Howard Srudnick.
Yes, good afternoon, Howard. I can hear you perfectly.
Good afternoon. So we've been here since 1 o'clock. Your defense team, including Mr. Shapiro, Mr. Armelino, Ms. Klein, we've been going through the proposed jury instructions, those proposed by us, those proposed by the state, and judge has ruled on our requested instructions, those of the state. And we've informed her that you have told us that you would abide by the advice that we have given you on the requested instructions, that you've deferred to us because you don't have any legal background, and that you were relying on our experience and advice in how to best present those instructions for the court's consideration. As well, we've informed you that there was a discussion about a lesser included offense. It would have been the misdemeanor offense you were originally charged with, which brings a maximum sentence of 60 days in jail. It is not a felony. We discussed with you that option, and that you had advised us that you would not be seeking this lesser included offense at this time, which means that it
What?
won't be presented to the jury as an option for them to deliberate about. Did you understand everything I said, Mr. Pino?
I did, Howard.
And do you continue to prefer to follow the advice that we gave you, including declining the lesser included offense
They said
instruction?
That is not an express
Yes, I
concession.
did.
Is there anything else, Judge, you'd like me to ask Mr. Pino?
No, that is not an
No,
express concession.
That's not for 7.7. That is for the new lesser that they wanted to add to the
I-
manslaughter under
No.
327.333A, subsection
Right, but that
3A.
is a lesser to the manslaughter, which is like the jury instruction 7.7. So that would have been a lesser to the homicide charge,
Yeah.
and
George declined
they're
that.
declining it.
All
He
right,
doesn't
well,
want to go to jail for 60 days.
let's see if she gets to the.
I think they're
express
still doing the
concession.
lesser on the vessel homicide, but not the manslaughter.
Why not the manslaughter? That's the one that carries 30 years. Wow. Wow. These lawyers are really crazy. Fucking insane.
They
Wow,
were
they're-
with it, then said they wanted to speak to the
They're
counsel,
playing
came back
poker.
and said that George didn't want it. That's
They're rolling
I
the
mean-
dice. They're
Big
playing
time.
like
They're not
whoa.
they're not giving the jury anything to hang their hat on other than the big guys. It's the Karen Reed situation. You know, you throw the
Yeah, but
DUI in there just in case the jury needs to convict him on some shit. Well, there you go.
What is the downside? What is wrong with these people? Must be maybe something that Kat said, like it's going to let her start talking about all the violations of the
Navigational.
rules.
the special
Navigational
jury
rules.
instructions can now become, because you need to understand the navigational rules
But she
to
also
decide on this.
she would also be saying to them, this is for the only for the lesser included. Purposes of deciding the lesser included.
Yeah.
I don't know.
I think that, so the instructions, in terms of any objections you made, any special instructions, they're all adopted by Mr. Pino, and I want to be clear that this would satisfy as a
Express concession.
necessary part of the proceedings, an essential part that Mr. Pino actually needs to be present for, even though I did accept a waiver of his presence, because this is a critical part of the proceedings. I wanted to make sure that Mr. Pino understood why we have reached out to him today, so that down the road, we have a clear record that Mr. Pino is considered to have participated in this critical part of the proceedings.
Mr. Pino, did you hear the judge?
I heard everything very clearly.
And you recall that yesterday we spoke about the option of you either attending or not attending today's conference, that I explained to you these were legal matters, that the jury would not be here, and we discussed and you preferred to allow the lawyers to appear on your behalf so that you need not attend the proceedings even though you had the option to attend. Is that right?
That is correct.
Okay, yeah, and when we talk about this again, it just, I don't know what the future will hold. So there could not be a claim later on that, that something so important and fundamental that you were not present for, that there was, you couldn't object to it later on, basically, if there was any issues that came up.
I understand, Your Honor.
Okay, well, okay, I think I covered everything. State, do you have anything that you feel I needed to ask Mr. Pino?
I
Was
just
he
want to
making
verify
direct
whether any
concessions?
lesser included at all that the defense is seeking in this case.
Okay, so there are no lesser included instructions that the defense is seeking.
Yeah, culpable negligence to vehicular homicide or vessel homicide.
It's getting all of us, that vehicular and vessel thing.
One moment.
All right. Just stay with us if you would.
I
Okay,
thought the
I'm
question was
gonna
just
say
about the
this one
manslaughter
more
one.
time because she's wrapping her shit up.
Okay.
That is not an express concession. She needed George Pino to say, I'm expressly conceding that the instructions on justifiable and excusable homicide are not going to be read.
Right, or not
I
applicable.
mean, like him saying whatever he said that the lawyers he's deferring, it's not an express. Like, I'm just telling you. I'm just telling you.
I don't know if she's going to stick with that though, because she said she didn't even want his
Well, she's
to
definitely
hear
not
from.
going to stick to it now because that was not an express consent. If she's
But remember, she said she didn't even want to get into that issue with Mr. Pino right now because she wants to mull it over the weekend. So I think she's indeterminate on that particular matter.
all right, well,
Even though we know where she's going to come back and land, I think, but
All right, hit play.
all right, I'm going, babe.
Wait, she can bloop. Don't go. I'm about to be done. Come on.
I want to go. Like, why do you
No.
want to come?
Why not? There's no kids here. There's what? Wow.
they're getting George Pino's. They're still.
Lesser included offenses that are being solved.
While I have Mr. Pino here, I'm just gonna finish up with our charge conference. Mr. Pino, would please stay on our Zoom. And I think I had left off with, the one question on whether 3.12D, the legally interlocking counts instruction would be given. The state had objected, I believe, to my giving that instruction. And that goes back to the argument that was made that vessel homicide is a necessarily lesser included offense of the manslaughter, and therefore, if the jury came back with not guilty on vessel homicide, that they necessarily could not come back on a manslaughter. And Ms. Adams, if you had anything further on that, I don't know if you found any other cases or
She
anything else you
doesn't
wanted
just
to
get to
address on.
say I charged to a lesser separately, so it's not a lesser. It's still a lesser. Like legally.
Okay, come on, Laura.
I don't think it is a correct statement of the law that the jury cannot find the defendant not guilty of vehicular homicide, but guilty
She
of
said it.
manslaughter. They are not mutually exclusive crimes.
They are.
The vehicular homicide is not a lesser included offense of manslaughter by intentional
Force just
act.
distance himself.
Moreover, the state has has opted to charge them as two separate counts.
So what?
So the jury should make a separate finding as to each crime, and even if, under the Perez case, they made a finding or they decided to acquit the defendant of the charge of vessel homicide, they still could lawfully find him
I
guilty.
cannot hear you, Your Honor.
I'm sorry. You want to move that microphone up?
Oh.
I'm sorry.
Oh,
No,
boy.
you can just take the one on your desk and turn it on.
This is so
They are not
atypical
mutually
myself
exclusive crimes.
Because if I understood, again, on the manslaughter, there are two theories of prosecution, which is lawful, which would be the intentional act which resulted in death, or the culpable negligence. And that, if I understood, that was the state's position as to why they're not, first of all, they're not legally interlocking, and second, why the other requested instruction that a not guilty on the count 2 necessarily requires the jury to come back not guilty as to count 1. It would also impact how the verdict form would be prepared and read, because it would be, they would have to be instructed on, they would be instructed on count 2 first, on vessel homicide, and then there would have to be some statement in the verdict form, which is used in capital cases, where, you know, you stop here if you don't find the state has proven beyond reasonable doubt the vessel homicide.
And that's so distinct from what we're doing here. That's, you know, for sentencing purposes.
I understand.
So, I mean, to the extent that the state
Somebody tell her to shut up.
I made a choice in how I charged this, and I want the jury to make a separate finding as to each crime. And even if they were to say he's not guilty of the vessel homicide, the jury still has the option of finding him guilty of manslaughter. And there's nothing to say that that's illogical or not a lawful verdict that the jurors can have. Who knows, maybe they acquit him on both, I don't know. But what I do know is that these charges were separately filed, and the instruction that the court gives as to your verdict as to one charge should not impact your verdict as to the other. They are
It has to be
separate
treated
crimes.
as a separate crime charge.
Correct.
Okay.
And that jury instruction reflects the law, and I think that what the defense is seeking does not reflect the law.
Okay, I understand. And I understand the defense argument in this regard, and the request for not only the special instruction following the vessel homicide instruction, but also the instruction for 3.12D, legally interlocking counts.
Thank you, Judge. I think this also feeds into the verdict form.
And it's in the verdict form instruction
Right.
as well.
And so what I'm hoping the court can explain, if not to us, to the jury then, what is the difference between the vessel homicide and the manslaughter charge if the state is proceeding under two theories of manslaughter, intentional being the A, culpable negligence being the B.
But it's an or. It's an or.
Right, it's or, but this is what I'm struggling with, is that intentional is a higher level of mens rea than culpable negligence. So,
They're alternative ways in which, by law, the state can prove the manslaughter.
it's almost, I think it's culpable negligence is a lesser included of intentional. Logically. And so, and we know that McCreary has already said that vessel or vehicular homicide is a lesser included of manslaughter. That was the whole point of McCreary. So I'm still struggling to understand how the mere choice by a prosecutor to allege both theories under manslaughter allows them to then avoid what the Supreme Court has said.
I think it depends on, in terms of the evaluation of what intentional act means and how the jury is permitted to evaluate that. The intent to, again, the examples that were given, if the jury finds that the intent to operate at the speed that the vessel was operating at, the intent to, go through a point in the channel on, one side of the channel versus another, the act of a change of course at some point. Those are the acts, I think, that the phrase intentional act are modifying.
That's their theory, but it could either be...
That's the state's theory, of course.
So they've defined, however, they want to define the acts, whatever that group of acts are.
Mm-hmm.
Then the question, was it done intentionally or culpably negligently? It's still the same acts. They can't, I don't think one count can charge different acts within it.
Okay.
They have to...
I hear your argument. I understand it. I'm not agreeing with it. I'm going to instruct the jury as requested by the standard instructions. I'm not going to give a legally interlocking count instruction. And I'm also not going to give a special instruction advising the jury that a not guilty, if they should find not guilty on the vessel homicide, that necessarily requires them to find not guilty on the manslaughter.
I understand your ruling over objection. What I think the court has done at the state's invitation is said that vessel homicide and vehicular homicide are not lesser included offenses of the manslaughter by intentional act. That would be the logical conclusion, which I believe is inconsistent with McCreary, having said that that's exactly what the legislature intended by passing the vessel homicide statute.
Okay.
So that's,
That's our difference of interpretation of the court. Absolutely fine to do that, of course, and we have a good record.
And so, can I then, before we call it a day, bring us back to where I began? I still would like to be able to understand how the jury is going to differentiate between the two crimes if the difference under McCreary is that manslaughter has a greater degree of mens rea. It seems to me that the instructions don't accomplish that because they both deal with this conscious indifference. And so, given the court's rulings, I'm going to request again further instructions on the manslaughter to make clear that that's some greater level of depravity, I'll use that word loosely, than the mere recklessness. Otherwise, they sound the same to the jury when the instructions given.
And that was the additional language that you refer me to under the manslaughter instruction that you had provided to me.
Yes, sir.
Now, my rule is going to stay the same. I will review it again, as I do, over the weekend, and if there's anything that should change, I would certainly notify the parties of that. But either way, obviously it's good and interesting legal argument, and I think some of these matters could be matters of first impression anyway, and we have a good record. Okay.
She wants us to go to the
We're
appeals.
submitting the case to the jury, and will the jury have a clean laptop
Yes, I have one reserved.
And you'll make sure that the defense looks at the laptop, make sure it's a clean laptop.
Yep.
And for any digital evidence.
Yes.
Because I don't bring them out if they ask to see
All
digital.
right, I gotta go.
want them to have
All right, see you, Bob.
everything they need.
Hi,
and the jury
Ali is coming with
to
me.
be able to view
Okay, I'll
and
bloop you
listen
guys.
to all
All
of the
right, bye,
evidence.
everybody.
So I'm just, in my mind, thinking, documents, audio and
Then there
visual.
was one.
I want to make sure they have everything they need. So if I'm missing anything other than a clean laptop,
I will also have a DVD drive that can be plugged into the laptop because one of the items of evidence that was introduced was a DVD.
okay, good. Because it was in a DVD. Okay. I can't think of anything else.
There may be one other issue that now we have to address, which is unanimity as to the theory of manslaughter. 'Cause
Okay.
now, right, the state is proceeding under two different theories.
Which is, okay, so, right, whether or not there needs to be a special verdict where the jury would have to find unanimous as to
Well, for
either manslaughter
100%.
By an intentional act leading to the death or culpable negligence. Similar to if we have, I guess, a first-degree murder with premeditation, right?
I've never done a first degree murder.
Okay, premeditation or felony murder. I think I'm going to think of this as an argument along the same lines because I haven't researched the issue of whether or not with a manslaughter, with the alternate theories, whether or not a special verdict is necessitated.
At a minimum, I think at least a jury instruction that they must be unanimous as to whether it was an intentional act or culpable negligence.
I don't have any case law on that at all, and I invite anyone to find me a case that would require that. In fact, for the request, I'm going to leave it at that. Right now, I'm going to decline to do that, or to create a special verdict form to do that. But if anyone, state or defense, should find any kind of legal authority that would require a special verdict, I would love to see that. You'll see this now in the context of, enhancements. It comes in for the purpose of sentencing. In the cases that you're going to find where there are special verdicts, it has to do with if there would be enhancements for a jury to make. A jury would have to make a special finding for certain enhancements. That's where you'll find the cases that talk about special verdicts. Okay? So if you find anything, I'd love to see it. I've not seen it before, but because when we talk, even it has been a lot of discussion over the years in murder cases over felony murder versus premeditated. And while it continues to be
I
an issue
disagree
that,
with her. If I'm understanding this correctly, she's saying that, well, I'm aware if there's an aggravating factor, it needs to be determined by the jury. Like, yes, a firearm was used for when it's an aggravating factor, not something baked into the underlying charge. But she seems to be saying that special verdict forms she's never heard of that being used for alternative theories of prosecution. And I'm just shocked to hear her say that. Because I don't think that's the case. Maybe it's a weird Florida thing that I'm not aware of, but like I've watched plenty of other cases where there's been special verdict forms because of alternate theories. I missed the chat because I would ask the chat right now.
defense counsel raised, I think the Supreme Court has maintained the position that there is no special verdict for the jury to find unanimously either a felony murder or a premeditated murder. So I'll leave you all with that, and I will see everyone at 9:30. We'll start up 30 minutes. At least we should meet 30 minutes before, and I have coverage, so we'll be good to go.
I will just, I have I think a small table that I would like to bring with me to the courtroom just because.
I can't hear you, Honor.
Okay, I'm sorry. I think counsel was going to bring a table to set up in the courtroom, I guess, so that the evidence could be kind of, instead of going back and forth, and I think everyone might have access to it, right? If you bring a table here?
I would share it.
You would share it?
Of course.
Very good. So it just makes it easier to set up any evidence on that table as opposed to coming back and forth to the clerk. So that's fine, and I think
Alright,
that would be
they're
fine with
closing
defense
this
because we're gonna share. Okay,
Judge, what schedule are
ready
you
to come
proposing
back,
in
Chad.
terms of where we're going to break during the course of the
okay.
closing?
I propose, you think tell me how you think you're gonna break up your closing, generally.
I think probably, if I would need maybe about an hour or so for
I cannot
my,
hear you, Your Honor.
I think I would need about an hour or so for my initial close.
About an hour or so.
And again, I would reserve about 30 minutes perhaps for rebuttal.
I will tell you, I do not put time restrictions on, I don't do any opening, I don't do any close, I don't do that. So if you're a little bit over, a little bit under, I plan to give you a couple of hours. I think you all indicated you wouldn't need more than 2 hours, but I'm not gonna put a restriction. So you're gonna break it up, and what I think would happen is, after the state's first close, we would take a break. You can then figure out how you wanna set up the evidence, and then the jury will come back. You do your close in its entirety. And then what's gonna happen is, we're gonna have to break for lunch at some point. That's probably when we're gonna break for lunch, okay? And after you finish your close, we're gonna come back, and the state, I'd like to see if we could finish the state's rebuttal close before I break for lunch, but I don't know that that's gonna happen.
If the state is about an hour, I think I'll be about an hour, in which case I think we can get them all done.
If that's the case, that's fine, but I don't wanna break too late for lunch, because I have to have a break for lunch, and then instruct the jury. And I need to get them out and instructed, I would say, no later than 2:30, 3 o'clock, and get them working. And I don't tell them this, but I'll keep them working. I'll order them dinner and not interrupt their working until they're gonna turn the lights out on us, which is about 8:30 or so, okay? And at that point, if we don't have a verdict, they come in, I instruct them, they come back, and they go right back into the jury room the next day. They don't even see us. They're just taken right back into the jury room by Renee. And in fact, this courtroom is, while the jury is in the jury room, no one's permitted in the courtroom, except for Renee. And the clerk could sit here, and Vanessa could sit here, but no parties, no spectators. The room is clear. And so, once they start deliberating, we're not gonna have anyone in this courtroom unless there's a question, and we'll all be in the courtroom, and/or we have a verdict. Okay, so no one is in this courtroom at all. So if you're gonna have, we'll talk about that, but you'll take things out with you that you need to take out with you, because you're not gonna have access to come back in.
So I've got a question with the essentially equal time being provided to both sides in closing arguments. I appreciate, as litigator, that the court does not impose a hard cutoff, but I just want to be clear for our purposes, for our planning purposes. If, for example, Ms. Adams were to take an hour for her close, and then we took an hour, 15 minutes or so, the prosecutor's final close, rebuttal close, it seems to me there should be at least some restriction to provide at least fairly equal time between parties to address the jury.
Okay.
I'm just wondering about that.
Well, let me say this, we have to be reasonable, okay? If you're able to consolidate your close in an hour, and they've taken an hour for the first close, I'm not gonna deprive the state of their opportunity to come back with a rebuttal close. That's what the law allows for. And if it's 30 minutes rebuttal that they're asking for, then that's not unreasonable.
Well, I agree that as long as the rebuttal is not more than, let's say, 50% of their opening, I'm not going to complain that they've exceeded how much time I used. But
Listen, I understand, but I play it by ear also, and I give the state a fair chance to rebut, because the rules allow for it, and they get the last word, because it's their burden. So I would give them a fair chance to rebut, and I've not had any issues about this that I can ever recall. I think we can all manage it fairly well. What's fair? They're going to have a chance for a rebuttal close to rebut your closing. And if you have any concern, then you should raise an objection, and I will handle it accordingly. I will either say sustain the objection, or I will overrule and let whoever's doing the rebuttal close know that you have, start to wrap it up, or whatever my comments might be, because I'm obviously going to listen very carefully that it's truly a rebuttal close, right? So, I think we'll agree on that. All right.
Last question, just
Yes, sir.
logistically, once the jury begins its deliberations, is the court going to require that the parties remain here in the courthouse, or will
Just you're going to give me all your information, and you're going to be on call, and for questions, you have to be accessible. I've done it at times where we've done it via Zoom. I don't bring the jury in generally to answer questions. They'll come in a note. I'll get the parties together. We'll decide what I'm going to respond and how I'm going to respond in the note and a handwritten response, and that goes back to the jury. Kind of have to play it by ear depending on what their question or concern might be, if there is one. You're free to do what you need to do. Just you want to be within a reasonable time to be able to access either the courthouse or Zoom to answer questions.
Thank you, Josh.
Okay, you all have a good couple of days, and I'm sure we'll be in communication. See you 9:30.
Thank you.
Thanks.
Thank you, Your Honor. I hope
Oh God, George is loud. George is very loud. What does he say?
you have a nice weekend.
Okay, you too, thank you.
Thank you.
And then that's it. They booped us out. All right, chat. Come on back. Come on back. All right, mine is live. And I'm pretty sure someone for Defense Diaries will go and turn their chat back on. Oh, wait, let me get this. Yeah, so I tried to look up, and it looks like, again, it is something that it's a judge's discretion, but it's not something that's barred. This idea that for jury unanimity, when we have alternate theories, the culpable negligence by act, the manslaughter by act or manslaughter by culpable negligence, those are alternative theories of prosecution under the manslaughter charge. And this idea that you can request a special verdict form where you get the jury to say, yes, all 12 of us find unanimously that this theory has been proven or this theory has been proven. There's no reason that the defense can't ask for that. So, the judge is acting like it doesn't exist. I found very quickly that it does. She will have the discretion. I don't get why she just said, I'm not doing that, and leave it at that. Let me get chat back up. Chat back up. I see you guys coming in already. That's awesome. That was quick. Yesterday it was super, super duper slow to pop back in. Also, hold on, wait. I had Dakota had some thoughts, sent a Venmo, and said the judge seems to be guiding him to a long prison sentence, not adopting any defense proposition for instructions. And the manslaughter question about what was removed was from what I recall. Oh, hold on, I can't read it. Was from what I recall, they took subsection B out and made subsection C show as section B for the instructions. Oh, okay, that clarifies it. Yep, so they'll do that. If you guys have ever watched a trial where it's like, we're charging like counts 1 through 5, but then for whatever reason, counts 2 and 4 go away, they won't send back count 1, count 3, and count 5 to the jury. They'll rewrite it for the jury as count 1, 2, 3. So good catch, great catch, and thank you for the Venmo. So Sheriff Chuck's like, we're looking like guilty on all accounts, Again, no lesser included are gonna go back. So Iceman says, I'm here. Bice says, woo. Jenna with the thank you. Thank you guys. Thank you guys for coming back to chat. Always love that. This is going to be a quick one here. Jury instructions I feel like I've learned so much, especially it was awesome to have, I can look up statutes, but I don't have Westlaw. I don't have an account for that. I don't think I can have an account for that. So it was super, super helpful, not just to have Ali and Bob explain things and break things down, but for Ali to also be sharing the screen with the words on screen. Having both was just super, super helpful, super educational, super informative. Oh my gosh, why is the screen blue? That was weird. Maybe it was just my side. Let's see. Justice says I'm always joining off the wrong account. That happens. Hey, I heard something, by the way, you guys, that YouTube is rolling out a new feature that I think nobody asked for. I haven't noticed it yet, but some accounts have noticed that when they're sharing a link from YouTube and sending it out, it's adding like a URL parameter. So like the extra garbage that gets added to URLs, so sites can track the activity where clicks are coming from and what's going out. They're adding something that will say like the channel, Katt Not Williams, is sharing this YouTube video with you. So if you're concerned about privacy, if you try to use an anonymous account and you're sending it out and don't want people to see your YouTube name when you're linking something somewhere else, be aware. I've heard that that's something people are rolling out. It's also something Instagram already does. So if you have like an Instagram account that might have your personal name, your first name, last name, and you're trying to share it with your friends here from YouTube in one of these group chats that we have, but nobody in those chats knows your real name, when you share a link from Instagram, it adds an attachment. You've got to look for the question mark in the URL, highlight the question mark and everything after it, and delete it. Otherwise, it'll be like Katt Not Williams is sharing this with you and expose your profile, any information you have there when you share a link out. Really, really stupid. It does not warn you that that's going to happen. Really, really stupid, I think. I don't think anybody asked for that feature. And I think it's a major risk to someone's privacy. Oh, okay. So Learned Hand Knit says I can get a Westlaw or Lexis account if you want. So I don't need to actually be a lawyer to do that. It's just money. So, I mean, one problem goes away, another enters the chat. So, but thank you for that info. Also, Sarah says, it's wild. One, it's wild how no one in that room even understands what the charges are. Two, judges acting like it's no big deal to just rot in jail waiting for appeal. Yeah, she seems excited that this is, she said more than one issue of first impression, and I agree. I agree that there's going to be issues of first impression because of the way that the state has decided to charge this case based on the fact pattern. But to be so gleeful that when you are the judge who has some discretion now is like, oh, state, do you have any case law for me? No. Okay, well, I'm not going to do that. And the defense is like, although the defense is kind of mildly trying to assert their arguments, right? Maybe they could put a little Ali behind it and pep it up a little. They're just like, oh, well, we disagree. There's a case law that says this, but she doesn't seem to want to hear it anyway. So, but yeah, I totally agree on both points here. The judge to me came off as being excited about this. Defense diaries popping in, I think from the road, saying, don't forget to like, share, and subscribe. And if you're on Replay Crew, look for that little hype thing. I think that hype thing is helpful. So, yeah, Martha says it will be an anger verdict. I think that's a very real thing in more cases than just this. For sure. Yeah, the glee went away when we talked about the fundamental error. The fundamental error. Yeah, Justice is going to start using a fake account. Yeah, sorry for the little tangent thing about the privacy thing with the accounts, but I just think it's a dumb feature, and I don't think it's something people think of. And hopefully now, in case you were thinking about sharing something from an account that might have personally identifying information and you don't want to do that, now you at least have the awareness that Instagram and potentially YouTube now, if they're doing the same feature, they are not warning you. They are not warning you about the changes. Wolf says, I hope the jurors see what they're doing. Also, guys, personally, I'm not clear on what the ultimate jury instructions are going to be. It seems like there could still be some changes over the weekend. I mean, I think we are safe to say there's not going to be any lessers going back. But the judge, just like we saw through the trial, like, oh, well, let's call some witnesses and we'll deal with that later when you're about to call that witness. Or, oh, we're not going to revisit this again, then we revisit it again anyway. I think that's what they're going to have going on for them this whole weekend. And unless they file something on the docket, I don't think we're going to be privy to any of that. Because it's going to be like email communications between all of the parties. So while I expect that it'll be pretty similar to what the state wants, that the judge has not been granting any like permissible supplemental special instructions that the defense was asking for, there could be some changes that we won't know until we hear the judge read them. It's kind of frustrating. If they do publish the final jury instruction form, of course, we'll add a link to the description. That way you can read them as she's doing them. Yeah, someone's saying they already did their rebuttal witnesses. Yep, the evidence is closed. Everything is done. All of the presentation of proof is completely done. So there's no court tomorrow because it's Juneteenth, so federal holiday, and then they're coming back Monday. And I believe she said she wanted to do 9:30 on Monday. So 9:30 on Monday. Let's get some final thoughts. Yeah, Stream Elements, the bot here says, make sure to hype the video. Do what the bot says. Let's see. Yeah, Tiny says all my accounts have a fake name, but it's just to protect my employment. Good idea. Think it's a good idea. Debbie says defense doesn't fight on the issues. I think Howard to me comes off as fighting as if he's already at the appellate level, where it's like argument. There isn't like this, it's just like a different vibe. But this is the trial still. Like, your client is not yet convicted. You could fight, and maybe it'll make a difference. Maybe it won't. Maybe it won't. So, MBW says, isn't doxing against YouTube terms of service? Listen, they would argue that you consented and that there's somewhere in the terms and conditions where they disclose that sharing would do this. And I haven't noticed it on my account. Again, where I saw it initially mentioned, I don't know what device they were using, if it was like Apple or something that was doing it, but I wasn't noticing it on my own account. Also, Kitty Coo here sniping with the Defense Diary gift here. Big thank you. Welcome to Defense Diary's new member. I can't see who it is over here. So shout out to whoever just turned green. Make sure you say thank you to Kitty. And then, guys, I'm going to wrap this up. Remember, since no court tomorrow, the next time we'll get together for this case will be Monday. I'm not sure. Does one of the Defense Diaries mods or someone, if Ali and Bob are watching, are you guys doing anything like upcoming this weekend before we meet again that we want to shout out? Yeah, the family hug. So if you guys want to try to get that in the chat real quick, that way the people know what Bob and Ali might be up to this weekend on YouTube before we get together again on Monday. Me, I want to cover a few things. I want to cover Lindsay Isaacs. She filed a federal lawsuit because of her wrongful arrest by Florida Highway Patrol, where she was driving a black Durango that wasn't near the scene of a hit and run, and a lazy investigator used a license plate reader, saw that her car was there, and arrested her, even though her car didn't have any damage consistent with this accident. And it was really a maroon Durango, and a 911 caller reported seeing this other individual who has now been arrested. But that woman, Lindsay Isaacs, who was falsely accused, has now filed a federal lawsuit, so I want to look at that this weekend. Also, SCOTUS, maybe Bob and Ali want to join me for that. I want to look at a SCOTUS ruling that came down today, 8-1, where when you sign a plea deal, you aren't necessarily permanently and without any possible relief waiving your right to appeal the conviction and or appeal the sentence that comes with that plea deal. Gorsuch had a very insightful concurrence that many others joined on with, going through the evolution of plea deals and how they're used in this country. I thought it was very interesting and raised some concerns with, because plea deals seem to be the system now. Most things resolve in a plea and don't make it to a trial. Here are some things that this court might want to consider. So this decision today, he said, was just the start. So if you guys think plea deals are messy and you would be interested in that, I'll invite Bob and Ali on. We'll do that sometime this weekend. And I might gripe about the Rashawn Jones case. So that's what's on my book. Also, big thank you here to Sheriff Chuck, gifting 5. So make sure, again, guys, if you're getting a gift, make sure you say thank you. Sheriff Chuck, thank you so much. As always, stream sponsor, big thank you. And also, I had a comment that I saved from Sheriff Chuck that I thought was insightful. Why are we declining these lessers? And Sheriff Chuck proposed that maybe they're declining because it muddies the water on the other charges. The state will convince them if he broke the law on navigation, he then meets the burden for the other charges, so it pushes it right back up to guilty on all. So I think insightful logic there on why somebody would advise or decide, let me not include these lessers, because it gives the state that inch to get them the whole way. So I wanted to share that too. I copy and pasted that and almost forgot. Drama says, thank you. Hold on, did anyone say what Bob and Ali are going to be doing? Just wanted to see real quick. I don't think I see. Okay, you guys say we never know, it's always a surprise. All right, guys, well then that means hit the notification bell. That's the best way to find out when Defense Diaries goes live next. Me, I'm kind of the same way. But I have so much I'm behind on that I kind of know what I'm going to cover. Sometimes it's a surprise, but yeah, thank you guys so much. If I don't see you this weekend, have a great weekend. Have a great Juneteenth tomorrow. Have a great holiday if you have off from work tomorrow. See you on Monday, and looking forward to being back with Bob and Ali.